Welcome, I'm AdaKay. This is the only channel bringing you unfiltered courtroom commentary, breaking down the gripping drama and providing full ASL interpretation, making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Good morning, everybody, and how are you today? We are here ready for more Ali trial. We are going to be getting into the closing arguments this morning, and hopefully we'll be in jury watch by this afternoon. Oh, I hope so, guys. I hope so. How is everybody doing today? Sorry I was a few minutes late. As most of you know, if not all of you, I live in Kerrville, Texas, where the floodings happened on the 4th of July, and it's still like a war zone in some areas. But we are having some roaming outages, and hopefully that will be the last of my problems today. So if things get a little glitchy, just be a little patient, please. I want to give shout outs to our first in chat, Tinkatude. Hello, Tinkatude. We have Aaron E. We have June. Thank you so much for joining. We have Out and About with Diane, where it is 2 o'clock in the morning their time, I believe. Or I think it's 2 o'clock in the morning their time. God, love you, Out and About, Diane. Seba, thank you so for joining. And oh, sweet Magnolia and Honey, 2800. Oh my gosh, one sunny day. Ronnie, my mod, June and Ronnie are our mods today. So thank you so much. And G14, oh my gosh, we got a lot of you today. Thank you so much for joining. We are going to start heading into the trial. I know that they've got some commentary that they've started. We're going to listen to that in a minute. But I kind of want to give y'all a rundown. We have planned the entire week out, and we've got some stuff happening. So get ready for some deep dives this week. So I want to go here and see what they have to say.
Reminding the jury that there are two separate people here, and that they should keep in mind that Mom, it wasn't in the video choking, and Mom wasn't that person that the eyewitnesses said forced Fatima's eyes to roll back in her head. Do you expect her attorney to make it very clear to the jury before they go deliberate that you have to take Mom into consideration separate from Dad?
Yes, because they are separately charged. And, oftentimes what judges will do to cure that kind of potential for confusion and overlap is you have two separate juries hearing the same evidence. So you have one jury judging Mom and the other jury judging Dad, I'm sorry. But the court found in the interest of judicial economy, they'll be tried by one jury. But having said that, really what the prosecution is going to have to show in this particular case is that Mom was not coming to the aid of her kid, that she was just pretty passive through the whole experience. It's almost as if she was the lookout, almost as if she was the getaway driver, if you will. Like, yeah, you get her, you do all the dirty work, I got your back. When you're done, you signal to me and off we'll go. She did not do enough to pull or pry Dad off that child to say that she was not complicit. If anything, her presence there and her passivity, knowing it's her own child, speaks volumes about an intent to kill. And unfortunately, the jury doesn't get to hear anything about arranged relationships, arranged marriages, honor killings, all that kind of stuff, because I'm telling you, that would have changed the entire landscape of this case.
We often see the defense team, the prosecution bring in the exact words of what happened in testimony. I want to go back to something that I think the attorney for the mother is going to be bringing up, and that's from the victim when she was on the stand.
What are you thinking during this period of time?
Heartbroken.
Okay. By what?
For what my dad did.
Okay. Did you have any fear?
Yes.
About what?
I'm dying.
Where inside the school?
Straight to the office.
Did you tell them anything when you got there?
Yes.
And what did you say when you walked in?
He was trying to kill me.
You have shared with the police and with others that you felt like your mom wasn't trying to hurt you. Fair?
Yeah.
Your mom is just there holding you as you regain consciousness, correct?
Yeah.
Difference in the way Fatima testified about her parents. We're actually getting word that closing arguments are about to start there inside of the courtroom.
Yeah, they're convening now. The jury has not entered the courtroom yet, so let's get a break. And when we come back, we'll hear from both sides, all three sides, as the closing arguments in Washington versus Ali begin. Stay with us.
Two parents face a jury
over the attempted murder of their own daughter. Court TV takes you inside the trial that's torn a family apart. The attempted honor killing trial. Live coverage today, only on Court TV.
Friday night, superstar guards face off at the Indiana Fever.
Okie dokie, guys. Now we got commercials. Sorry about that. I am fighting to keep everything up and running. We have installed a electronic brick thing that saves so much power. So when the power goes out or something happens, I'm still live for a certain number of minutes. So yay. But like I've told you guys, we are definitely going through some glitches. For those of you who don't know that just hopped on, I live in Kerrville where that awful flooding happened in January. On the 3rd or 4th of August, I'm going to do a 1 month catch up. I did a drive out there. Some people can get through. Most people cannot. I'm a first responder. I can. And they still have everything locked down. You can't go out there unless you live there or you're first responder. So good news is that there's a lot of cleanup that's happening. The bad news is, well, it still looks like a bomb went off in a lot of areas. It's horrible. So everybody's doing good this morning. Thank you so much for joining. Everybody sees this Nightbot up here. We've figured out how to do bots. So that's what that is. Somebody asked, who's Nightbot? That's what that is. She-Wolf, thank you. Oh my gosh. Jennifer King. They are, I guess there's a delay in, did they say they're not?
Did you have any fear?
Yes.
They're holding.
We're about to start there inside of the courtroom.
Yeah, they're convening now. The jury has not entered the courtroom yet, so let's get a break. And when we come back, we'll hear from both sides.
Yeah, they are going to do them. They are going to do them. It's just going to take a hot minute and for them to get everything up and going. Court seems to be a little more relaxed and slow today. Don't know why, but it is. Hello, Teresa. How are you doing, love? Thank you for joining us. I'm setting up our likes and subs. Don't forget to share, like, and sub to be entered into the drawing for the monthly giveaways. Yeah. And they're up and running. We have one new sub. Woohoo! Thank you so much for subbing. I think what I'm going to do for today and today only is I will give extra giveaway entries if you sub and you're brand new subs. Uh-oh, we've got court. I need to crank it up. Let me know how the volume is. Uh-oh, let me get the feed up. Give me a second. I don't know what happened. There we go.
124 to 127.
Hello, Debbie. Weird Debbie.
8 to 140. And obviously they're not numbered as the state is going through and saying them, so that would require media to count, but I did want to try and give that at least as a heads up. Names certainly are used throughout. First names generally only unless it is the alleged victim's name in this case. But in terms of photos specifically that depict them, I wanted to at least give that heads up.
Okay, Seba, that is all on the court. I have you up 100%. Let me show you where you normally are.
All right, thank you.
That is your
And
normal
as
volume
shown
for
when
every
we
other trial
discussed
I
this
have.
issue last week.
I am
we
up
had estimated
100%.
that
I can't go any higher.
potentially,
I am so sorry.
2 hours for your closing.
It brought me
Do you
down.
believe that you can finish that many slides in 2 hours?
I think it is going to be very close. Certainly there's a number of, I would say photograph video that take up a good portion of that as I have identified. And there is overlap between several of the charges and evidence. So some of those go significantly faster. My hope is to be at 2 hours. I'm also trying to be mindful of not speaking too quickly. Sorry, I put a cough drop in this morning. I know that we have a new interpreter as well. The other interpreters that we've had throughout the trial have indicated that the pace has been fine. But if for some reason that changes, I would just hope that somebody would let me know so I can slow down. But my goal is to be done right at 2 hours. That's the state's intent.
All right. I estimate that it will probably take me about 40 minutes to read the 49 instructions to the jury. So we might be close to 10 o'clock by the time that I conclude. Once I conclude, I will give the jury a stand up, move around little break. I don't want to interrupt anyone's closing, and I'll address this also with Mr. Keating and Mr. Leary. But I'm hopeful that you will have some sort of natural breaking place so we can take a 10-minute recess during your closing.
I think that I think there is a natural breaking or pause place so that way folks can get up, go use the restroom, whatever needs to be done.
All right. Thank you. Mr. Keating, do you have any preliminary issues this morning?
No, I was just going to ask about scheduling. It sounds like it's probably going to be just after lunch before defense will start. Is that the plan then?
That's my guess, just based upon the timing with the estimate for the length of the state's closing and taking into account the time it'll take me to read the instructions. I do, and presuming that's around noon, we'll recess for about 30 minutes. The jury will have lunch, and then we will bring them back in for to start with your closing. Also, you indicated on Thursday, you indicated you believed 60 to 90 minutes for your closing. Is that still accurate?
I believe it is.
All right.
I think 60 is actually close.
All right. So if it's 60, then I think that you just give your entire closing. If it's going to, as you're watching your time getting closer to 90, we may want to just take a stand-up break also, just to give them a little bit of a break. And then Mr. Leary, I would anticipate taking a 10-minute recess after Mr. Keating's closing, so that, and then you would provide your closing. And depending on where we're at timing after your closing, whether or not I just do a stand-up before rebuttal or whether or not we take another 10-minute recess will just depend on where we're at. And you indicated that you believed probably around 60 minutes. Do you still believe that that is likely accurate?
Maybe a little bit over, but not much over.
All right. And same for you. If at some point you think it would be helpful to have a stand-up and take, a couple minutes, and or you think based upon it, the way everything else is going, that a 10-minute recess, please feel free to indicate to me that you think it's a good time for a recess, and I would do that.
I appreciate it.
All right, bring the jury in, please.
While they're bringing in the jury, I need to let y'all know that if you are a subscriber of my channel, please go back and double check and make sure you're still subscribed. YouTube has done its little thingy, and sometimes they will unsubscribe people because they're not sure if they're bought or if they're real. So please, 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 please make sure that if you are a subscriber, make sure you're still subscribed. Okay, here we go, guys. My hair drive me crazy this morning. Yeah, it does. And it's okay because they have to. YouTube does need to make sure, because people can buy or use a bot to boost their subscriptions, which I've never done, nor will I do. But because of that, they basically do audits. So please go in and double check your subscriptions. And if you haven't subscribed, please do. It doesn't cost you anything. Also, we will be doing a poll after the closing arguments.
Good morning, members of the jury, and welcome back. As I told
Good
you when we
morning,
were last
Kale.
in court, what is left is for me to advise you as to the law that applies to this case. And that law is contained in the jury instructions. You have each been provided your own copy of the jury instructions. The only difference between what you have in front of you and what I have in front of me, the originals, which I have, are signed by me and dated with today's date, and the original instructions and the original verdict forms are printed on white paper. Everything that you have is on blue paper. After I read you the instructions, and I'm required to read them to you, then we will begin closing arguments. We do anticipate that closing arguments will take all day today. And as I told you previously, we have ordered or are ordering lunch, and we anticipate probably about a 30-minute lunch break. And we will still have a recess in the morning and a recess in the afternoon, but those might only be about 10 minutes each. All right. These are the court's instructions to the jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proven, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that a witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by words or conduct, my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I have indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatsoever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the constructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. Instruction number 3. A separate crime is charged in each count. You must separately decide each count charged against each defendant. Your verdict on one count as to one defendant should not control your verdict on any other count or as to any other defendant. Instruction number 4. Each defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendants have no burden of proving that a reasonable doubt exists as to any of these elements. The defendants are presumed innocent. This presumption continues throughout the entire trial unless during your deliberations you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all of the evidence or lack of evidence. If from such consideration you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. Instruction number 5. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 6. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given to you for evaluating the testimony of any other witness. Instruction number 7. A defendant is not required to testify. You may not use the fact that neither defendant has testified to infer guilt or to prejudice them in any way. Instruction number 8. You may consider a statement made out of court by one defendant as evidence against that defendant, but not as evidence against another defendant. Instruction number 9. A person commits the crime of murder in the second degree when with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Instruction number 10. A person commits the crime of attempted murder in the second degree when, with intent to commit that crime, he or she does any act that is a substantial step toward the commission of the crime. Instruction number 11. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. Instruction number 12. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Instruction number 13. A person is guilty of a crime if it is committed by the conduct of another person for which he or she is legally accountable. A person is legally accountable for the conduct of another person when he or she is an accomplice of such other person in the commission of the crime. A person is an accomplice in the commission of a crime if, with knowledge that it will promote or facilitate the commission of the crime, he or she either 1. Solicits, commands, encourages, or requests another person to commit the crime, or 2. Aids or agrees to aid another person in planning or committing the crime. The word aid means all assistance, whether given by words, acts, encouragement, support, or presence. A person who is present at the scene and ready to assist by his or her presence is aiding in the commission of the crime. However, more than mere presence and knowledge of the criminal activity of another must be shown to establish that a person present is an accomplice. A person who is an accomplice in the commission of a crime is guilty of that crime, whether present at the scene or not. Instruction number 14. The defendants are charged with attempted murder in the second degree. If the defendants were charged with the completed offense of murder in the second degree, the following elements would need to be proven beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant acted with intent to cause the death of Fatima Ali. 2. That Fatima Ali died as a result of the defendant's acts. And 3. That any of these acts occurred in the state of Washington. Instruction number 15. To convict the defendant Ihsan Ali attempted murder in the second degree as set forth in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant did an act that was a substantial step toward the commission of murder in the second degree. 2. That the act was done with the intent to commit murder in the second degree. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 16. To convict the defendant Zahraa Ali of the crime of attempted murder in the second degree as set forth in count 1, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant, as a principal or as an accomplice, did an act that was a substantial step toward the commission of murder in the second degree. 2. That the act was done with intent to commit murder in the second degree. And 3. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 17. A person commits the crime of assault in the first degree when, with intent to inflict great bodily harm, he or she assaults another by any force or means likely to produce great bodily harm or death. Instruction number 18. An assault is an intentional touching or striking of another person that is harmful or offensive. A touching or striking is offensive if the touching or striking would offend an ordinary person who is not unduly sensitive. Instruction number 19. Great bodily harm means bodily injury that creates a probability of death or that causes significant serious permanent disfigurement or that causes a significant permanent loss or impairment of the function of any bodily part or organ. Instruction number 20. To convict the defendant Ihsan Ali of the crime of assault in the first degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Fatima Ali. 2. That the assault was committed by a force or means likely to produce great bodily harm or death. 3. That the defendant acted with intent to inflict great bodily harm. And 4. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 21. It is a defense to the charge of assault that the force used was lawful as defined in this instruction. The physical discipline of a child is lawful when it is reasonable and moderate and is inflicted by a parent for purposes of restraining or correcting the child. You must determine whether the force used, when viewed objectively, was reasonable and moderate. You may, but are not required to, infer that it is unreasonable to do the following acts to correct or restrain a child: throwing, kicking, burning, or cutting a child, striking a child with a closed fist, interfering with a child's breathing, doing any act that is likely to cause and that does cause bodily harm greater than transient pain or minor temporary marks. You shall consider the age, size, and condition of the child and the location of the injury when determining whether the bodily harm is reasonable or moderate. This inference is not binding on you, and it is for you to determine what weight, if any, such inference is to be given. The state bears the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, it will be your duty to return a verdict of not guilty as to this charge. Instruction number 22. The defendant is charged in count 2 with assault in the first degree. If, after full and careful deliberation on this charge, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the second degree. If, after full and careful deliberation of the lesser charge of assault in the second degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the fourth degree. When a crime has been proved against a person and there exists a reasonable doubt as to which of 2 or more degrees crime that person is guilty, he shall be convicted only of the lower degree. Instruction number 23. A person commits the crime of assault in the second degree when he or she intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. Instruction number 24. Strangulation means to compress a person's neck, thereby obstructing the person's blood flow or ability to breathe, or doing so with the intent to obstruct the person's blood flow or ability to breathe. Instruction number 25. A person is reckless or acts recklessly when he or she knows of and disregards a substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. When recklessness as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally or knowingly as to that fact. Instruction number 26. Substantial bodily harm means bodily injury that involves a temporary but substantial disfigurement or that causes a temporary but substantial loss or impairment of the function of any bodily part or organ, or that causes a fracture of any bodily part. Instruction number 27. To convict the defendant Ihsan Ali crime of assault in the second degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant A intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B intentionally assaulted Fatima Ali by strangulation, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either alternative element 1A or 1B have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. To return a verdict of guilty, the jury need not be unanimous as to which of alternatives 1A or 1B has been proved beyond a reasonable doubt, as long as each juror finds that either 1A or 1B has been proved beyond a reasonable doubt. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to either elements 1 or 2, then it will be your duty to return a verdict of not guilty. Instruction number 28. A person commits the crime of assault in the 4th degree when he commits an assault. Instruction number 29. To convict the defendant Ihsan Ali of the lesser included crime of assault in the 4th degree, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali, and 2, that this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 30. To convict the defendant Zahraa crime of assault in the 2nd degree as charged in count 2, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant intentionally assaulted Fatima Ali by strangulation. And 2. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 31. A person commits the crime of unlawful imprisonment when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty, if the restraint is without legal authority and without the other person's consent, and the person knows that the restraint is without legal authority and without the other person's consent. Instruction number 32. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. When acting knowingly as to a particular fact is required to establish an element of a crime, the element is also established if a person acts intentionally as to that fact. Instruction number 33. Restraint is without consent if it is accomplished by physical force, intimidation, or deception. Instruction number 34. To convict the defendant Ihsan the crime of unlawful imprisonment as charged in count 3, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant knowingly restrained the movements of Fatima Ali in a manner that substantially interfered with her liberty. 2. That such restraint was without Fatima Ali's consent. 3. That the defendant knew that such restraint was without Fatima Ali's consent. 4. That such restraint was without legal authority. 5. That the defendant knew that such restraint was without legal authority. And 6. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 35. To convict the defendant crime of unlawful imprisonment is charged in count 3. Each of the following 6 elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant, as a principal or as an accomplice, knowingly restrained the movement of Fatima Ali in a manner that substantially interfered with her liberty. 2. That such restraint was without Fatima Ali's consent. 3. That the defendant knew that such restraint was without Fatima Ali's consent. 4. That such restraint was without legal authority. 5. That the defendant knew that such restraint was without legal authority. And 6. That any of these acts occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 36. Family or household member means a persons who have a biological or legal parent-child relationship, including step-parents and stepchildren, and grandparents and grandchildren. Instruction number 37. It is a defense to a charge of assault in the 4th degree as charged in count 4 as to Ihsan Ali that the force used was lawful as defined in this instruction. The use of force upon or toward the person of another is lawful when used by a person who reasonably believes that he is about to be injured in preventing or attempting to prevent an offense against the person, and when the force is not more than is necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of the facts and circumstances known to the person at the time of and prior to the incident. The state has the burden of proving beyond a reasonable doubt that the force used by the defendant was not lawful. If you find that the state has not proved the absence of this defense beyond a reasonable doubt, then it will be your duty to return a verdict of not guilty as to this charge. Instruction number 38. Necessary means that under the circumstances as they reasonably appeared to the actor at the time, 1. No reasonably effective alternative to the use of force appeared to exist, and 2. The amount of force used was reasonable to effect the lawful purpose intended. Instruction number 39. It is lawful for a person who is in a place where that person has a right to be and who has reasonable grounds for believing that he is being attacked to stand his ground and defend against such attack by the use of lawful force. The law does not impose a duty to retreat. Notwithstanding the requirement that lawful force may be not more than is necessary, the law does not impose a duty to retreat. Retreat should not be considered by you as a reasonably effective alternative. Instruction number 40. No person may, by an intentional act reasonably likely to provoke a belligerent response, create a necessity for acting in self-defense, and thereupon use or attempt to use force upon or toward another person. Therefore, if you find beyond a reasonable doubt that the defendant was the aggressor and that the defendant's acts and conduct provoked or commenced the fight, then self-defense is not available as a defense. Instruction number 41. To convict the defendant Ihsan Ali of the crime of assault in the 4th degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant assaulted Isaiah Williams. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 42. A person commits the crime of burglary in the second degree when he or she enters or remains unlawfully in a building with intent to commit a crime against a person or property therein. Instruction number 43. A person enters or remains unlawfully in or upon premises when she is not then licensed, invited, or otherwise privileged to so enter or remain. A license or privilege to enter or remain in a building that is only partly open to the public is not a license or privilege to enter or remain in that part of the building that is not open to the public. Instruction number 44. A person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime against a person or property therein. This inference is not binding upon you and it is for you to determine what weight, if any, such inference is to be given. Instruction number 45. The term premises includes any building, dwelling, or any real property. Instruction number 46. To convict the defendant Zahraa Ali of the crime of burglary in the second degree as charged in count 4, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, the defendant entered or remained unlawfully in a building. 2. That the entering or remaining was with intent to commit a crime against a person or property therein. And 3. That this act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 47. A person commits the crime of violation of a court order when she knows of the existence of a protection order and knowingly violates restraint provisions of the order prohibiting contact with the protected party, or a provision of the order excluding the person from a school, or a provision of the order prohibiting the person from knowingly coming within or remaining within a specified distance of a location. Instruction number 48. To convict the defendant Zahraa Ali of the crime of violation of a court order as charged in count 5, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about October 18, 2024, there existed a protection order applicable to the defendant. 2. That the defendant knew of the existence of the order. 3. That on or about said date, the defendant knowingly violated a restraint provision of the order prohibiting contact with a protected party, or provision of the order excluding the defendant from a school, or a provision of the order prohibiting the defendant from knowingly coming within or remaining within a specified distance of a location. And 4, that the defendant's act occurred in the state of Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 49. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 12 jurors are present. You are all officers of the court and must evaluate the evidence with an open mind, free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions, and verdicts forms A, B, BB, BBB, C, and D for the defendant Ihsan Ali, and verdict forms A, B, C, D, and E for defendant Zahraa Ali. Some exhibits and visual aids may have been used in court, but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. When completing the verdict form for count 2 for the defendant Ihsan Ali, you will first consider the crime of assault in the first degree as charged. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form B the words not guilty or the word guilty according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form B. If you find the defendant Ihsan Ali guilty on verdict form B, do not use verdict form BB. If you find the defendant Ihsan Ali not guilty of the crime of assault in the first degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of assault in the second degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form BB the words not guilty or the word guilty according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form BB. If you find the defendant Ihsan Ali guilty on verdict form B or BB, do not use verdict form BBB. If you find the defendant Ihsan Ali not guilty of the lesser crime of assault in the second degree, or if after full and careful consideration of the evidence you cannot agree on that crime, you will consider the lesser crime of assault in the fourth degree. If you unanimously agree on a verdict, you must fill in the blank provided in verdict form BBB the words not guilty or the words guilty according to the decision you reach. If you cannot agree on a verdict, do not fill in the blank provided in verdict form BBB. You will also be given special verdict forms A1, B1, BB1, BBB1, and C1 for defendant Ihsan Ali for the crimes charged in counts 1, 2, and 3. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find a defendant guilty of these crimes, you will then use the special verdict forms and fill in the blanks with the answer yes or no according to the decision you reach. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. You will also be given special verdict forms A1, B1, and C1 for defendant Zahraa Ali for the crimes charged in counts 1, 2, and 3. If you find the defendant not guilty of these crimes, do not use the special verdict forms. If you find a defendant guilty of these crimes, you will then use the special verdict forms and fill in the blank with the answer yes or no according to the decision you reach. In order to answer the special verdict form yes, You must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer. If you unanimously agree that the answer to the question is no, then you must fill in the blank with the answer no. If after full and fair consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the proper form of verdict or verdicts to express your decision. The presiding juror must sign the verdict forms and notify the bailiff. The bailiff will bring you into court to declare your verdict. The following pages after instruction 49 are the verdict forms that I have referenced. Members of the jury, we're going to just do a quick little stand up and then we'll start the closing arguments.
Thank you for the break. I needed that. That was tough. But she read it well. Where's my Diane? I'm going to try and get Diane in here. This is a lot.
All right, we'll have everyone have a seat.
No, Diane.
Members of the jury, if you would please give your full attention to Ms. Stone as she makes
Okay,
closing
I'm not going to
argument
do
on
this
behalf
part.
of
We
the
got
plaintiff,
captioning, and the
state of
deaf person's not watching.
Council. Ladies and gentlemen, so a couple of weeks ago when we came in and we started this, we indicated you would be here for several weeks, and there was a lot of information that you were going to get. We have reached that point where you've now been informed on the law by the court. You have a fairly lengthy packet of instructions, and you've heard a lot of evidence over the course of the last several weeks. I will tell you that there is no fast way to get through all of that evidence and compare it to the instructions. The court, I think, has informed you, and you'll hear it again. The state has the burden. That is properly the state's burden, and the state accepts that burden. But what that means is I am responsible for proving to you every element of every crime that has been charged. So we have to take some time to do that. And then at the end of this, because it's the state's burden, we get to talk to you again. I promise you the second time will be much shorter. But if at any point during the course of this, someone needs a break, you can't hear something, you just need to stand up, please catch our attention. We will plan to take a break, but we want to make sure that if someone needs that earlier, you let us know, okay? So I have slides. Everybody processes information differently. Lots of you take notes. You can see that the attorneys take a lot of notes too. Some folks are much more auditory processors, and some folks are very visual processors. So I've tried to give you a number of different ways, as the court has during the course of this as well, of processing that information. If slides do not work for you, then please ignore them and don't pay attention to them. It helps me stay on track. It helps me present it in a more organized fashion, but that may not work for everyone else, okay? So don't feel like you have to pay attention just because they are there. Make sure that, there we go. So I always start with this first slide, lawyer statements. Lawyers talk a lot, right? It's what we do. You are going to hear obviously from
Tracy.
a group of us. First myself, then Mr. Kading, then Mr. Leary, and then me again. What we tell you is not evidence. The evidence is the testimony and the exhibits that came from the individuals that were sitting in that seat over there. The attorneys will tell you things. We will argue to you the evidence we believe that you have heard over the course of the last several weeks. Attorneys are human too. And whether it is myself or Mr. Kading or Mr. Leary, what we tell you is not evidence. So if we misspeak, if we say something that we believe a witness has said or we recall a witness having said, and that does not jive with your memory of those events.
You can go back and watch on a replay. You can rewind. I'm not doing that again.
Or your notes or your recollection, your memory, your notes is what the evidence is. We are not the triers of fact. We are just the attorneys. Okay, so please rely on the instructions you've been given by the court and your recollection in those notes. So evaluation of the evidence. We provide this instruction also as well. Oftentimes you will hear folks during the course of whether it's a TV show or an argument or something else. Well, it's just circumstantial evidence. It doesn't mean anything. That's an inaccurate statement. When you come in, at least in the state of Washington, when you come in here, you do not come in here in a vacuum of life experiences. We want a fair and impartial jury, both for the state and for the Alis. We want to ensure that that is what you are there to do, but we do not assume that you have no life experiences and you cannot process information.
Where, Debbie, are you wanting me to interpret this? If I need to interpret it, throw up the ILY, but if I don't need to, let me know.
About what is reasonable behavior, what is unreasonable behavior, and reasonable inferences to take from those. So in Washington, we give you that distinction between direct and circumstantial evidence. Direct evidence is that thing that you have directly perceived. Circumstantial evidence is the thing that you know and you can make a reasonable inference from. So let me give you an example of that. And we use a cake example very often, right? If you go in and you make a cake, everyone who's ever made a cake knows you cannot frost a hot cake, right? My bakers know that. That frosting is going to slide right off the side and be a gooey puddle. It will look nothing like what it's supposed to do. So if you make your cake, you have to let it sit out and cool. So now let's say that you've made that cake. It is sitting out. It is cooling.
Oh, okay,
you live
good.
alone, you live with your dog, and you have errands to run. So you lock your doors. Your windows are all locked. Nobody else is there. You come back a couple hours later, and what was once a beautiful cake waiting to be frosted is now in shambles on the floor. There's crumbs everywhere. Your dog looks comfortably full, and there's crumbs all over the dog's face. Direct evidence would have been a video watching your dog eat that cake. Circumstantial evidence is exactly what we've just described. You know your dog ate the cake. That is the only reasonable inference that comes from that evidence. You didn't see it, but you know that that's what happened. There's no other reasonable explanation. No one's broke in. You said no one lives there. There's no windows. That's what happened to your cake. That is circumstantial evidence. And that is in large part why we provide you this instruction, but we trust that you are going to use your rational mindset and your common experience to know what facts and inferences to take from the evidence.
I haven't eaten anything today. It is 12 o'clock. I'm starving, and this does not freaking help.
That you see. There may be differences in types of evidence that you receive, but the fact that one is circumstantial and one is direct makes no difference in terms of the weight that you give it, just by definition. So please don't get stuck in that loop in deliberation, like, well, it was only circumstantial, or oh, it was direct, so that's better than this kind. That's not the case. Like I say, that individual piece of evidence may have a different weight, but that weight is not drawn from whether it is a piece of direct evidence or a piece of circumstantial evidence. Okay? So evaluation of the witness testimony. Our way through those. In addition to the fact that you are the triers of fact, the sole triers of fact, you are also the sole judges of credibility. The attorneys are not. We cannot comment on the credibility of witnesses. We can point out whether there was a particular manner about a witness testifying, whether there was a personal interest, whether there's a reasonableness of the statements that they may have provided to you in context of everything else that you saw, but you are the sole judges of credibility. So when you are looking at the testimony of witnesses and how to evaluate that, you are given an instruction about some of the things that you can look at to help assist you in that process, okay? Reasonable doubt. Before you came into trial, if you've never sat on a jury before, but before you came in here, I believe that you would probably describe yourself as reasonable people. Most people would describe themselves as reasonable people. Having sat in here now and gone through all of these instructions, I would submit to you that we have ruined you with the law. You are no longer reasonable people. When you go back home and you're talking to friends, when this is all over, or talking to your family, when the court has released you from your instructions not to talk about it, you can say, well, I don't know, I had a reasonable doubt, And we didn't convict on A, B, and C or at all because I had a reasonable doubt. Or we convicted them on A, B, and C, or we convicted them on all because we had an abiding belief in the truth of the charge. Nobody talks like that. Lawyers talk like that, right? But now you will talk like that, at least as you're evaluating this and in talking to each other in that back room. So what does reasonable doubt mean? And you have the instruction. I submit to you that reasonable doubt and abiding belief are two sides of the same coin. If you have an abiding belief, then you do not have a reasonable doubt as to the truth of the charge. An abiding belief is abiding, long lasting. You believe it today, you believe it tomorrow, you believe it next week, next month, next year. That is an abiding belief in the truth of the charge, that the defendant did what the state has charged them with, and that the state has proven that beyond a reasonable doubt. You have an abiding belief. If you have a reasonable doubt, then you cannot have an abiding belief in that truth of that charge, right? So it is not, there's no numeric value that you can apply to it. It's not a 51% or a 75%. Reasonable doubt is one of the highest standards, certainly, that we have. And we talked about that during voir dire, but it is not 100% either. So there is no numeric value associated with reasonable doubt. But as it says, if you have an abiding belief in the truth of the charge, then you do not have a reasonable doubt. And it's just another way of, I think, talking about that and evaluating within yourself. It's kind of this, amorphous is not the right word, but we as humans really like objective measurements, and there's no objective measurement associated with reasonable doubt. So you really have to look at this standard as you're talking about it and thinking about it amongst yourselves, whether it has been achieved, okay? Things you will not get. The court told you this just now in the instructions. Ms. Zoe talked to you about it during opening arguments, or excuse me, opening statements, if you recall. You are not going to get certain documents. And that I know is frustrating every time for a jury because people have referenced them. But the reason that you don't get them is exactly what we talked about, because the testimony is the evidence. A police report is not evidence. If that were the case, we wouldn't call anyone into court. You wouldn't hear from witnesses ever. We'd have them write a statement. You'd have police reports, you'd get doctor's reports, and you would never have anyone come in and testify. In the law, we value the testimony of people who are coming to tell you what they saw, what they heard, what they observed, what happened related to these events. And that is why the testimony comes from the person sitting in that stand. That's why you don't get police reports that officers have made along the way. You're not getting medical reports because the doctors came and told you what is contained within those reports and told you what they observed. Prior statements of witnesses, you don't get those either, right? That's why we have cross-examination, why we have direct examination. So please don't ask for them because they are not coming. You have to make your decisions based on the information that you have heard and what you have received as exhibits. And as we go through this process, right, talking to each other. And then last, of course, transcripts of any trial testimony. You're not getting any transcripts of, can we get a transcript of what so-and-so said on such and such day? That's not coming either, okay? So as you are going through and organizing your thoughts, please keep that in mind. There's a lot of overlap. So I'm going to tell you that there is approximately, if I did my math right, 11 different crimes that I have to go through and describe to you. There's a lot of overlap in that evidence. So I've tried to break it down as we go through those crimes where there is a overlap between both parents, and then we'll separate out some of the parents. So let's start first with count number 1, attempted murder in the second degree of that victim, Fatima Ali, for both parents, Ihsan and Zahraa Ali. Attempted murder in the second degree. I think it's instruction 14, I believe, gives you what it looks like if there is a completed murder in the second degree. Please do not get caught up in that is what the state has to prove. That is not the case. Instruction 14 shows you what completed murder in the second degree would look like. Instruction number 15 tells you what attempted murder looks like. If they were to have done this and completed it, this is what the state would have to prove. Instruction 15, I believe, is the one that says, but here are the actual elements that the state must prove, and that is a substantial step. It's substantial step needs to occur. So a person commits the crime of attempted murder in the second degree with intent to commit that crime. He or she does any act that is a substantial step toward the commission of that crime. Okay. There is the completed murder in the second degree. A person commits the crime of murder in the second degree when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Then you are given what I'll call a bunch of definitional instructions. This one is as to the mental state. So intent, a person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Here's your definition for substantial step. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. It's not simply thought, but it is an act in furtherance of that intent. So these are what we talked about initially. The defendants are charged with attempted murder if, and I don't know that my red, it's a giant red dot. So you can see the if underneath, right? If the defendants were charged with a completed offense, this is what the state would have to prove, right? But because it is attempted, this is what the state actually has to prove, that on or about October 18th, the defendant did an act that was a substantial step toward the commission of murder in the second degree, that the act was done with the intent to commit murder in the second degree, and that any of these acts occurred in the state of Washington. And then when we talk about Zahraa Ali, the only difference between Ihsan and Zahraa is that Zahraa is charged as a principal or as an accomplice. Ihsan is only charged as a principal. Zahraa is charged in both fashions. So principal, you do it yourself without any help, or accomplice, that you were doing it to assist. You're assisting another in reaching their goal. So let's talk first about elements 1 and 3 for both parents. When we talk about elements 1 and 3, there's going to be, as I said, overlap. These are the elements that I anticipate there's not going to be a lot of argument from. I still have to prove them to you. The state still has, beyond a reasonable doubt, responsibility for proving these, but defense counsel, I don't believe, is likely to argue that it didn't happen on October 18th and it didn't happen in the state of Washington. So here's the evidence that applies for each of those, right? All testimony agrees that this is Friday, October 18th, 2024. You have the bus and the body cam videos that you saw that confirmed that. And then you have the testimony of the date and time of those school videos that Celeste Waltermeyer. We pull it and download it. Those dates are not shown on that video, but that's specifically the date, time range that I was looking and pulling from. And that information that you see in context on those school videos themselves from Timberline High School are consistent with what you see in context from all of the other videos. So I submit that that's accurate. She didn't pull a different date or a different time, right? Element 3, that these acts occurred in the state of Washington. This is Timberline High School. That testimony occurred over and over again. 6120 Mullen Road, Southeast, Lacey, Washington. And all of that testimony confirms the same. You're going to see this, a variation of this slide, a number of times because it applies to every single count that we have, okay? So again, what exhibits do we have that demonstrate that as well? Here is exhibit 1. You have that bigger aerial photo. You have Timberline High School. You have the parking lot here. Now my red dot is covering towards the bottom center of that page where that bus stop is. And you have Mullen Road that runs diagonal across that page. Exhibit 2, bigger shot of the same thing. Again, at the bottom left corner, you have that bus stop identified. Mullen Road is identified. You can see that parking lot that we've watched several videos of throughout this trial. And you can see the crosswalk running diagonal across the parking lot, but almost directly perpendicular up and down on this page with the white dashes running across it just to the left of center. Right? That's the crosswalk that we observe Fatima and during the course walking to the bus stop, and then again, people describing later towards the Timberline High School, which is outside of this photo, but would be at the very top of it, right? That's where those front doors are. So then we talk about let's talk about the rest of element 1, right? Remember, element 1 under attempted murder has a couple of different.
This is her closing argument. But what she is doing, which some attorneys really like to do, is they like to present it more like a PowerPoint with very detailed on laws. She's not going in narrative, which is what some attorneys do.
Things within that element itself it has to prove. So the rest of element 1, speaking first to Ihsan Ali did an act that was a substantial step toward the commission of murder in the second degree. So what evidence do you have of that? What facts did you hear during the course of this trial? First, you have it. He grabs Fatima by the hoodie and places her in a rear naked choke. Let's be clear, the state is not asserting that Ihsan Ali showed up on that day with the intent to try and kill his daughter. There was no premeditation that the state is asserting. But by the time Ihsan goes into these events, the state's position is that that has changed. His intent has substantively changed. He grabs her by the hoodie and he places her in a rear naked choke, and we've heard that described with specificity. He takes her to the ground. He holds her in that choke for an extended period of time. He ignores those repeated screams and demands of no less than 6 kids. There's probably more there at varying times, but there's approximately 6 that are there pretty consistently throughout that entire process, and 2 separate adults to release her. We see Mr. DeNicola come up on the scene in his bright orange vest. We see later Josh Wagner arrive on scene, and they're all saying the same thing. They're all screaming at him to release her, to let her go. DeNicola, I think even at one point, I submit when you watch that video, is pointing a finger, and he's telling you, he told you in his testimony, I was telling him to let her go, to release her, to let her go, and he was just doing nothing. He was ignoring me. So it's not just kids that are running around. There's no chaotic panic. These are adults that are watching it happen and very clearly know that this is wrong. They're screaming that she can't breathe and he's killing her. And you hear that on the video. He continues to hold her while she fights and struggles. There's an apparent seizure. She goes limp, and then she is unconscious. The testimony by everyone is that her eyes have rolled back in her head. Her face is pale. Her lips are blue. And I believe Josh Wagner says she has changed colors. When asked on direct examination, Mr. Wagner, based on what you observed, and you came to it towards the end, based on what you observed, is there any way that could have been confused with hugging or simply restraining that child? And his response is no, it's very obvious she was being choked. That was Josh Wagner's statement. And then you have Exhibit 61, which is Elijah's video that shows you exactly the same thing. So I submit to you that that substantial step towards murder in the second degree has been taken. So then element 2, that the act was done with the intent to commit murder in the second degree. So what evidence have you heard throughout this trial that shows that? First, he holds her throughout all of that and continues to hold her after. The only time he releases her is when Josh to release her. All of these things are happening. This is not a like, oh gosh, it happened so fast, I had no idea what to do. It is an extended period of time, and he continues to hold her. DeNicola, remember, he testifies that his arm is straining around her neck, that Ihsan's arm is clearly, there is a tension there. His hands are locked. Mr. DeNicola's statement was, when asked, well, how do you know, what did that look like? And he was like, it was the look on his face. So he is there with them on the ground, and Ihsan's face clearly demonstrates to Mr. DeNicola the intent behind what Ihsan Ali is doing to his child. It is so upsetting, in fact, Mr. DeNicola testifies towards the end that he calls his supervisor to call it in, and says he is in shock. He's trying to process what he just saw, and he has to pull the bus over on the side of the road, and his supervisor has to come take his route. That is how upsetting. This is not a group of kids that are just overreacting to a situation. That is how upsetting that event was to Mr. DeNicola. And he's described that I have security camera on my bus. I've had to look for a bunch of things, fights, whatever. He had to pull his bus over to process what he saw here because it was so upsetting. So what does that tell you? How is this different from the objective observer that doesn't know any of these individuals from Adam about what he observed from Mr. Ali's intent, that it was an intent to commit murder, not something else? You have Caleb talks to you about what we're trying to get him off. In fact, I'm pulling so hard at his arms that he tears Ihsan's coat, and still he doesn't release. Nothing changes. And you see evidence of that coat tear later. It is shredded down his arm. Ihsan doesn't let go. He is holding on to Fatima's neck throughout. He releases only when he is physically forced to do so, despite, and go back and watch the video I submit to you, she has stopped struggling for approximately 15 to 18 seconds prior. She's unconscious, and he continues to strangle her around the neck for another 15 to 18 seconds, and would have continued to do so even longer, but for the intervention of those adults. Then you have Dr. Gilbert's testimony about the effects of strangulation on the body, what happens, and why that happens. She talked to you about the jugular vein inclusion, carotid artery inclusion, and tracheal inclusion. Remember, the lack of, starting first with jugular vein inclusion, the lack of removal of deoxygenated blood. Those are those thin-walled veins on the outside of your neck, right? You need the bad blood to come out of your brain so your brain can function. And we'll come back to the pressure, but it's about 4 pounds of pressure for that jugular vein inclusion, one on each side, thin walls. Then she talked about the lack of oxygenated blood to your brain. That is that carotid artery occlusion. Those are thicker walled arteries, and they are deeper within your neck, right? And that is greater pressure to close. She said about 11 pounds, I believe. And then she talks about what that lack of oxygen to the brain and that buildup of pressure does in the brain, how that leads to brain death, which is death. So then we talk about element number 1 for Zahraa as a principal or as an accomplice. So remember first, this is generally speaking what it means, that language principal or accomplice means. All assistance by words, acts, support, or presence, and present at the scene and ready to assist. First we have, well, let me back up for one moment. When we talk about principal or accomplice, it's really obvious what a principal is, right? You're the person doing it. You don't have any help. You're doing it sort of independently yourself. As an accomplice, if you're assisting someone else. And we distinguish, I'll give you a bank robbery as kind of the classic example. When we distinguish an accomplice in like a bank robbery identification, right? We want to talk about the people that are there to help assist the principal in doing whatever the principal is doing, generally robbing the bank. We want to distinguish that person from the customers that are present, that are there to do business. They know bank robbery is happening. They're present and they're aware, but certainly we wouldn't identify the customers as accomplices in that case.
Welcome, Miss Diane.
Apologies for not being able to arrive sooner. Talking
That's okay.
with the doctor. You know what he told me? Miss Margie had what is more commonly known, and most men have it, a
Widowmaker.
Yeah,
That's what I called
my
it.
brother-in-law had.
Had.
Yeah. He said it's a miracle that she is here.
It is.
But we
It
know
is. Yeah. Okay. So I want to show this to you because Miss Diane is here, and we're going to take a quick break. I want to show something that did not get properly shown this morning. Some of you did not see it, but let's see the new intro. Welcome. I'm AdaKay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. What do y'all think about the new intro?
it's beautiful.
Yeah, you're on it.
I'm on it. Surprise. Yeah, that's really nice. Thank you for including me.
Well, you're interpreting with me.
True.
So I wanted to show that to everyone. That's the new intro. I hope y'all like it. I hope you do. Diane will. Huh?
I want to tell you one more thing God did.
Quickly.
Quickly. Remember I told you I had to have a chair for Margie? Last week, I said, God, I would really like to have a sofa and a chair that matched. He gave me a beautiful sofa and a chair for free that matched. So Margie can now sit on the sofa and put her feet all the way up and lay down if she feels like it.
Wonderful. For those of you who don't know, Margie's her sister. Yeah. I'm a spiritual sister to these two women.
Oh yeah, we keep her.
Yeah. And Margie basically died on us.
Yes.
On the operating table. She had a heart attack so bad it blew a hole in her heart.
Yes.
And her blood sugars was well over 700.
Yes.
And she's still alive and no brain damage.
No brain damage. None. There should have
been.
So
we are all good. She's in rehab. So I just want to give everybody a catch up. Okay, we're going to get back in a few minutes. We'll switch back and forth. So you know the cue.
And if you
I did 49 instructions all by myself.
Yeah. You hear me?
Made a few mistakes, but oh well.
I said if you hang around, she may give you mustard since she gave you ketchup.
Yep. So anyway, we're gonna get back, Diane. I might need you to scoot back just a little. We're losing hands.
Would identify the getaway
I got
driver,
you too.
The lookout, the other person who's providing the banking information or copies of the key. We would describe those people as accomplices. And even the lookout, right? They may not even actively touch anything. They may literally just stand at the door, but they are still identified as an accomplice. So that accomplice liability instruction, and you have it in your instructions. I don't recall the number off the top of my head, but that is what distinguishes somebody who's just present and has knowledge of what's going on from the person who is actively engaged in trying to fulfill the goal or extend the behaviors of the principal, right? All assistance by words, acts, support, or presence, and present at the scene and ready to assist. That is your accomplice liability instruction. So what do you have? You have Exhibit 34 at 2:13:57 on Exhibit 34, and that's that the bus video, the road view of that bus video. Mrs. Ali arrives at that tree. Josh Wagner, white line, he's still in the street on Mullen Road. Ihsan is struggling with Fatima, but Zahra is already there. She is a couple steps ahead of Josh Wagner. 2 seconds later, same exhibit, you see that Zahra is at the group. She is bent down with Fatima. Her arms are outstretched. Josh Wagner has just reached the dirt. He's not even at the group yet. So he's not there. He hasn't interrupted the strangling, but Zahra is there. And Zahra's not like somewhere else. Zahra is right there. She is bent down with those individuals. These are separate acts and behaviors from those of the kids watching. Because what are the kids doing? The kids are still screaming, get off of her, like go of her, you're killing her. And what does Mary Wagner say? Mary Wagner says, Zahra is not helping the young woman on the ground. She seems to only be trying to stop the teens from hitting the man who is strangling Fatima. She did nothing to assist Fatima from what Mary Wagner saw. I submit to you what you see on the video. It's fast. Remember that those videos they pause, they go in slow motion, and you have access to those to fully and fairly consider that. But she goes in and she immediately is pushing kids, but she's not providing assistance to Fatima. Neither Josh Wagner or Denicola describe any assistance for dislodging Fatima by any other adults. They're the only two that are in there trying to get Ihsan Ali's arms pried off of the neck of his daughter. No one else, in terms of adults, are doing that. Then you have Exhibit 122 plus Mrs. Ali's statement. She clearly expresses over and over again to law enforcement that her concern is for the kids that are hitting and striking her husband, not Fatima. In fact, she doesn't even mention that her husband has been strangling Fatima. But she's there. We know she sees it. Everybody else sees it. But she says not a word about how her child has been strangled into unconsciousness. And we know by the time she arrives, Fatima is unconscious. She is pale, her lips are blue, and she is laying still because there's only about a handful of time from the time that she gets there to the time Josh Wagner is able to get Fatima released. And what does Josh Wagner say? He immediately knows that a child is being choked. He doesn't say, when I got up, I could see that it was a child being choked. When I got out of the car and started coming across the street, I could immediately see this is a child that is being strangled immediately. And again, he doesn't know these individuals from Adam, but Mrs. Ali does. In fact, she's outside of Isaiah, is really the only one who knows exactly who is strangling and who is being strangled. And she doesn't mention a word to law enforcement. Remember what Officer Bell says. When asked, how long until you knew? He was like, at the end. It was basically to the end of my time there on scene before I had any idea that Fatima had been strangled. Because even though I had talked to mom and had interactions with mom, she didn't say anything about it. Not a thing. So we have to go through the accomplice liability and the principal for Zahraa. So element one, as an accomplice, what evidence do you have? As an accomplice, at 2:13:55 into that exhibit, and remember that's the date time. In exhibit 34, it has the date time stamp on the bottom. So 2:13:55, Fatima goes unconscious. So we know she's already in that state by the time mom gets there. Her face is pale, her lips are blue. Ihsan is still actively strangling Fatima at that time. We said she knows what's going on because it's apparent to everyone else, immediately apparent to everyone else. And Zahraa is the only one that knows those individuals. And that she's attempting to intervene on behalf of her husband while he is still actively choking Fatima. Not Fatima. She's not attempting to intervene on behalf of Fatima. That is a substantial step. That is more than your presence and knowledge at that scene. We know that Fatima is not released by Ihsan until about 2:14, 10-13. So that if you look at that video and watch, somewhere between 10 seconds after and 13 seconds after, that is when we know Fatima gets released. So there's a period of about 11 to 14 seconds where mom is assisting Ihsan and not Fatima by trying to prevent assistance to Fatima from those kids. So again, as an accomplice, element 2 for Zahraa, that it was done with the intent to commit murder in the second degree, that she is actively watching her husband strangle her child in that rear naked choke with the arms tightly locked around her child's neck. She is actively able to see what every other person has described as Fatima's appearance throughout that time. She has time to view the situation and make a decision to try and remove impediments and prevent injuries to her husband. So we know she's able to quickly evaluate a situation and take actions based on her evaluation. To be clear, this is not a complicated fact pattern to evaluate when you have arrived on that scene. Everybody says so. Everyone that's present says so. Every other person immediately knows the danger, obvious danger of death to Fatima, but somehow Mom doesn't. So what do we take from this? Her loyalty is to her husband and his purpose, not to her child. So then as a principal, what is the substantial step, the evidence you have of a mom as a principal? She's just watched her child being choked and unconscious for approximately 11 to.
I have to get clarification. Diane, principal, how are you signing that?
Main person or, yeah.
Okay, that's what I thought.
I'll
13,
double
14
check.
seconds per that bus camera video. Fatima is then released. Josh Wagner gets her released. She is incoherent. Remember what Fatima says. The last thing she sees, remember seeing is Isaiah on her face and bushes. And the next thing she knows, she is in her mom's arms, and her mom has her arm around her neck. She is not there. Mary Wagner talks about that, like that girl is not there. Like, I don't have another way to describe that. She just was clearly not aware of what is happening around her. She has come out of that unconsciousness. But she immediately wraps her arms around Fatima's neck. Her ability to breathe, Fatima says, I can't breathe. I'm trying to tell my mom, but everyone describes like nothing is coming out. There's no sound coming out. Denicola says he remembers hearing her being almost like raspy, whispery, but she wasn't really making sound. And plainly, he said, I wasn't looking at that. I saw what appeared would be a mom and the child, so I assumed they were fine. My focus is on dad because that's where the immediate threat was. And I was trying to pay attention to the immediate threat. But I remember hearing this very whispery, raspy. That is consistent with what Fatima told you that she was trying to do. Trying to tell her mom, I can't breathe. I can't breathe. And her mom doesn't let her go. So what happens? And the kids intervene as well. That's the substantial step. Dr. Gilbert, again, all of that same information about the effects of strangulation on the body and why. And certainly, if you've just been strangled for 45 seconds, being strangled a second time doesn't improve that condition. You don't start over from zero as if the first time it never happened. It is a continuation of that strangulation. So it is the information that the act was done with the intent to.
Everybody, I wanted to take a minute to welcome Miss Natasha. She's an interpreting student. I appreciate the invite. Maybe next trial. I don't have the background information to accurately interpret the case. Would love to join you for future streams. We would love to have you. Interpretation is a volunteer. This is not court. This is entertainment, but we are viewing court. And Diane is a nationally court certified interpreter of how many years now?
Oh, I don't even know.
Over 30 years.
Certified for a long, long time.
Over 30 years. So Natasha, please come join us. We would love to have you. It would be awesome. I open this up to anybody who's a student as well, because you learn a lot. And my deaf audience is aware of that. They are accepting of the students, and they are encouraging you guys to do this. So welcome aboard. Please join the Discord and stay in touch, my love. Stay in touch.
And we'll take feedback from deaf watchers anytime.
Yes. And I'm in Texas, and I went to San Antonio Community College to learn. I am deaf without my hearing aids, so my signing may be a little bit different than a straight interpreter, but that's okay. So great to see you, love. Back to court.
Commit murder. Same intent as accomplice liability. That hasn't changed. She's actively watched her husband strangle her child. She's actively able to see what everyone else has described. She's had time to view that situation and make decisions to try and remove those impediments to her husband and prevent injuries. And she's had, at this point, when she is separately strangling her daughter, has even more time now, knows the danger, and does it anyway. She does it anyway. That is not an effort to comfort her child. Again, that is not where her loyalty lies in this situation. And she demonstrates that over and over and over again during the course of those videos. So here's that bus video. I'm going to play it in regular speed. You can play it whatever speed you want.
We will not see the video. Diane, I'm going to let you catch up. I got to do something behind scene.
Okay. You do your horns like that, I do. I don't.
Horn. I do bus, and then you're going to have to lean back, girl. You're like,
No!
I'll show the video at lunch.
Was he crying?
This is what you see from the backside, right? They've now run away. And this is the face of Isaiah and Fatima as they are running to the school for help. It is not the face, I submit to you, of children who are just goofing off, who just believe that they are trying to get away from their parents because they're going to get in trouble. Evaluate what that face looks like as Fatima's running away from her parents. Look at Fatima's face when she comes in Exhibit 111, page 3 of that, because it comes in a packet of still shots. Look at Fatima's face when she comes in that office. You heard Tracy Arnold testify that she looked like she was in terror. She was frantic. Submit to you that is consistent with what Exhibit 111 presents. Now you also have a instruction attached to a special verdict form. Everything that is a -1, essentially, in your packet. There's a lot of verdict forms, you guys. Everything that is a -1 is what we'll refer to as a special verdict form, and you have to just answer yes or no. And that is essentially depending on which count it is Ihsan a family or household member, or is Zahra a family or household member of Fatima? And here's the instruction that describes what a family or household member is. It's exactly what you would think it is, right? If you are a biological or legal parent-child relationship. So in terms of the elements, attempted murder in the second degree, family or household member, on special verdict form A1, Ihsan Ali is Fatima's father. Everybody says so. Fatima says so, right? In fact, part of the defense that has been provided to you is that they are parents, they are her parents, and so therefore they get to behave in a particular way. So I submit to you, this is not an argument between the parties. You still have to find it, again, beyond a reasonable doubt. The parties are not arguing about whether Ihsan and Zahra are Fatima's parents. So the answer, if you convict on any of those charges, the answer on each of them should be yes. So now we're going to jump over to count 3, unlawful imprisonment of Fatima, again, for both parents. Your Honor, it sounds like maybe we need a break.
All right, I'm going to ask the bailiffs to come forward and we're going to take a recess for 10 minutes. Remember, you are hearing closing arguments and deliberations has not begun. You are not to discuss anything during this break.
Okay, Diane, if you don't mind, keep signing. I think we may have someone watching. Just so you guys understand. First, I want to go back to our fabulous new friend, Natasha. Thank you so much for hopping in. I don't know if you're still here or not, but the next case that we're going to be covering is the Donna Adelson trial. And if you join our Discord, we have, if you want to do any kind of interpreting, I will share the documents so you have an idea what's going on with the case. Grieve Frank Leroy, but wonder why she said on the stand, because I don't think that's what she said at the school office. Well, I understand there was slight inconsistencies with her testimony, but once again, trauma can can happen in trauma. Okay, so we should be coming back in court any minute. I have what I'm going to do once we go into verdict watch. I'm going to start doing a deep dive. Well, I'm going to do a recap of this entire trial, and then we're going to start doing a deep dive into the key players for the next week and a half to 2 weeks between court dates and trials in the Donna Adelson trial. Yes, we have merch, in my humble opinion, is right here. So we're going to go do that. So I think I have the bell on automatic, June. So for those of you who are just joining and don't know a whole lot about this trial, let me give you a quick rundown of what's happening. Ihsan, Ihsan, or Ali, the father, Zahraa, Zahraa, the mother. The victim is a 17-year-old daughter, Fatima, Fatima. They lived in Washington. I know that the daughter now lives in Canada. The date was October 18th of 2024. The charges. Now, this is where things got a little crazy. So we're going to go through the charges. Second-degree attempted redrum. First and second degree attempted kidnapping. Second degree. How are you doing degree? Like college degree?
No, I spelled it.
Oh, okay. You went like that. I was like, ah. Domestic violent assault. Fourth degree assault on the father, by the father, in violation of protecting order and second degree burglary of the mother. So on day one, we had, of course, the jury selection, opening statements, and overview of charges. Day two. First responders and school staff testified about the scene at Timberline High School. Day that was day 2. Sorry, day 3 was a cell phone video presented eyewitnesses' recounts of the assault. Day 4, we had the cultural experts discuss the honor-based violence in the family dynamic, not the honor-based red drumming, which is what everybody is all about, that we cannot talk about, but they did discuss the cultural violence of the family. Fatima, the daughter, testified, described the threats, prior abuse, and the day of the attack. Then we go into day 6. The defense cross-examines. Some people think it's Fatima. It's Fatima. Fatima. It's real fast. Introduces cultural defense arguments. Day 7, charge conference, legal arguments over admissibility, and the jury instructions. Day 8 is today with closing arguments. So that is where we are. Now, here is some of the legal strategy breakdown. The prosecution is arguing that this was a premeditated assault with intent. The defense is suggesting it's just a cultural misunderstanding. No malice was present.
Excuse me. Sorry.
Are you okay?
Yes, I just didn't believe what you said.
Oh, I know, right? I know. You're like, what? What? And now I lost. There we go. That's the page I was on. The prosecution highlights prior threats and protective orders. The defense challenges the credibility of witnesses and the victims, which is what they're going to do. Then the prosecution uses video and eyewitness accounts. And of course, the defense questions the interpretation of the footage and motives. I'm like, please. So let's talk about honor red drumming a little bit, the legal recognition and the classification of that. Motivated based definition is HBV is often defined by its intent. Acts committed to prevent or restore family honor, rather than a specific crime like just assault or just plain kidnapping. Meaning the female, and it's always the female, has done something that brings dishonor to the family. Thus, they are going to unalive that person to bring honor back to the family. The most legal framework threat HBV has as a subset of violence against women and girls. Acknowledges the root is patriarchal control over female, I can't say this, autonomy. AUTONOMY, autonomy. Human right violations, international bodies like the UN and the Council of Europe classify HBV as a violation of human rights, particularly the right in life and liberty and bodily integrity. Now, the common legal charges is a cultural defense. So some defendants argue that the culture norms justify or mitigate their actions. Courts vary in response. I'm like, BS. Oh, y'all quit talking about food. I'm trying to lose weight and I can't if I keep eating. Victim credibility. Now, the victims may face community pressure, fear, or shame. That complicates the testimony in prosecutions. And those that are being brought in to testify against the viewing or witnessing of said act will also have that same problem. And if it's a woman who testifies against somebody who they believe or has seen to commit these acts, then they themselves, when they are in private and out of the protection of the U.S. government, they too can be honor redroomed. The term honor can obscure the criminal nature of the act. Some advocates term the control crimes or gender crimes. Sorry. So, HBV is protected under general criminal laws, the assault or attempted redrum, but the courts may consider motive during sentencing. This is the U.S. legal approaches. Immigration protections. Asylum survivors may qualify if they face prosecution or persecution from family and community due to gender or nonconformity. T visa available for victims of forced marriages or family trafficking. See, forced marriages to me, family trafficking. It's a form of human trafficking and enslavement. The international perspective is the Istanbul Conference required singularly countries to prevent, protect, prosecute those, countries to prevent and prosecute, but also to protect the victims of HBV as a part of broader efforts against domestic violence. Now, the UK and the EU models, some countries have developed specialized units and legal definitions for HBV, including forced marriage and honor unaliving. So I want to talk about the father's charges and the class of felonies. The father is getting charged with attempted redrum second degree, class A felony. A class A felony is I have to scroll down. I have a bunch of notes. A class A felony is imprisonment plus $50,000 in fines, requires intent to cause unaliving. Attempted kidnapping is first degree and second is A and B felonies. So that felony is also life and up to life imprisonment with $50,000 and up to 10 years and a fine up to $20,000, includes strangulation and substantial injuries. We will continue that when we come back. I hope y'all are liking this. I lost my place. What, love?
Kidnap?
Kidnap. I'm doing this.
Yeah, well, it's no, it's kidnap. Kidnap.
Okay.
Kidnap.
SK?
Yeah. Well, no S. Well,
or fist K?
Palm facing up.
That looks like back. All right, you chirp it. I'll look it up.
Okay, you see if you can figure it out.
I just say.
Well, that's what I would think, but that's not what they show.
Well, also different regions and different areas.
See a book? That's all I got. American Sign Language Legal Dictionary, Random House.
Oh my God, you want to see how they sign it? Watch this guy.
Huh? That's Indian Sign Language. That ain't working. Kidnap ASL.
Kidnap and an abduction is this. That is what I've learned.
That works. Oh, sure. I'll take that.
Well, cover mouth and to take.
Yeah, well, that works too. I like this one best.
I do too.
All right, that works. We take it.
That's what I've been using.
Well, what's that website?
I don't know. I closed it already.
Don't help me. Okay, that's all right.
Let's put it this way. because mother attempted, even though she was found not guilty in the court of the U.S. laws, by what was testified today, she probably would be protected. The reason why she probably attempted to finish off the act of of strangling her daughter was because if she did not, she would be included in the honor red room later.
Yes.
I think she's protected. I think what she did was just enough to keep her from being unalived herself, but I think she would become a martyr in that community, in that culture.
Yeah.
Both of them.
Wow.
That's right. Yeah. She's sympathetic to her mama's situation because, in all honesty, this woman was born, raised from day one in this culture. She doesn't understand or know any different at all. Dad.
Please be seated. Ms. Stone, you may continue with your closing argument.
So now we've moved on to count 3. We're going to skip count 2 for Mr. Ali. We're going to come back to that. As you can see in your instructions, there's some other instructions that follow along with that. So let's skip over to count 3 first. That applies to both Ihsan and Zahraa, and that is the unlawful imprisonment of Fatima. So you have the instruction that tells you what unlawful imprisonment is, how unlawful imprisonment is defined. I've highlighted for you the intent element, which is knowingly. Person commits that crime when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty. If the restraint is without legal authority or without the person's consent, and the person knows that restraint is without legal authority and without the other person's consent. What is restraint? Restraint is without consent if it is accomplished by physical force, intimidation, or deception. You have that definition in your packet. I'll tell you, I don't recall what the number is. For those, I don't have them all committed to memory. And then you have knowledge. What knowledge is described for you. Throughout the course of your instructions, you have a number of different intent elements that are described for you, or mental states that are described for you. Knowledge, intention, doing something with intent, and as you'll see later, reckless. Okay? A person acts knowingly when he or she is aware of that fact, circumstance, or result. You don't have to know that the thing you're doing is a crime by NRCW. You have to know that the thing you are doing is the thing that you are doing. You are acting with knowledge that you are doing the act. If I walked over here and pushed Miss Zoe, I don't have to know that that is a particular type of an assault. I have to know that I am pushing Miss Zoe, right? If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. And when acting knowingly as to an element is required to establish the element of the crime, that element is also established if that person acts intentionally. So if I walked over here and shoved Miss Zoe, I know that I have to know that I've shoved her, right? Not like I tripped or somebody bumped into me and I had no idea that I actually bumped her or pushed her at the same time. If I walked up and 2 hands shoved her, if you agreed that I did that intentionally, then you also agree that I've done that knowingly. Intentionally is essentially one mental element higher than knowingly. So as it pertains to Ihsan Ali, that is your to convict instruction, count 3. You have that in your packet. We're going to come back to these. And then you have the same instruction for Zahraa, exactly the same, except again, it has for Zahraa that principal or accomplice language. That is the only
That's on them, not me.
those 2 instructions in your packet. Okay. So again, those elements as it applies to both parents. Remember, I said that we are going to talk about what overlaps between them first. So what applies for both, don't anticipate that there is going to be an objection, or not an objection, a disagreement by defense counsel that happened on October 18th, 2024. I also don't anticipate that there is going to be a disagreement. Again, you still have to find that I have proven it to you, but that the defendant knowingly, and as to this element, restrained the movements of Fatima in a manner that substantially interfered with her liberty. You have to find it. I don't think the parties disagree that Fatima's movements were restrained. Ihsan strangles Fatima. She's unable to get away without help. Zahraa holds on to Fatima after, strangles her, would not let her go. Again, Fatima is unable to get away without assistance. So I submit that these are not going to be issues that are going to be really in contention between the parties. That restraint, as it relates to both parents, that restraint was without Fatima's consent. That is the testimony of everyone. She is fleeing her house and her parents. She has run away. She has been actively avoiding her family all day. Exhibit 34, you see that she is trying to run from dad. She is fighting dad. You have exhibits 74, 75, 78, 77, 81. You see all of those injury photos, and we're going to look at them in a little bit, but they show all those scratch marks to her neck. And you heard the testimony. I believe it was Dr. Gilbert. It may have been Lisa Wall talking about she's clawing at dad's arms, and you hear all of the students talk about that. Clawing at dad's arms, trying to get him off of her neck. Clearly, that demonstrates a lack of consent by Fatima to be restrained, let alone restrained in that fashion. And then Fatima tells you too, she's trying to tell her mom to let her go. She is not consenting to her mom strangling her. She is not consenting to the manner in which her mom holds her. And I want to be clear, we're going to come back to it, or not come back to it. We're going to get to it in a little bit because you have a parental discipline statute. The state is not asserting that a parent cannot restrain their child. We know that that is the case, right? There are things that parents have to do to correct restrained children, but this is not one of them. So as you're starting with the initial baseline of whether this happens with Fatima's consent, it certainly does not. And you have ample evidence of that fact. And then you have exhibit. Mom is strangling Fatima around the neck at about 2 seconds in, grabs her again at about 8 seconds in. And you have those screenshots. It's far away. It is harder to see, I would submit, but it is there. The location of mom's arms. You have that Fatima, you see her forward, and then you have her leg going up, and you see that she is being pulled backwards at about 6 seconds in. She is trying to get away. She is looking to Isaiah for help. Her balance is being pulled off, and that is mom who is holding her at that point in Noah's video. Again, that applies to both parents, that the defendant knew that restraint was without Fatima's consent. That's the testimony of everyone. Her parents know that she does not want to be restrained by them, certainly. And all of that evidence is exactly the same. Not only was it without her consent, but that same evidence tells the parents that they know that it is without her consent. They're not under the mistaken belief that somehow she's okay with it, and that any of these acts occurred in the state of Washington. Same information that you had previously. Okay. So what is the unlawful imprisonment as it relates to element 4 only for Ihsan? First and foremost, without legal authority. You cannot strangle your child to restrain them. It seems really obvious, but apparently it has to be spelled out. You cannot strangle your child to restrain them. Instruction 21 is the self-defense instruction for assault, but I submit to you it is instructive for explaining the limitation on parents' rights for either correcting or restraining your child. You forfeit your right to use parental discipline to restrain your child when you do so in this manner, when you strangle your child and impede their breathing. It should be obvious. The other examples given in that instruction, you can't burn your child, that should be obvious to correct them or restrain them. You can't throw your child. You can't cut your child. You can't punch your child with a closed fist. Those should be really obvious things as parents, right? You do not, that force is incompatible with the duty to care for your child as a parent. So you cannot restrain your child by strangling them and cutting off their air. That is not an appropriate use of legal authority. And element 5, as it relates to Ihsan, that the defendant knew that restraint is without legal authority. He knows he's not allowed to strangle his child. You go back to that instruction 32, knowledge, subjective and objective components to knowledge. There's a subjective, he knows all the facts that what he is doing is not simply restraining her movements, right? It says, based on the facts and circumstances known to the person at the time, he knows he is not merely restraining her movements. Everybody there says it too, right? They're watching it. It's his arms around Fatima's neck. That objective measurement, if a reasonable person in the same situation would believe that fact to exist, then you are permitted but not required to find that he acted with knowledge. A reasonable person, I submit to you, with all of those same facts and circumstances known to Ihsan at the time, knew that restraining her in that manner was not with legal authority. There's no good faith belief here that such use is reasonable or moderate. And the law does not require you to know that that act is unlawful specifically or an element of a crime. It doesn't require you to go to an RCW or a jury instruction element 5 and say, well, I didn't know it was that element, so therefore you can't hold me accountable. That would be absurd, right? You have to know that the behavior itself is wrong and without legal authority. So how does that apply then to Zahraa? Again, same information. You can't strangle your child to restrain them. She watches Fatima being strangled by Ihsan. She then puts her own arms around Fatima's neck. She's not comforting her. She's strangling her to keep her from fleeing. Her breath is impeded. Fatima's breath is impeded by that hold. She testifies to that and told the medical professionals, you heard that from the professionals specifically, that she reported that by her mom to the medical professionals. You look at that instruction 21 and those limitations on what parents can do to their children to discipline or restrain them. She's doing it both herself as the principal, and she's continuing her husband's actions for that same purpose as an accomplice. That the defendant knew that restraint was without legal authority, that information is the same as it was for Ihsan. And then again, how do you know that she knows that that's without legal authority? Her own statements. Her statements are about how people have treated Ihsan at the scene. She has talked about, where is my daughter? Give my daughter back. I want to see my daughter. And I want to see my daughter. I want to talk to my daughter. Right? Her focus consistently is on Ihsan. It's not on the health or care of her daughter, just location and access to her. That is all she expresses to law enforcement. So same thing, family or household member. This is your verdict form, C1. No change to that. Exactly the same as the last one. So now we're going to go to Ihsan Ali, count 2. And now that's the overlap between the two parents. Now we go to separate crimes for each of the parents. And we're going to start with count 2 for Ihsan Ali. That is that assault in the first degree. Assault in the first degree, the crime of assault with intent to inflict great bodily harm. He or she assaults another by any force or means likely to produce great bodily harm or death. And then you have the definition of assault. We'll come back to that. That will apply when we get to the assault on Isaiah. Touching or striking, harmful or offensive. Right? Great bodily harm. And great bodily harm that creates a probability of death. Bodily injury that creates a probability of death or significant permanent disfigurement or causes significant permanent loss or impairment of the function of any bodily part or organ, right? If you take somebody's eye, you're talking about great bodily harm as an example. Or if you use a measure of force that creates the probability of death if that force is not then otherwise interrupted. And that's what we're focusing on in this case. So you have those definitions, or excuse me, you have the overall elements. You're given that in your packet. There's 4 elements. So let's go through them. Well, we're going to talk about this first, actually. Physical discipline of a child that the force used was lawful as defined. We just kind of went through that. That force is lawful when it is reasonable and moderate, when it is inflicted by a parent for purposes of restraining or correcting. And you must determine whether the force used, when viewed objectively, as a reasonable person looking at that same force, is that force reasonable and moderate? And that definition goes on, as I said, things that the law identifies as that you may consider unreasonable. Striking a child with a closed fist, interfering with a child's breathing. The other examples we talked about, burning, throwing a child, kicking a child, all of those things. As part of your determination of whether force use is reasonable or moderate, you shall consider the size, age, condition of the child, the location of the injury. Certainly, the smaller the person, the younger the child, the more concern there is for how that force is used on that child. It's not a binding inference, right? But that is an example of things that you can determine are. So that element, as it pertains to Ihsan, again, the things that I submit to you are not going to be in contention between the parties, right? October 18th, it's Fatima Ali and State of Washington. Those are not facts that people I submit are going to be arguing with you. Element 2 is where I think you're going to be focusing the majority of your discussion in this case as to this issue. So let's talk about the evidence that you have. Element 2, that it's committed by a force or means likely to produce great bodily harm or death. So first you heard from Lisa Wall, and you're going to see LOC because I run out of room in each of these, right? Loss of consciousness. What happens when you lose consciousness? Your muscles relax. The damage becomes easier to inflict, and the easier the damage is to inflict, the result is death. That is the next logical step following loss of consciousness, is death in that process. You have the exhibits from Synovia Rivas, 67 through 81. She talks about the symptoms that she observed immediately afterward during that exam: headache, dizziness, lightheadedness, again, loss of consciousness, memory loss, a fuzzy feeling. Fatima reported feeling fuzzy, confusion, weakness and numbness, vision changes. She says everything got dark. And you heard her talk about that. Hearing changes. She had ringing in her ears. She had neck pain, external neck pain. And you see all the bruising from that. You hear her talk about her sore throat, her difficulty and pain swallowing, those voice changes, the hoarseness. They describe her as hyperventilating. She was still hyperventilating after the fact. All the redness, abrasions, and bruising, and then the petechia around the eye, she describes. Fatima described a 5 out of 5 for pain, told Ms. Rivas she thought she was going to die, and it felt like it went on for 5 minutes. It felt really long. She said, I'm sure it wasn't. I know it wasn't, but it felt really long from where she was. And think about what Dr. Gilbert, when Dr. Gilbert went through and talked to you about what the effects were of jugular vein occlusion, carotid artery occlusion, tracheal occlusion. She correlated all of that to those symptoms specifically. Why do you get headaches? Because you have that buildup of pressure, right, in your brain. Why do you have loss of consciousness? Because there's not oxygen going to the brain, right? There's not bad blood coming out. There's not good blood going in. Why do you have memory loss or fuzzy feeling? Because all of that brain function has been interrupted as that process goes. She talked about the eye changes and the hearing changes because your brain stem is interrupted, and the ability for your brain stem to process and connect to the vision in the eyes is been interrupted and is unable to do so. Hyperventilating, we talked about panic. One of the natural symptoms, your body's natural reaction is to panic when it can't breathe, and that panic continues on until it no longer feels like it is in threat or fear. She's describing hyperventilating to Synovia Rivas while she's arriving at the hospital, still after the fact. She has not come down yet. Her brain has not taken that threat away so that her breathing has returned back to normal. Dr. Gilbert talked about all of those things. So then you heard also by the force or means likely to produce great bodily harm. You heard from Dr. Kim, who was not excited to testify, right? He talked about that. It was terrifying for him. But an otolaryngologist, I'm sure I am mispronouncing that. he's a specialist at that point, called in by St. Pete's, right? Strangulation can result in death. This seems to be a very accepted premise. Strangulation can result in death, not one really for argument. He says that there's air in the esophagus. They didn't scope it because they were worried that there was a tear in the esophagus, so they're not going to put a scope down there and increase that danger. That air is from damage to the throat, not from compression to the chest, not because somebody, she fell down and people landed on her. That's not where that happens. That happens below. And the air that he saw was higher up in the throat area. He said it's better in 24 hours, but he can't say it's gone. Remember what he said? Like, it had not gotten worse. It wasn't gone. And he can't say it's gone because we don't do that kind of exam for that. We don't want to put that much radiation into this very small 17-year-old. Dr. Stankus is an ER doctor. She testified for the defense. She said no mediastinum. She agreed. It can certainly result from strangulation. She agrees that the standard of care for pneumomediastinum, the air that was higher up in the chest, to admit the hospital for observation and retesting. We don't send those folks home, right? It's not benign. It's not a mole. That was her example of something benign. We don't send those folks home. If you present with pneumomediastinum, especially as the result of strangulation, you're getting admitted, and we're going to watch you because it absolutely is dangerous. And Dr. Kim said, I had significant concerns. We were worried about her. That's why we admitted her. And Dr. Stankus agrees. Strangulation can result in death. Then you have Dr. Gilbert's testimony, and she talked about being a child abuse specialist and a 30-year medical practice. And she gave all of those strangulation effects on the body that we've previously talked about. She talked about that jugular vein occlusion. Remember, 4 pounds. That's that lack of ability to remove the deoxygenated blood. 4 pounds of pressure. It takes about a minute to lose consciousness with jugular vein occlusion only. 20 to 30 seconds for petechia, 3 to 4 minutes for death, if there is only jugular vein occlusion. Carotid artery occlusion, slightly different. Greater pressure required for carotid artery occlusion. 11 pounds of pressure. You lose consciousness in 20 to 30 seconds. Death is anywhere from 1 to 3 minutes. It's a range, right? You can't say specifically, but it's a range. And she talks about that. She said when a carotid artery occlusion, you're going to see more global results. You're going to see loss of consciousness. You may see seizures. Then you move to brain death or death and a loss of muscle tone. When Dr. Gilbert watches that video, she says, I believe that I see a seizure. There's a moment right after or right before she loses consciousness that her arms, I believe she says, flail without any movement. And prior to that, there's some significantly focused intentional movement. And then there's a moment of flailing, and then she goes limp. Fatima goes limp. Caleb says, that's the word he uses. Isaiah used, she like frizzed, and then she went limp. So what are those kids describing to you? They're describing a difference between the moments where she is fighting, Fatima is fighting for her life, right before she loses consciousness. And I submit to you that is a seizure. And that is what Dr. Gilbert watches that video and believes she sees. She said, we can't test for it. That's not the kind of testing that we're able to do, but I submit that's what I see. And that is consistent with what the science says. It's consistent with what the witnesses observe. So how do we know that we've gotten to the carotid artery occlusion? Because about 30 seconds in that 20 to 30 second range, when you watch the video, that is when Fatima loses consciousness. So we know we don't have solely jugular occlusion. We also have carotid artery occlusion. He is imposing enough force on that child's neck to create significant damage, great bodily harm, and the likelihood of death, but for the interruption. And that death can happen in 1 to 3 minutes. Tracheal occlusion results in the lack of oxygen to the brain, that buildup of pressure. And again, Dr. Gilbert describes there's going to be immediate panic. You've got that CO2 buildup that's telling your brain that you have to breathe, and then it results in death. She describes observing the pneumomediastinum, the subcutaneous emphysema, that air in the throat, And anytime there is obstruction of either blood or air to the brain, it is a life-threatening injury. So Exhibit 72 and 103, the petechia described, you have synovia brevis on the left-hand side. And how do you know that it's petechia? Because it doesn't exist a couple of days later. 3 days later, it has resolved itself in Exhibit 103. And that is the distinction right between those two. October 21st, the photos show the bruising and scratches that cover from the left to the right side of her neck, consistent with the arm placement and pressure for her carotid artery, her jugular vein, and that tracheal occlusion. And you see that all in that space right there. Again, Exhibit 74, same. These are 3 days later. The bruising and the scratch is consistent to the front of her neck, where Fatima is scratching and clawing at her dad's arm to get it off of the front of her neck. That's the tracheal occlusion happening there at the front. Remember, your carotid and your jugular are on the side, and your trachea runs right down the center. Exhibit 81, the side of her neck, and that bruising goes all the way over to the back side of her neck. Again, consistent with the arm hold that is described by all of the witnesses leading up to that point, right? All of this bruising is the result of that, and that right arm and left hand in a chokehold from behind, and pressure for the carotid artery and jugular vein occlusion. So then element 2, again, force or means to produce bodily harm or death. Those symptoms reported in that video evidence tells us, based on the time and those symptoms experienced, that all 3 of those occurred in this case, which means the amount of time it takes to inflict the probability of death is grossly shorter. The force used would have resulted in great bodily harm or death if not interrupted. No injuries to her head are noted by medical staff or reported by her. Defense counsel, I believe in his cross-examination, said, well, if they hit that tree, couldn't this have happened? Couldn't this have happened? What if all of those symptoms are consistent with a head bump? And Dr. Gilbert said, some of them are. Not all of them, no, but some of them are. But also, I did a head to toe in none of those. There's no bumps on her head. There's no bruising. There's no tenderness. Plainly, there's no medical symptoms or signs to indicate in any way that she struck her head. All of her injuries and damage is to her neck. All of the symptoms she experienced flow directly from that damage. And that's it. Element 3, acted with the intent to inflict great bodily harm. He's acting in anger for her defiance. That is intentional. That is what Ihsan Ali is doing. He holds her in a rear naked choke for just under a minute, and he is squeezing hard. He knows she is fighting. He knows she is struggling. He knows she is gasping for air. He knows that she is grabbing at his arms. And then she goes limp and stops fighting. But despite that, he continues to strangle her. So you know he is acting with that intent. He's ignoring the strikes and the screams of the kids. They are punching, they are kicking, and it has zero effect. It does not impact or change his behavior in any way. And that is an extended period of time. We know that he already has his arms, in fact, around her neck when they go down to the ground, and he doesn't throw his arms out to catch himself. He's going down with her, and he's going to hold on to her neck no matter what happens to her in that process, from the beginning to the end. Because at the point that he grabs her by the neck, he is furious. And that is what he's acting with the intent with. It's not to restrain her. It's not to do any of those things. He is now just a grown man strangling a child because he is angry that she has defied him. He's only released Fatima when he is forced to do so by other adults. When you go back to that family household member, that is your B1 special verdict form again. Nothing has changed. Back to physical discipline, that force used is lawful as defined, reasonable and moderate, purpose of restraining or correcting, and viewed objectively. So why does this not apply? Well, it applies for charged and lesser offenses. You're going to see that, and you have a whole range of instructions in there about lesser offenses. First, it must be your child. Okay. he meets that, it's his child, it's not somebody else's child. Must be for the purpose of restraining or correcting. It fails immediately there. None of this contact at this point for the assault in the first degree is for restraining or correcting. It is punishment. He's intending it for punishment of this child. Ihsan is angry. He may have gone to the bus stop to get Fatima and take her home, but by the time he grabs her, he is no longer doing that for the purpose of correcting her. I think one of the primary tenets of parenting is that if you are so angry you can't see straight, you do not engage with your child. You walk away. You don't attempt restraint. You don't attempt correction because you are no longer acting in a manner that is for the child's purpose. By the time you make contact with that child, you are doing so for your own edification. That's exactly what is happening here. Parents don't correct children by strangling them. Parents don't correct children, restrain children by strangling them. It has to be objectively reasonable and moderate. You are deemed to be reasonable people. That's why you're sitting here. It has to be objectively reasonable and moderate use of force, and that is not what occurs in this case. It is unreasonable to strike a child with a closed fist or interfere with their breathing. The medical evidence proves that his acts interfered with her breathing. You have to consider the size, age, and condition. We heard that Fatima's 5'1".
Oh, why, thank you, Ada.
100 pounds, maybe soaking wet. She's a small person. She might be 17 years old, but she's a small 17. And she is certainly grossly smaller than her father. We also heard the testimony of Tracy Arnold. The day occurred. Remember, Fatima's been home being online. She's not been at school since about September 17th. So they haven't seen her in about a month. And Tracy Arnold, she looked thinner, way thinner than the last time I saw her, and much more frail. So I submit to you that Fatima is particularly vulnerable. She already was with her size, but even now more so than she was just 4 weeks prior. And we also know that Fatima's throat is particularly vulnerable as a child. And Dr. Stankus' testimony on behalf of defense also said, yeah, I mean, children obviously are smaller. It's easier to
Was I speaking?
do damage to their windpipes. It's easier to do damage to their necks. She might be 17 again, but she is a small 17. And as a child, she is already more vulnerable than.
Welcome to the family, Plum Awesome.
Right. That placement of that force is extremely dangerous for those jugular veins, the carotid arteries, the trachea, and the spinal cord in the back of the neck. And all of the medical folks talked about that. You have an instruction in there that is very wordy because, again, we're lawyers and that's how we put things in a narrative. But I'm giving you a picture, okay? You start with assault in the first degree. That is what you evaluate first. You do not move on to any other instruction and evaluate it until you have completed assault in the first degree. If you have evaluated and deliberated on assault in the first degree and you agree unanimously that he is guilty of assault in the first degree, you stop. You don't address assault 2, you don't address assault 4, you stop. Your inquiry is done. If you're like, yeah, I don't know, then on assault 1, then you move over. Whether it's unanimously not guilty or you're unable to reach a verdict, then you go to assault 2 and you start that process over again. I will tell you that as you go through, you may well say to yourself, well, these two are easy. These two are really obvious. We'll just do those instead. You don't get to. Your instruction says you do assault 1 all the way first. And then if you are unable to complete that, then you move to the other 2. You work your way down, right? But otherwise, your inquiry stops if you all agree unanimously that he is guilty of assault in the first degree. Same thing. Do not begin that analysis until you've reached a decision on assault in the first degree. So then we go to assault in the second degree, that lesser included. When someone intentionally assaults, as it relates to Ihsan, when the defendant intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. You now have the definition of reckless, knows of and disregards a substantial risk, and that disregarding is a gross deviation from conduct a reasonable person would exercise in the same situation. I'm going to show you a ladder here, that mental elements ladder. So remember, we talked about if you do something intentionally, then you've done it knowingly. If you've done it knowingly, then you've done it recklessly. So it's a when recklessness as to a particular fact is required to establish element, it is also established if a person acts intentionally or knowingly as to that fact, right? And that makes sense, because if somebody has disregarded a standard of behavior that is expected, and that is a gross deviation, then we presume that you did so knowingly. I'm sorry, if you've done so intentionally and knowingly, then we presume that you've also done so recklessly, right? It's incorporated therein. So substantial bodily harm, a temporary but substantial loss or impairment of any bodily part or function, or a fracture. And then you have the definition of strangulation: to compress a person's neck, obstruct the person's blood flow or ability to breathe, or do so with the intent to obstruct the person's blood flow or ability to breathe. It's a really obvious, I submit, definition, but we have to give it to you anyway. So count 2, assault in the second degree. These are your definitions. We'll come back to the bottom paragraph, but you essentially have to decide A or B, 1A or B, and you don't have to be unanimous about 1A. So as it applies, same information for October 18th, 2024 in the state of Washington. None of that has changed. So 1A, intentionally assaulted. There are 2 ways that you can, Ihsan Ali could have done this under the assault in the second degree. 1A, he intentionally assaulted and thereby recklessly inflicted substantial bodily harm. So the evidence you have of the intentionally grabs her twice. This is not an accident. He grabs her the first time and then he grabs her the second time. That moves into that rear naked choke with sustained pressure. Kids are pulling so hard that they have to dislodge him, that they have ripped his jacket. And regardless, he maintains his hold throughout. That is intentionality. Can't breathe is a temporary but substantial impairment. Losing consciousness is a temporary but substantial impairment of any organ or function. If you cannot breathe, if you have cut off air to the jugular veins and the carotid artery, or excuse me, blood flow, jugular veins and carotid artery, you have temporarily but substantially impaired their ability to function the way that they are supposed to. If you have cut off the airflow because you've crushed the trachea or closed the trachea off so the air can't get through, that is a temporary but substantial impairment because that bodily organ cannot function. If you have lost consciousness, your brain is not working the way it is supposed to. It is a temporary, even if you regain it, but substantial impairment because you are intended to stay conscious. That is what your brain is supposed to do. And his behaviors have impacted her ability to do so.
Oh, why, thank you, Ada.
Sore pain, sore, painful throat, difficulty swallowing that she describes well after the fact, temporary but substantial impairment, those changes to her voice, those changes to her motor skills, her ability to get up and move around. You heard that described, that loss of muscle tone, temporary but substantial impairment. And then you have all of that bruising along her neck. By definition, that is temporary but substantial disfigurement. That is not how she appeared prior to. And we're looking at 3 days later and it's scratches and that bruising is still there, those abrasions. So then strangulation, 1B, exhibit 34. You see him grabs at her neck twice. It's not an accident and refuses to release. You see, again, that's the same pressure. A lot of that information is the same for strangulation as it was for 1A. You have that her face changes color. You have all of that bruising. You have the medical reports and the nurse's testimony. And you have that she can't breathe. Again, doctor reports, nurse testimony, and medical reports. So all of that information is the same for 1B. You're going to consistently have overlap in the evidence between many of your charges. When you go to do that evaluation, you have to all unanimously agree that either 1A or 1B occurred. You do not have to agree which of 1A or 1B it is to find that element number 1 has been met beyond a reasonable doubt.
Thank you, Ada.
Okay. BB1, family household member, again, exactly the same. when we talk about count 2, as it separates itself, the lesser included for assault in the second degree from assault in the first degree, the initial placement of dad's arms around his daughter's neck and the impediment to her breath, that strangulation is complete. That's it. Assault second is done. As soon as he puts his arms, there's no requirement for loss of consciousness. There's no requirement for any of these other things to do. For strangulation, all he has to do is impede her breath. And the moment he puts his arms around her neck and you see her standing there grabbing at them before they've even gone to the ground, assault in the second degree is completed. That extended hold of her neck is what distinguishes assault in the first degree from that assault in the second degree. That is why that is not merely assault in the second degree. It is also, but it is not merely. So that's where we were. Back to your roadmap again. If for some reason you're stuck on assault in the second degree, then you go back through that same process. If it's guilty, you stop. If it's not guilty, unanimously, or you are unable to reach a unanimous verdict as to assault 2.
Okay, we're going to take a little verbal break here. I know this is really boring to a lot of us, and it is kind of getting a little redundant. And I know that this is not the wham bam that some closer DAs have, but she is being very methodical, very clear in the forms. And I think that is very wise of her, considering other trials that we have recently been following, that the forms have given jurors problems in understanding how it's to be filled out and understanding where's guilty, not guilty. If we go to this form, do we do that form, whatever. So I think she's doing a good job of it, although it is not as entertaining as I would like. I understand, babe. That's all I know. But thank you for becoming a member. Yay. Yay, 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 yay. Thank you so much. Night bots like this. This is a bot, I guess. It's kind of like a little mini program that we use to help us out so we don't have to hand type all this every time. See, I can come in here and do ILY. Well, wait. ILY, enter. And it should pick it up. There it is. If you're deaf and hard of hearing, you need interpretation, put an ILY in the comments. And it's consistent. And this particular bot is set up to some of these bots are set up. And that way my wonderful mods, June and Ronnie, brain cramp, June and Ronnie don't have to hand type this every single time. So that is helping them out and giving them more abilities to do other things. And by the way, we are seeking new mods. So if you are interested in becoming a mod, you like what we do here, you want to become a part of our family here, go to our Discord and log in and register, validate your account. You have to validate it to access the files, and then go and private chat me, and I will be happy to talk to you about possibly becoming a mod with our fabulous group.
Then you go to assault in the fourth degree. So there's that definition for assault in the fourth degree. It's simply committing an assault. No bodily injury required whatsoever. Nothing changes for counts elements 1 and 2. And the back half of element 1 then, as it relates to Ihsan, simply that he assaulted Fatima Ali. The touching is harmful. We have all of that testimony of the parents, of those present, the kids, Mr. Denicola, the Wagners, all of the doctor and the medical. And then we have that the touching of Fatima is offensive. She's fighting it. She clearly doesn't want to be touched like that, like how he is touching her. There's no injury required for assault in the fourth degree. So yes, obviously assault in the fourth degree has been met by the evidence before you in this case. And then BBB, 1, that's your family household special verdict form again. And that's where you end up. So last count for dad assault in the 4th degree as it relates to Isaiah. That definition is, we talked about those elements. They are exactly the same as that lesser included was for Fatima, but now it is for Isaiah. We all are likely to agree that none of this information has changed and is not at issue in this case. It is October 18th. That is Isaiah Williams, state of Washington. So what evidence do you have about the assault 4 of Isaiah? Well, that touching of Isaiah is harmful. You have the video of Ihsan punching Isaiah earlier in Exhibit 34. You have those still shots from Exhibits 8 and 9, 8 and 9 of him punching Isaiah in the head. Not simply a shove, not simply a push, but a closed fist punch to the side of Isaiah's temple. And then you have the Exhibits 39 to 51 showing his injuries, that redness, bump, the pain. You have Officer Beltran described seeing that in person and taking those photos. And you have that testimony. And also, you saw Isaiah. It's physically much, much smaller than Ihsan. You saw him when he was present here, and you see him in the video. They are not the same size individuals, right? And you know that touching is offensive. First of all, I submit to you punching anyone in the head, unless you are engaged in a boxing match, which you've signed up for, is offensive, right? Punching a child in the head is particularly offensive. Notably, no injury is required, but it exists here. There is that bump, that redness, and that swelling and that bump to the side of Isaiah's head. And you see it there, consistent with where he says he is struck and with where you see Exhibit 51, that closed fist strikes him in that bus video. So then you also have the self-defense instruction that is given to you for Ihsan, saying, well, I'm forced essentially to do this, and the state has to disprove that. So as it relates to count 4, force used by a person who reasonably believes he is about to be injured and the force he uses is not more than necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of those facts and circumstances known to the person at the time of and prior to the incident. Then you have a definition for necessary, as they reasonably appeared to the actor at the time. Not as he claims that they appeared or he'd like them to have been, but as they actually reasonably appeared. That there's no reasonable, effective alternative to the use of force and that the amount of force used was reasonable. And you have that in your definition. There's no duty to retreat, to be very clear. If somebody is attacking you, you are not required to retreat. But still, there's the requirement that the lawful force be not more than is necessary.
Oh, why, thank you, Ada.
You don't get to do whatever you want, plainly. There are limitations on what force you get to use in response. You also cannot be the person that physically instigates that interaction in order to create the likelihood of provoking a belligerent response from someone so that then you can use self-defense after the fact. And you have that instruction there as well. So why is this not self-defense? Start first, that force is not lawful. He does not reasonably believe that he is about to be injured when he strikes Isaiah. He is not striking Isaiah to himself. That's not what he is doing. And you'll look at those photos and you'll look at that video again. He is striking Isaiah to prevent Isaiah from interfering any further in his mind with what he gets to do to Fatima. It is objectively unreasonable what he does to Isaiah. He is grabbed at the point that a strike hits. You'll watch that video. He has already grabbed Fatima by the hoodie and he is dragging her by her neck into the dirt. And Isaiah is trying to pull him off. Isaiah is not striking him. Isaiah is literally trying to disengage Fatima from her dad, who has her by her hoodie front collar and is pulling her forward. It is already choking. That has already started. That is an unreasonable means of restraining your child, I submit. And Isaiah said, just like grab her, like, let's go home. That's not what happens. He's like, he grabs her aggressively. And remember that Isaiah has known Fatima at this point for a couple of years. And he says, I know Fatima. I know what she goes through. And so he is anticipating that this is not simply a, let's go home and have a sit down family talk about it. He is concerned deeply for what might physically happen to Fatima. And almost immediately, when she's getting ready to go, Dad grabs her by that hoodie and starts dragging her. And Fatima says that. It is, as we saw from the parental discipline, our laws recognize that it is objectively unreasonable to throw, to strangle, or punch their own children with a closed fist, let alone someone else's child. And that's when we give more leeway to parents, right? If you look at that video, he's not striking, Isaiah is not striking Ihsan. The evidence does not support that finding. And we talked about the size of Ihsan compared to 16-year-old Isaiah, who is 5'5". He didn't know how much he weighed, but I submit to you, he's a pretty thin kid. He's not a big kid. And he's also not punching a grown man who is in the middle of throwing a punch at him. That force used by any objective standard is unreasonable. You heard Elijah describe thunk. It's like, I heard that thunk when it hit. He's punching Isaiah in the head with a closed fist. It's not okay to do that, especially not when and how that punch occurs. It's for the purpose of neutralizing Isaiah. He can get to Fatima. It's not for protecting himself. It's not self-defense. Ihsan has created this situation. Isaiah did not. Ihsan's intentional actions were reasonably likely, I submit to you, to provoke a belligerent response from those present. Isaiah to be closest and have the most background information. We talked about that. And from the get-go, Isaiah is trying to assist Fatima, who he believes to be in physical danger. And he's right? And notably, when you look at the self-defense instruction for defense of others, Isaiah is entitled to protection under the same legal principles. So if anyone is entitled to defend themselves, it would be Isaiah. Those strikes by Isaiah on Ihsan do not occur until Ihsan is already strangling Fatima on the ground. There's a lot of, well, he hit him like 42 or 32 times, whatever number defense counsel proffered. That doesn't happen until after the fact when they're already on the ground. Isaiah has not struck Ihsan when Ihsan punches him in the head. There is the initial, and you'll be able to watch it in Exhibit 5. There is the initial contact, and when you look at that video, when you look at those photos, you'll see he's already dragging. He already has a hold of Fatima by the front of her hoodie collar, which is what Fatima describes, and Isaiah is trying to pull them apart. And see, there's another example of Isaiah, Ihsan dragging Fatima by the front of her collar, and she is pulling back, and Isaiah is trying to dislodge them. Exhibit 6. You go to Exhibit 7. All he is doing here is, again, trying to get him to let go of his daughter, who he has by the front of her collar, and is throwing her on the ground. That is what Isaiah is doing during the course of this interaction. And now Fatima's down. He's thrown her on the ground. And look at what Isaiah and Ihsan are doing. Isaiah's hands are out. They're out in the, what are you doing, man? What is happening? Oh my gosh. His hands are down by his side and they are out. And what is Ihsan doing? He's grabbing him by the front of the collar, and then bam. And look at Ihsan's face. Does that look like the face of an individual who is protecting themselves? Or does that look like the face of a guy who's real angry? Real angry that this kid had the audacity to interfere with how he has decided he wants to parent his child. I submit to you that's exactly what that face is. That has nothing to do with protecting himself and everything to do with exerting his anger and his power and control over this other child that is present. He's not being attacked, he's being thwarted, and he's being interrupted, and he doesn't like it. It's happening because Ihsan is mad. The force he uses is neither reasonable nor is it moderate in this case. It is not a necessary use of force in either the timing of when it occurred to protect himself, nor is it a necessary amount or reasonable amount of force being used. So now we are at Zahraa Ali, count 2, assault in the second degree. That completes all of Ihsan's charges. We are done with Ihsan. We have hit a milestone. Element 2, pertaining to Zahraa Ali. The on or about October 18th, assaulted Fatima Ali by strangulation. When you look at this element itself, this count itself, you will note that there is only one type. Whereas with Ihsan assault in the second degree, we had 1A and 1B. We have those alternatives. For Zahraa, we only have strangulation. Again, October 18th, state of Washington, none of that changes. Intentionally assaulted, Exhibit 133. She intentionally grabs Fatima at the neck, not an accident. That mom is holding Fatima around the neck at about 2 seconds, grabs it again in 8 seconds, and then those screenshots show that location of her arms, like we talked about before, that she's being pulled backwards. That strangulation for assault too, or that same behaviors, that is separate and apart. You also have that Fatima testifies she can't breathe. You heard Zayla Carter talk about how Fatima is trying to get up and run, and mom is grabbing her by the throat, and Fatima is pushing her away. Mom is not giving aid. Mom is not asking if she's okay. Zayla says she's just trying to grab her, and she's grabbing her by the throat. Athena immediately knows it's wrong, and she says so. Like, what are you doing? Mr. Leary asked her a question about whether it's mom or sister, and you remember you heard Athena go, it was mom. And then she goes, well, now that you're asking me and pointing the video, I'm not sure if I know if that's mom or sister. But she is correct. We know from the video it's Zahraa. Visible standing away from Fatima. So we know that Penny never puts hands on Fatima. As far as the video shows, we know that it's Zahraa the whole time, and Athena is correct. So yeah, the child, again, got confused in terms of the direct examination questionings by Mr. Leary, but you watch the video and you know that she is right. She says, mom grabs her by the throat, and I said, what are you doing? You can't do that, because she just watched it happen. Even Athena, who has no medical training whatsoever, knows that that is not proper, and mom has done that. And she is correct. And then you have the testimony that Zahraa, she's holding on to her by the throat to both keep her from fleeing and to continue those efforts of dad. And Fatima is fighting that as well. There's no indication by anything that we've seen in terms of evidence that somehow Zahraa is below average intelligence or has some sort of eyesight problem. Nothing that interferes with her ability to perceive what everyone else testifies about over and over and over again is clear and obvious, even to Josh Wagner, who after Zahraa is already on scene, right? She knows that her daughter is unconscious. She knows her daughter is injured because they were her arms helping to do it. And she doesn't ask if she's okay. Just let me talk to my daughter. Those are grossly different response. And you saw the video of that. The grossly different response for the arrest of her husband and the strangulation of her child. And let's be clear, the state's not saying that there is some sort of anticipated, expected response, that everybody's response to an emotional situation has to be a particular way or it has to be consistent. We know that that differs from person to person. But when we're talking about Zahraa's response for the arrest of her husband compared to the strangulation of her daughter are demonstrated by Zahraa on body cam to be grossly different. And then we have the strangulation, the medical reports, the doctor and nurse testimony. So the physical discipline defense for Zahraa is the same analysis as it was for Ihsan. It is unreasonable to interfere with a child's breathing. That is an inference that you get to make based on that description. Nothing changes about the size, age, and condition of the child. And nothing changes about the location of the injury to Fatima. And that's same special verdict form for assault in the second by Fatima, or for Zahraa on Fatima. Count 4, burglary in the second degree. Burglary in the second degree, occurs when you commit the crime of entering or remaining unlawfully in a building with intent to commit a crime against a person or property therein. That's the definition. Then you have the definition of enter or remains unlawfully. That is again in your instruction packet. You enter or remain unlawfully in or upon premises when you are not then licensed, invited, or otherwise privileged to enter. So enter or remain. Guys, that also means that when somebody has trespassed you from what otherwise would be a public place, that means that you are no longer licensed, invited, or have the otherwise privilege to so enter and remain. Instruction number 44, a person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime or person therein. This inference is not binding, and you decide what weight, if any, to give it. That means the state does not have to also charge underlying offenses and also prove those beyond a reasonable doubt. You get to infer, if you so choose, as to the defendant acting with the intent to commit a crime or against person or property therein. And then there are your elements. October 18th, entering or remaining, state of Washington. This slide probably looks very familiar. Again, it doesn't change. Elements 1 and 3 happens on October 18th, it happens in the state of Washington. Backside of element 1, unlawfully in a building. How do we get to the point where she's unlawfully in that building? You heard the testimony on September 16th, that incident occurs with Isaiah campus. You hear that Celeste Walter corroborate that, and as a result, I trespassed Mrs. Ali from campus and all North Thurston School District property. You heard the testimony of Ms. Waltermeyer and Officer Howard on September 17th. Haneen comes to try and pick Fatima up early from school, and the school says she needs to stay and you need to tell your mom to come have a meeting with us. So later that afternoon, Zahraa returns. She meets with Celeste. She meets with Officer Howard in Celeste's office and is presented with that trespass order and those instructions about the order by Officer Howard. You have further that when Zahraa returns and they serve her with that trespass order and she's given those instructions, Officer Howard offers Zahraa the language line. And you heard what the language line is. The language line is, if you don't understand, the document that's been provided to you is in English. If you don't understand or you're not comfortable with that, we can provide you assistance. Would you like someone who speaks Arabic directly to be on the language line and have this conversation with us? You can choose to take it, you can choose not to take it, that's your choice. Zahraa declines the language line. She does not want the language line. Instead, she asks for Haneen to come assist. So Officer Howard and Celeste say, sure, we'll wait. So in the meantime, they're chit-chatting with her in English about a number of topics. And then Haneen, Zahraa's request, arrives and they go over the order a second time while Haneen is present and assisting. You hear the testimony that she's offered chances to ask questions. She is specifically identified for the places she can and can't go. You can't go to the baseball field. You can't go here. You can't come to the building. You can't come to pick up your daughter. It's fine for Ihsan to come pick up. It's fine for Haneen to come pick up. This only applies to you. You are not allowed to be on the property, period. She has a chance to ask all of those clarifying questions about the parameters. She's given the phone number to call if she has any further questions. Defense counsel said, well, there's nothing on there that says she can appeal that decision, right? There's no requirement. And you're not going to find it in your instructions anywhere. It doesn't exist. She is given a sheet that describes what she is to do. She's been orally advised twice with the interpreter of her choice. She speaks English, to be clear. It may not be her first language, but there are consistent interactions with English. No one's saying that her English is great, but it is certainly enough. You heard Fatima's testimony. They've lived in the United States since Fatima was 6. So we're at 11 years at this point. And Zahraa is able to communicate in English with these women, and she has done so consistently. And that is described. But even with that, she asks for Haneen to come. They wait for Haneen, and they go through all of this. And that phone number is pointed out and identified. Here, if you have further questions, then call this number. And per Ms. Waltermeyer, that never occurs. There's no questions about it. It is a clear, self-explanatory order that is accompanied by oral explanation. And then you have that trespass letter itself at Exhibit 121. Then on October 18th, she violates that order. She enters or remains unlawfully in a building because she is not allowed to be in that building. You have that she arrives on campus where she's already expressly been told not to be. She understands that. Moreover, Haneen, the person that
I've been here, I just didn't push the button. Thank you, guys.
had that conversation while she was present is with her. So Haneen knows as well. She's not there by herself. Then when Fatima escapes from the stranglehold, she chases her into the main office inside the school building where she is not allowed to be. She not only goes into the building, she goes into the office and tries to continue to go through the back. And you heard Tracy Arnold say, I had closed those doors and I was using my weight to try and hold those doors closed because I could still hear her and Denise Kinley yelling back and forth. She then leaves, and you see her in the video try and go through the side doors, and Principal Dean cuts her off. Got that intent to commit a crime. The entering or remaining is with intent to commit a crime against a person or property therein. She knows husband of just strangled is in there. She has demonstrated at this point her ability to physically assault a child. She knows Isaiah. She chased them. She ran after them. And we've heard it over and over again. In her story, there's no evidence to support that whatsoever. If anything, Isaiah is a kid in the story that everybody would, I think, like to have as their kid. He is kind. He is respectful. He is there to help out friends and look for danger to people that he knows are particularly vulnerable. And he demonstrates that on the stand. But she blames him and his family for everything. I submit to you, you heard from Victor Barnes. Victor is Isaiah's.
Sharia law is basically it's their laws that they live by, but they have tried to get the U.S. government, no, we're not going political, but they have tried to get the U.S. government to accept Sharia law within the Constitution and laws of the United States. And my understanding, and I could be wrong, that under Sharia law, even then, honor redrum is not really permitted, but it is tolerated, I guess is the best way I can say it. So in a Sharia law, they are very well could be justified. It's their laws that they follow, and they think that Sharia law should follow them no matter where they are. And no matter what country they are in, they believe that that law is the only law that they should have to follow. That's what you get for thinking.
Listen, we tried to engage. We tried to have a reasonable conversation. We tried to be respectful about what the parents wanted, what Ihsan expressed he wanted. And so we said, you guys can't see each other. You need to take a break, right? And he was not like over dramatic by any means. He said, I understand that parenting is hard, right? Everybody agrees that parenting is hard. I think everyone would agree that parenting teenagers is not for the faint of heart. It is difficult for sure. And we've talked about that at length. But this goes well beyond that. And Victor says, I understand it's difficult, but you know what? They're teenagers and they're in love, or they think they're in love at least. What are you going to do, right? So we put some boundaries on it. We put some guidelines on it, and it didn't pan out. And this was the response. And for Zahraa, that is all Isaiah's fault. That is his fault, his fault, his fault. And so what is she doing? She knows there's a no contact provision. So what is she doing when she goes in there and chasing him in? She knows she's violating that order, and she intends to violate that order. She knows she has that with Isaiah. She has to stay 1,000 feet away, and she knows that he is in there because she watched him go into that building. The intent to commit a crime against a person or property therein. Again, I don't have to prove, you don't have to find what crime the defendant acted with the intent to commit therein. That's not in your instructions, and you're not going to find it because it doesn't exist. It could be any number of them. A further assault of Fatima, an assault of Isaiah, a further violation of the no contact order with Isaiah. You must only determine that the entry or remaining within the building was with the intent to commit a crime. but you need not actually identify that that crime has occurred. So there we know she's going in the building because she's actually in the building, right? Exhibit 110, page 6. We know she's in the office itself because there she is, bottom heading towards those back doors. There's Tracy Arnold, exhibit 111, page 9, running through to try and get in front of her because, as she said, when she closed those glass doors at the front of the office, main office, Mrs. Ali goes around her. And there she is yelling at Miss Kinley and arguing. Page 11. And still arguing with Paul Dean in front of that campus expectation sign. We know she's not allowed to be. Now, mind you, the burglary doesn't happen until she enters a building. The burglary itself is not for simply being in the parking lot or on the property. The burglary happens, in this case, when she enters the building, because that is the definition. Okay, so just make sure you make that distinction. Last crime, we're almost there. Count 5, violation of that no contact order with Isaiah Williams. So violation of the court order, you commit the crime of violation of a court order when you knowingly know of the existence of the order and you knowingly violate one of the provisions that's identified within that order. And you have, again, that element instruction in your packet. 4 elements altogether. We're going to go through those elements with the evidence that you've seen for each of those elements. 1 and 4, seen this, same instruction, right? Don't anticipate argument or significant argument, but you still have to find that the state proved it, and you have to find the state proved it for each count that exists, okay? So the court, here's the order, Exhibit 36, page 1 that you have. You have the court that has issued that order. Let me go back up for 1 second. There existed a protection order. So let's look at the back half of element 1, existed a protection order. Exhibit 36, page 1, you have the court that has issued that order, Superior Court of Washington, Thurston County. You have the protected person or the petitioner, Isaiah Williams. Isaiah is 16, so as a parent, I have to petition on his behalf to protect him. You have Zahraa as the respondent. You have the effective date until October 24th at 9 a.m. And then you have this order restrains and then Zahraa Ali. So clearly identified as the restrained party. It's not an overly complicated order to read. Then you have section 3 on page 2. Protected minor is listed on section 3. There's your section 3 when you're looking for it right there underneath the red dot. And that order protects Isaiah Williams. Page 4, here are all of your provisions that she is restrained from doing and clearly outlined. No harm to Isaiah. And the minor listed in section 3 above. No contact with Isaiah. Clear through a third person. No stalking of Isaiah. Passing, following, monitoring of Isaiah. You have the exclude and stay away by 1,000 feet from Isaiah. His school, himself directly there under D, element D. And then stay 1,000 feet away from the listed residents, and they put in their own listed residents specifically because by that point they know, mom and dad already know where they live because they've shown up at the house, and you've heard Victor talk about that, right? That he tried to reason with them, he tried to talk to them, he tried to avoid this, and he was unable to do so based on the way events had been unfolding because they showed up at his house. So the elements that the defendant knew of the existence of this order, you have Officer Hang's testimony that he serves that order on October 16th. Remember that it is issued, let's go back. It's issued October 14th. That's when the order is issued. 2 days later, Officer Hang serves that order. Exhibit 37, you have that proof of service that Hang files with the court. And then you have Exhibit 38, the body camera of that service. He serves it on Zahraa at her home. You watch that. You see that Haneen is with her at the time of the service. Again, at her request, Haneen says, "Can I stay? I help my mom." Yeah, sure. The two women are communicating with each other back and forth about that order as Hang is describing it. Zahraa asks questions about it herself in English of Officer Hang. Haneen also asks clarifying questions. You know they understand that Mrs. Ali, Zahraa Ali, understands what that order is because she demonstrates that. He, in fact, points out the number to call in the document if she has further questions. He explains it to her in basic terms. He doesn't use overly complicated terms. And it's not a complicated document or set of directives to comply with or understand how to comply with. Moreover, you see her ask that clarifying question. Wait, so if this means I can't contact him, does this mean he can't come to my house either? She understands what the limitations of that order are. Does that mean that if I'm here and he comes to my house, then he gets in trouble too? Well, what does Officer Hang say is, well, if he comes to your house, like you have a right to be in your home, you can call law enforcement if that's the case, right? We know she understands the order. She asks that clarifying question. She provides alternative situations and is trying to decide how that order, those alternative situations fit into this order. So we know she understands what the limitations of that order is. And she has, again, her chosen interpreter present with her, and she's communicating with her throughout. She doesn't demonstrate at any point that she doesn't understand how she is personally restrained or demonstrate confusion about how she is personally restrained. And then you have element 3, the defendant knowingly violated that restraint provision, prohibiting contact, excluding the defendant from a school, prohibiting the defendant from knowingly coming within a specified distance of the location. So on October 18th, about 2:13 p.m., she's certainly within 1,000 feet of Isaiah. She's physically engaged with Isaiah, and she chases him and her daughter into Timberline High School, certainly within 1,000 feet. And then you have it again at 2:13. She's in 1,000 feet of his school grounds itself. So there's 2 separate provisions that she has violated. And then she knows exactly confusion about who Isaiah says his name. She tells Hang and Bell and Chavez, you see that in their body cameras. He goes to school here. She knows where Isaiah goes to school. He's a student here. Hanina just said, Isaiah James Williams. He's a student here, I'm pointing, right? She knows exactly who is protected by that order. There's no confusion. She knows exactly where his school is. There is no confusion. She knows she's violating that provision of that order. She just doesn't care because it doesn't matter to her. She doesn't care. There's exhibit 134. There's Isaiah, where everybody starts running. There's exhibit 108, page 2. There's Fatima and Isaiah, Zahraa right behind with Haneen behind her, certainly within 1,000 feet there, certainly on the school grounds, while Isaiah. Page 109, again, you have them running, and I believe that's at 2:20 of that video, of the 2-minute and 55-second video. Again, you see Fatima and Isaiah. And at 2:41, 21 seconds later, you have Zahraa chasing after them. She's about 20 seconds behind them in her run, and certainly within 1,000 feet of Isaiah. So that is it. At the conclusion of all of your deliberation, I'm going to ask you to return verdicts of guilty on each of the charge counts and findings of yes for each of the special verdict forms for Ihsan and Zahraa Ali as the state has charged them. Thank you.
Members of the jury, at this time, the bailiffs will lead you back to
It's
the
lunch
jury
break.
room. We anticipate a 30-minute break, but if you are not done eating lunch after 30 minutes, you tell the bailiff that, and we'll have a longer break. When we return, we will start with the closing arguments by Mr. Kading on behalf of Mr. Ali. Thank you for your time and attention. We're still just in this process. When you go back, all you're doing is eating lunch. All of my instructions as it relates to not discussing this case, not seeking out information, the like, that continues to apply. Thank you for your time and attention.
Well. What a closing argument. Kind of boring. Not my favorite closing arguments, as you could tell. It didn't keep my attention very well. But I get it. It is what it is.
We'll be in recess for 30 minutes.
So they'll be in recess for about 30 minutes. Not surprised. I may regret doing what I'm doing. I am going to be, how do I put this for you guys? In August, I have to go to some training. That's not what I needed to do. And I am required to wear a cowboy hat. It is a part of our uniform. But you know me, I'm not going to wear just any old cowboy hat, right? You know that, right? So this is a George Strait Stetson, and I thought I'd do a thin bead around it, but I ain't liking it, so I'm going to have to just stop, and I'm just going to have to cut this loose and do do what I call a thick standard line around it. I don't like it. I think it's going to be too big, but it's not. This is not my cup of tea. It's not looking the way I need it to, so I'm going to reconvene it. Start it all over again. And use a lot more beads, and I hate to say bigger beads, but I'm going to have to do bigger beads because these things are way too tiny. Way too tiny. They're minuscule. They're seed beads on crack, seed beads. So I'm going to have to go get me the other beads and do those. So anyway, what are y'all's thoughts on the closing arguments? Right now, I'm really neutral. Nothing I've heard has got me thinking either to change my opinion, to second guess my opinion at this point. So what I'm going to do is just give me a second to pick up these little beads. That's how little these beads are. You can almost not see them. I mean, counting these beads I just like, oh, I love the size, but not for this project. Definitely not something I want to do for this project. I do know, Aaron, your hat has been ordered. I've ordered your hats. I'm waiting for them to arrive. And as soon as your hats arrive, I will get to working on them. I do sell these hats, as y'all have seen. That's 5, 6, 7, that tiny. They look like little ants. I wanted to have a real dainty, but I'm just going to have to go ahead and get the bigger beads. This just ain't going to cut it. Angela! Woo-hoo! We finally get to see you, my dear. I have missed you, my dear. Where have you been, my dear? All right, I'm going to go get that. Then we're going to go do some court review. I'll be right back. Okie dokie, guys. Had to go to ladies' room while I was out there. So, and I don't have my black. I don't want to do black. I guess I'm going to have to. So I'll go get those in a minute. So let's go ahead and dive into court real quick and get into what we were talking about before we went into the jury verdict. I mean, the not verdict, the closing arguments. So yes, please like and leave your DNA. Thank you, everybody, for clicking the thumbs up after you have liked. On behalf of Washington, I'm having teriyaki for lunch. Congratulations on the teriyaki. Hello, Chadwick. I'm having mushroom chicken for lunch. Bring on the chopsticks. I wish. I think I'm going to do Chinese tonight. You got me hungry. I'm finally home. We are in verdict watch yet? No. We're getting ready to go into both of the defense's closing arguments, and then we will go back to the rebuttal closing argument of the prosecution. I can't wait till after the first one. I have money so I can send you my hats. Yes, I look forward to beating that. Oh, now the seed beads that I was using, let me give you an idea. Yeah, give you an idea of the difference in sizes. We'll do this. The ones that I use are super small to begin with, but then we have something called micro. So this is the bead that I've used on most of my hats. Okay, I have two beads here. The one on this end is perfectly uniformed. It's square cut on each side. And this one is like a micro seed. It's a size, it's smaller. It's as small as, if not smaller than, a mustard seed, depending on where you're getting the mustard seed from. But they are little, and they are painful. I will tell you, it is painful. Okay, that goes with that one. So yeah, not fun. I was doing some touristy stuff today. Yay! And visited the second happiest store in the world. First is Disney store. Second is Lego, of course. Yes, I like both. I don't think the closing kept the jury's attention. I was not impressed at all. Yeah, no. I felt the same, She-Wolf. No, not impressed. I thought there was a lot of, I think she could have moved through that a whole lot quicker. I think she's a little overwhelmed for having two defense attorneys going against her. That is quite overwhelming. No, they didn't need 85% of it. I just hope the parents are found guilty. Yeah, Angela, I don't mind saying I do not miss Legos in my house one bit. Raising three boys, I'm so glad Legos are gone. Just say it. Now, I have a Lego set that my daughter bought me. It's a floral thing, and I don't mind Legos. I just have, stepped on way too many of them. Sorry. It's Legos or it's the little beads from the girls. Not little big beads for me, but you know what I mean. Tinkertude, I had a mission today to find out when a possible set is coming out. And when it comes out, I'll be the first in line to buy it for myself. Okay, I got to know what it is. Angela, I bought my son the $2,000 Lego ship thing. He got it half built. I didn't pay $2,000. Don't worry. Yeah, if my son doesn't get to building on that thing, I might just have to do it myself. I might have to just do it myself. Okay, I want to share this with you guys. We have breaking news. I don't want the sound of the commercial. I already have to share because of all everybody else's crap. I hate that.
Authorities say there has been a shooting at the Grand Sierra Resort and Casino.
Police are urging the public to stay away while they respond to what they're calling a critical incident. The Washoe County Sheriff's Department says police were involved in the shooting, but provided no further details. Police have not said how many people might have been injured. We will let you know more as soon as we get that information.
Wow, that was a whole lot of nothing. That was a whole lot of nothing, y'all. Oh, stop. What happened to my trial? Go find it. Okay, so one of the things also is the depth. Oh, y'all, I didn't realize we had Delphi coming up. My bad. I'm kind of on the fence about that trial personally. All right, I want to go back to what I was sharing with you guys. Didn't mean to do that. I want to go back to what I was sharing with you guys earlier about the different levels of, there we go, about the different levels. And I think I'm going to try and get in big in this. Let's see what it looks like if I share this. Let's look like, I don't know if you can see that. Let me see if I can enlarge it. I can. Okay. So these are the charges. I'm going to have to do it this way, guys, because I can't read it otherwise. Give me a second to organize this. This is just irritating me to no end. There we go. That makes it mo better. Okay, the culture, I got to get down to what I want. Okay, right here. The charges for for Ihsan Ali is attempted redrum in second degree. It is a class A felony. It can be life sentence with the possibility, I think, of $200,000 up to $200,000 in fine. 50,000 life with 50,000 up to 50,000 in fines. So he can get that. Attempted kidnapping first and second degree, that is life and 20. Class A, Class B felonies. I just saw something about it. I don't think it's on again. I just saw something that just popped up, and it's my rabbit trail, my neurodivergent brain. Assault, second degree domestic violence, a Class B. That is, again, up to 20 years. Assault, 4 degree, gross misdemeanor. That is, I think, it's a year and just 364 days in prison for him. So he gets life as it is by itself up here, the class felony. Okay. I'm going to embiggen this a little more for y'all. Let me see what I can do. Make it easier. I got too many windows open. I need one more monitor. I keep saying that. Let me see if I can embiggen this for you guys. Okay, there we go. So attempted redrum second degree is a Class A felony, which can include up to life. Attempted kidnapping is up to life, plus it could also be 20 years for Class B. So first and second degree. So that's 2 life. I mean, he's not going to get found of all these, but assault second degree domestic violence Class B, that's up to 20 years and up to a year for the 4th assault. Yep. The state just finished their first part of closing. They're going to come back. That's just the first half. Then Zahraa Ali gets attempted redrum second degree Class A felony, attempted kidnapping first and second degree, same as her husband. She gets assault Class B felony, same as her husband. But she also gets a burglary in 2nd degree. He does not. He gets the assault in 4th degree. She gets not only the burglary in 2nd degree, but violation of protective order. So this is the notes on that. Attempted redrum 2nd degree. The lesser is assault in 2nd degree based on intent and injury level. Assault in the 2nd degree, assault in the 4th degree, judge allows the based on the case law and video evidence. Attempted kidnapping 1st degree, unlawful pursuant, DV enhancement, domestic violence. The state added the DV notice post evidence presentation. The burglary 2nd degree, criminal trespass considered due to Zahra's prior no trespassing servant on the school. Yeah. So that is where that is. So now y'all kind of have an understanding, I hope, a little bit of the charges. Let me get down here. Let me get back down to normal level. So what does all this mean? Well, they can get a lot of years. If Ihsan Ali is found guilty of the attempted redrum 2nd degree with the enhancements, he can be gone for life. Let me try, because just because it's bigger for you doesn't mean it's bigger for me. So let me try it. Okay, give me a sec. But see, once that happens, this thing shows up. Give me a second. I'm looking for it. Got to edit. Is that what you want, Ronnie? Is that what you're wanting, Ronnie? Let me know. So that's that. Sorry, so I'll do it again so that way everybody can read it. Let me go back up to the... There we go. Is that better, babe? So he's getting Class A, B, okay, and gross misdemeanor. Let me scroll. I wanted to look at the differences between the different levels of, here's what I wanted to see. So a Class A felony is attempted redrum. It has a life imprisonment with up to a $50,000 fine, requires intent and caused death. Class A felony, why do we have... Okay, but then we have a Class A felony attempted kidnapping with an enhanced of involving a DV or a minor. Then we have a Class B felony, which is up to 10 years, $20,000, including strangulation and substantial injury. Class B felony, they have up to 10 years, $20,000 fine involving unlawful entry into a non-residential area. The Class C felony, up to 5 years, $10,000 fine using as a lesser in kidnapping case. Gross misdemeanor, up to 364 days in a year, for basically a year. $5,000 fine, covers unwanted physical contact. Gross misdemeanors are 364 days a year, $5,000 fine, common enhancement in the DV cases. All right. Does that help? Did that help? Now get me back over here. Nope, it's okay. Angela, what are your thoughts? You've been following the case? Okay, I wanted to get to so one of the strategic, let me get this in front of me so I can read it. One of the strategic implication is that the defense is pushing for a lesser charge to argue the lack of premeditated and intent. That is pretty much this entire defense's case. The entire defense's case right there. Believe it or not, that's what they're arguing. That's what they're arguing. I don't get it, but that's what they's arguing. You know, at one point they argued that it was self-defense. I don't see how that is. When he threw the first punch and hit the boyfriend and knocked him cuckoo, prosecution's maintaining that the severity of the attack and motive honor-based violence warranted the full charges. Well, they're not saying Honor Redrum because she's still alive. And the judges permitted the amendments and lesser instructions despite the defense's objections, citing sufficient evidence. So we were talking about the legal approaches. We've talked about that. So under the common legal challenges, cultural differences, some defendants argue cultural norms justify or mitigate their actions. Courts may vary in response. I don't believe that crap. I don't care what your culture is. It does not mean that you have the right to unalive somebody as a cultural belief. I mean, you can't travel to a country and expect another country to abide by your old country's laws just because you're here. And that is something that that's basically what Sharia law is, that they're carrying their law with them and they want Sharia law here. Remember a few years ago, Sharia law, there was a huge movement in the Sharia law. Let me see. I remember this huge movement. In fact, there was a county in Texas that accepted the Sharia law, but that area was a very strong Islamic or whatever culture. The United States Sharia law system of Islamic moral and religious guidance is not recognized as a legal framework and does not override or replace the American law. Sharia law means a path to water. Sharia. Path to water in Arabic, and refers to the divine guidance derived from the Quran and Sunnah, the teachings of Prophet Muhammad. It encompasses personal religious practices like prayer and fasting, ethical behavior, and guidance on social manners such as marriage, inheritance, and business dealings. The interpretation of the Sharia law is called fiqh, F-I-Q-H, fiqh. I don't know, which varies among scholars and communities, making it flexible and adaptable across cultures. Sharia is in practice in the United States. Muslims in the U.S. follow Sharia law in a personal and religious matter, similar to how the Jews follow their laws, and Catholic follows the canon laws. But the examples including religious marriages, contracts, dietary laws, and voluntary meditation in family or business disputes. So if they have a family dispute, they can take it to the Sharia law and they can agree to go by that law. But that is so long as it does not go against the American law. Hello, Carrie B61. They are taught to lie. These practices are private and voluntary and must comply with the U.S. laws. Well, that's bull. They don't. They can agree to accept the judgment of the Sharia law, even if in an American court it would not have turned out in the same fashion. I don't agree with that. It should comply with the United States law, but it doesn't. For instance, polygamy is prohibited under civil law, so Muslims must follow monogamy. Not really. Go to Utah. Just kidding. I can't. I don't know what you just put, Carrie B61. I'm dyslexic as hell, and I have no idea what that is. Not your fault. But that's a poor. That's I don't know. I guess that is a good description. But they still get away with it. They marry one and live with 100. No U.S. community is governed by Sharia law. Any attempts to enforce a religious law over a civil law would conflict with the Constitution. Religious tribunals used by Muslims, Jews, and Christians. I don't know. Christians use tribunals? I haven't heard that. Can mediate disputes of both parties agreed, but their decisions cannot violate public policy or the constitutional rights. Well, if everybody wishes to follow that decision, even if it contradicts the U.S. law, it's going to be hard to fight it. Courts will not enforce religious rulings. Well, that's true. So if they come up with a Sharia law ruling and somebody violates that ruling and they want to escalate it to the civil court, the U.S. criminal court or U.S. civil courts, it will not be enforced, especially like in areas such as child custody or criminal justice. Yep, men are allowed. Yep, they are allowed to have all of that. Anti-Sharia law legislation. I remember this. 2010, over 40 states introduced a bill to block the use of Sharia or other foreign laws in court decisions. That is the one I was talking about. That's the one that I remember when everything got real heated and all of these states were putting that into the state laws and Sharia law, and there was a lot of conflict. These laws are often vague and may unintentionally affect the international legal matters or religious freedoms. Critics argue that such legislation may violate the First Amendment and higher legal proceedings involving foreign contracts and international family law. Screw that. I know that there are certain laws that we have with other countries under the international laws and stuff, but I'm gonna say, okay, Texas law says that I can go out and drink all I want and carry a gun in any bar I want to go to. Texas law, but I can't do it in the U.S., nor can I go to another country and do it. But it's a Texas law, so we's going to do it. No. Hello, Luca. Is that what that is? Lou from California or Luca? Greetings from Germany. Court in a short break. Yes, they are in a 30-minute lunch break. I've zoomed a little bit. Let me look at the time. If they haven't finished eating, the judge was going to let them go longer. They've been in a break for 36 minutes. So we should be back soon. So that is a little glimpse into Sharia law. I'm dead set against anybody coming into our country and expecting to carry laws from another country into this country. I am not against anybody coming into this country legally. I think just like we should go to other countries legally, but I can't go over to Dubai and expect the courts in Dubai to honor the courts in the laws of the United States in Dubai. It ain't going to happen. So why are we being forced, or people trying to force us, i.e. the Americans, to accept the Sharia law and allow honor unaliving? So I do know that some cultures and some countries if there is an honor unaliving, it's frowned upon, but they get a lesser verdict than if it was a regular red drumming. So that be where it is. Okay, guys, if you have liked and given us a thumbs up, please give us a thumbs up. If you've liked and given us a thumbs up, comment I liked in the comments to be entered into a drawing at the end of the day for a chance to be in our giveaway at the end of the month, which is coming up really soon. And I know we got a lot of first timers here. Hit the subscribe button, then say I sub, just the way you see it over there, and you will be entered into a drawing. You get extra entries. And then I shared is when you shared the video, and I see that you shared the video because I do check. But I shared, and you can be in the drawing for an additional entry for the end of the month giveaway. So, Papa, I love it. I love it. Oh, my bods are hitting me. Hi, Nick. Welcome aboard, Nick. Hey, Nick, I want to do a show with you, boo. We got hook up. Put you on the spot, but you don't have to answer. Nick, Mireille, thank you so much for rating our fabulous channel. I want to give a shout out to my two fabulous mods, Ronnie and June, and we are, just so we got some people. I do need to put this up and remind y'all, we are looking for new mods, and we would love to have you. You visited Bangladesh? Or no? What is that? Bal insignia? Hey. I know. Slightly buzzed from Friday Law Show. Friday. Yeah. I've watched your videos. I really enjoy them. Thank you so much. I have subscribed to your channel, so I get your I get your notifications. I love your channel. Ronnie, is there any way that we can put Nick or June, whomever, Nick's link up in here so people can go check him out? Yep. I know I haven't had it in ages either. Oh my gosh, what new law in Sweden? Somebody fill me in. Welcome, Raiders. We thank you. We love you. We appreciate you. I'll do this again because there's Raiders. If you share the video, put I shared, and you get in a drawing for a merch store shopping spree at the end of the month. If you sub, put I subbed, and you will get into a merch shopping spree at the end of the month. And then I liked, you will get in more drawings. And I draw for entries at the end of every show. And those winners get to be in the end of the month drawing. Oh, really? What do you think about that? It's okay for them to insult me, but I can't insult them. Yeah, I know. I've been watching that. Nick and Vikings, thank you so much for joining. Okay, we're getting ready to go into the closing arguments on probably Mr. Ali first. We call him Ali Baba because Baba is father in their language, and his last name is Ali. So we call him Ali Baba. Mr. Ali Baba would probably go first, and then his wife. And then we still have the rebuttal of the prosecution. And let me tell you, that was one of the most boring closing arguments I've ever heard in my life. Oh, so we talking like cray prices, like $1,000 prices in American, or are we talking like crazy good prices, like $10 prices? Oh, warm and buttery. You're making, girl. I don't have any popcorn in the house. You're making me mad. You're gonna have to share with me, boo. Yes, y'all go please and check out our friend's channel, Nick's channel. Yes. I knew it. Mr. Ali was going to go first. We'll see. And of course, okay. Okay, guys, I'm going to tell you this before anybody says anything. Everybody who's just joining me, the court volume is so low that I have the same Rodecaster Pro as Emily D. Baker and Recovery Addict, and I have gained everything to the max. Normally, this will be blowing your eardrums, but this is all you're going to get. I've done the best I can. So if it's, you're going to have to try and crank it up on your end. Yes. Thank you. Oh, Mr. Ali was never unconscious and prostrate on the ground. For those who were joining, they don't show the video in court, but we have seen it outside of court. And Mr. Ali had the shite beat out of him because he wouldn't let go of his daughter. He was strangling her by a bunch of kids and bystanders. He never passed out. And they finally got her free of him. And another bystander rolled him over and put one arm behind the back and restrained him until the police arrived. He never lost consciousness. I'm already arguing the defense. Is anybody else having a sound issue? Because I have all my sound turned up. Sinead Graham, I have explained to everybody that I've had to turn this up 100% gained. I cannot gain it anymore. It's the sound of them. We have no sound in court. I will refresh my page. How's that? Did that fix it? Mods, do we have sound at all? Hold on. Hold on. Hold on. I don't know what's going on. You have me, but not the court. Okay, give me a minute. Give me a minute. I don't know what's going on. Why can you hear me, but not the court? Okay, guys, I'm going to do something. Please don't go anywhere. I'm going to pop out. I'm going to close this down and open it up again. I'm going to stop sharing. Let me try another video. Let me pull another video, just something off of my YouTube, and see if you can hear that. It may be something coming from their end, but I won't know until I pull a video and play it for you. So let's play my video from you. Can you hear? Grab a cup of Java and let's dive in. Can you hear that? Can you hear that? All right, I haven't touched myself. I'm down as low as I can go. Okay, so that's on there, and give me a second, and I'm going to delete that feed. We're going to come back in. I'm going to find another feed. I apologize. Now, my mic is totally at the lowest level it can go. We've had a problem with this entire trial, and it's been a very exhausting and very frustrating experience with this court. We have done everything under the sun to try to rectify this. So I'm closing it down. Can you hear? I'm going to pop it on, see if you can hear.
She gets up, she gathers a few items.
Can you hear that?
Before anyone else is awake. We know that she's hiding out. She says she goes to
No, it doesn't.
She goes to the bus stop.
Yes, yes, yes.
Hiding out so that her parents won't find her. She says
I'll go back.
She saw her parents.
Okay, guys, I'm going to go back so we don't miss anything. Thank you so much for being patient. That's on their end, not my end. If I had other video played, it was on their end. Awesome. Okay, let's see if they got sound again. We will get going.
Take all of the brilliance that I'm going to put in front of you.
I'm sorry, Mr. Keating, you're
Yes.
going to need to speak up.
I'm sorry.
Thank you.
Do I need to be near a microphone?
Probably, I would think so.
All right. Sorry. Okay. So this is my opportunity to tell you.
Thank you for staying.
This case, obviously, different from what the prosecutor saw. What I'm going to tell you is this case boils down to 53 seconds for Mr. Ali. 53 seconds from when we start the bus video until Mr. Ali is laying prostrate on the ground unconscious. Okay?
Bull crap.
That's the amount of time we're talking about.
He was never unconscious.
What I want to know is, how did we get to those 53 seconds? And what do we know that's been presented here as evidence? I'm going to tell you right away. The first thing is there's two distinct groups in this case. Pretty obvious, right? We have the Ali family, and then we have Fatima's contacts outside the family. All right? Those are the two groups. They don't meet very often. All right? We know, for example, Isaiah was dating Fatima for approximately 10 months per his testimony. We know from Mr. Barnes and we know from Noah that they were in love. That's what we heard. What we didn't hear, though, was that Mr. Ali knew about that prior to at least September 16th. He did not know that Isaiah was his daughter's boyfriend. He did not know she was in a relationship. He had no way of knowing because she hid that from him. We heard from Isaiah, for example. They had clandestine meetings in the park. They didn't interact with each other's families at all. We know that Isaiah's contact with the family consisted of talking to daughter Haneen on one or two occasions, and that was it. We do know that Isaiah and his family was aware that Fatima was not to be dating. But they disregarded that, chose to anyway. In order to do that, they had to keep everything secret. So they're living in a secret world. What else do we know about that? We know that all of the information that came to Isaiah was through Fatima. He didn't have contact with anyone else to find anything out. He didn't have a way to corroborate what she was telling him. She was just taking her at her word as to what was happening, right? The problem is, as we found, Fatima is what we would like to call an unreliable narrator. right? She tells stories. She doesn't always tell the truth, but she's controlling the narrative on the non-Ali family side, which includes not only Isaiah, but his friends and the school. We know that Fatima has contact with them. We know that the family contact with the school is pretty limited. As a matter of fact, after September 16th, family contact with the school was zero until October 18th. Now, we could go into a lot of reasons as to why there was no contact, but it seems pretty clear that when Assistant Principal Walter Meyer decided that Zahraa Ali was no longer allowed at the school, Zahraa Ali took steps to put her daughter in a different school. To North Thurston High School was her choice. Eventually, she got set up in online school. Okay, so where do we get to on October 18th? We have a situation where Mr. Ali is pretty much in the dark. We know from Mr. Barnes that Mr. Ali talked to him on the telephone, apparently, on the 16th of September. Mr. Barnes said he called him, talked to him. We know that Mr. Barnes said that Mr. Ali came to his house the weekend before this incident. And that is what prompted him at that point to go get the restraining order on the 14th, which was Monday. Okay? So that is the contact that they've had as families. There's been no talk about the kids. There's been no talk about this relationship. There's been none of that. Okay? And Mr. Ali knows nothing about Isaiah. He's never met him, never seen him. Okay? So the scene that we have on the 18th is a situation where Fatima has decided that she's going to run away from home. Okay? Why does she want to run away? Because she doesn't want to travel with her mother, her sister, and her two little brothers to Iraq. Now, she's been to Iraq before. She said it was okay, but she said there were times that she didn't feel safe. She goes to school after running away on the 18th and talks to her counselor. Let's back up. We know that she was planning to run away because we know on the 17th she said she set her alarm for 4 a.m. so that she could get up and run away the next morning. She gets up, she gathers a few items, she runs out of the house before anyone else is awake. We know that she's hiding out. She goes to between Walmart and Safeway. She goes to the bus stop. She's going around hiding out so that her parents won't find her. She says at some point she saw her parents driving around looking for her in the morning. We know the parents called the police that day, talked to Dr. Hang. Early morning, he said about 8:30. He talks to them. They say she's missing. We don't know where she is. Now, at that point, he doesn't fill out a runaway report. But what does he do? He goes and checks a couple of things. He goes and checks around Safeway. He goes and checks at Isaiah's house. And apparently, according to him, has Isaiah's mom call the school, I guess to see if Isaiah is there. I don't know. I don't know that they would tell her if Fatima was there. But we know the officer Hang did not follow up with the school himself. Okay? So, we have Fatima going to school. I think it's telling what she does first. She goes to a first period class so she can talk to Isaiah. Isaiah, she says to him that she's running away, tells him the story. He's like, okay. She goes and talks to a counselor. She talks to her former mental health counselor, Liz Robinson, and she's talking about, oh, we need to help you because going to Iraq, you don't feel safe. Now, it's an interesting scenario with Mrs. Robinson because she's able to call law enforcement or CPS if she thinks someone's in immediate danger. But she doesn't do that in this case. And she chooses not to call the Alis at all. She said, well, I have confidentiality. Fatima didn't want me to call. Okay. So the scenario now is
human being.
Fatima's run away. Her parents have no idea where she is. They've called the police. Fatima's at the school. Nobody from the school calls the Ali's to say, your daughter's safe. I mean, I don't suppose they're required to say, we're calling from the school, your daughter's safe. They could just call and say, your daughter's safe. Don't worry about her. They could do it anonymously. Hey, we have your daughter. We're talking to her. But they don't. They choose not to do that. They leave the Ali family in the dark all day. So what do the Ali's do during the day? They talk to the police. They're looking around for her. Apparently, according to Walter Meyer, the other daughter, Nora, who we didn't hear much about, was seen at Timberline that day. Now, we don't know why she was there. She wasn't a student at the time, but we can assume maybe she was looking for her sister. Just putting it out there because she was on the videotape in the school. All right? Now, what's happening during the day? Liz Robinson is coordinating to help Fatima get out of her own house. She's arranging shelter. Now, remember, there's no imminent danger. She's just arranging shelter because Fatima has told her, I don't want to go to Iraq. I don't feel safe. She said it was okay, but I don't feel safe all the time. Now, that's an issue right there. That's a parental decision on where your kids go. If you're going to Iraq, you want to take your child with you, that's your choice. It's not somebody else's choice. It's your choice as a parent. So what Liz has done, excuse me, Mrs. Robinson, what she's done is now she's inserted herself into a family decision. Right?
Ooh, I don't like
She's telling
him.
Fatima, you don't have to go home. You can go to a shelter. I'll help you. And they get it done. Again, nobody's talking to the Ali family. Nobody's telling them what the plan is. They have no idea. So what else happens that day? Well, we know that Isaiah talks to her again, fourth period. We know that after school, Isaiah meets her at the front of the school. She waits for him, and he comes out, and they go to the bus together. Now, at this point, they walk past Mr. Ali's truck. Let's see if I can get that up there. This is exhibit 106, page 3. We can see there, right here in the sidewalk, Mr. Ali's truck. Oh, nice. Mr. Ali's truck is right here. So clearly, they see Mr. Ali. Mr. Ali can see them. Now, interestingly, the time on this photo, if you look down in the corner, it's not the time of day. It's just the time of the extent of the video, 9 minutes, 29 seconds. Okay? If we look then at page 5, the same exhibit, we're going to note now that Mr. Ali has moved his truck from this spot and he's driving over towards the bus stop. Okay? Now, why is this important? It's important because there was a 2-minute delay there. Okay? Mr. Ali did not immediately jump out of his truck and go grab his daughter. We don't know what he did at that point. We do know that a couple of minutes later, his wife and daughter show up at the parking lot. Okay? So, Mr. Ali is not going, obviously, to the parking lot to grab his daughter because he sees her walk by and he doesn't grab her. She goes off to the bus stop where she's talking to other students. And we know Isaiah's talking to other students. He talked to Noah. He's talked to, I forgot his name, but he talks to Noah. We remember Noah. They're in love, man, right? That's Noah. He talks to him and says, be prepared. Be ready. Isaiah himself says, I was ready for anything. Okay? So this is occurring while Mr. Ali is in his truck. He has no idea what's going on. He's never even seen Isaiah before this point, right? In his life, he's never seen him. Mr. Ali drives over to the bus stop to go talk to his daughter. Okay? He talks to his daughter, as we heard from several witnesses in a calm voice. You got to come home. She says, no, I don't want to come home. He goes, come home with me. This goes on, back and forth. She refuses to go. Okay? She's his 17-year-old daughter. She's a reported runaway. He wants her to go home. She doesn't want to go. That's where we are. He reaches out and touches her, grabs her shoulder. That's what we heard. Grabbing her shoulder in this situation is not an assault because, as we saw in one of the instructions, you have the right to control your child, right? Parental discipline. You're coming with.
Because she knew she was going to be forced to marry a 61-year-old perverted male.
Okay.
Probably wife
At that
number
point,
10.
Isaiah interjects himself into what's happening. Okay. What does he do? He says, well, I tried to push him away. Let's take a look and see what we can find here on the video. This is Exhibit 34, the bus video. We can turn that on. And this is the frame from 213 seconds, frame number 6, and they're all individually framed. Now, I just noticed, ironically, if you look right here on the left side where the arrow is on the right side photo, there is Haneen and her mother's car that's just now getting to the school. All right. But let's take a closer look at the view of what's happening at the bus stop as the bus comes into view here.
Mr. Kading, can you indicate which camera view?
Oh yeah, I'm sorry. This is the road view of Exhibit 34 at 2 minutes, 13 seconds, and 14. All right, hang on just a minute here. Let's back up just a little bit. And I've stopped it at 2:13:17. All right, get caught up here on my timeline. Okay, 2:13:17:5 is where we're going to go. And that is going to be 5 frames from here. Now, if we look in this frame right here, we can see Mr. Ali. He's right there. Okay. He's standing there. Some of the other people are standing there watching him. There's been no physical contact yet, but you can see something going up in his eye, in his face there. And what you're going to see is that it's Isaiah's hand pushing him away. All right. So let's watch this slowly in quarter speed from 2:13:17 to 2:13:18. You can now see the hand right there in front of his face. Okay. Now you can see he's walking backwards and he's still got Isaiah trying to hang on to Fatima. And if we stop it right there, this is just after the punch to Isaiah. Now, if we add on to this view, the front door photo, right next to it, you can see, here they are on the right side of the photo. There's a punch here. Now, what you're going to see is you're going to see Isaiah take about 2 steps, and he's going to turn around and he's going to point at Mr. Ali, and he's going to yell to some friends. Okay? And you can see that here in the video. Let's play that. Quarter speed, we'll play it. Watch that video on the right. You can see Isaiah doesn't hit the ground. He doesn't go down. He just stands up and he points right there. And then at that point, he starts running towards Mr. Ali. Okay? Now we're back on the left side. You can see him taking.
You indicate the time that you paused.
Oh, I'm sorry. This is 2:13:25. All right? So let's close this one out. And then we're at 2:13:25, and you can see up here on the right underneath this tree is Caleb, who's going to be coming in here in a second. Now, on the left, we got Mr. Ali, and we've got Fatima, who are kind of been, we can back it up just a little bit. Let me back it up just a hair to 2:13:22, and we play that, and we see Mr. Ali go to get his daughter. Now, remember, his truck is right here now at this point, and he's trying to get her in the truck. At this point, she's still squirming around, and she's standing up, and she's going to the left. Now, right here, he gets attacked, right? We see Isaiah come running in from across the way. And what did Isaiah tell us? He says, well, I was mad at him for hitting me, okay? He's not at that point going in to protect Fatima from anything. He's mad, and he attacks Mr. Ali. Now, we have another photo. This is exhibit 501, if I can just put this on for a moment. Remember 501. This is the photo of the frame where Isaiah has his arm up in the air and he's taking a swing at Mr. Ali, and Fatima's there. Now, what's interesting about this is that he can't really see Fatima from this point. I mean, he's coming in at the same angle as the camera. He says that he's trying to protect her, but really what he's doing is he's taking a swing at Mr. Ali because he's mad at him. Okay, that's what he said. And what he does after this is he pushes him into that tree. Thank you, Madam Clerk. Can you go back to the video? Now I'm going to back up the video here just a hair so we can see a little bit better what's going on. And we're at 2:13:27. Let's back it up just a little bit to 2:13:25.
When we go to break, I'll play it for you.
Okay. And so here's Mr. Ali. He's wrestling with Fatima, but he doesn't have arms around her neck. Okay, that's what we kept hearing people say. He's got his arms around her in a reverse chokehold. No, he doesn't. We can see he's got his elbow up on this side and his hand over on this side. She's squirming around over here. And clearly she's trying to get away from him. Okay? So here comes Isaiah. Boom. Hits him. Caleb comes in.
Can you indicate what time you stopped?
Oh, I'm sorry. This is 2:13:26. Caleb comes in from the right side. Now, he's not pulling anyone away. You can see he's pretty clearly pushing Mr. Ali, or excuse me, he's pushing Isaiah in the back. Mr. Ali here next to the tree, and these are the legs of Fatima over here. Okay? So there was no falling to the ground. This was clearly being tackled to the ground by at least these two people. And I think we're going to see Zayla. All right? You can see him hit the tree, and boom. At this point, everybody's on the ground. And right there, excuse me, I'm going to pause it again, 2:13:29. So we haven't gone very far in the video here. The first thing we see is Isaiah kicking Mr. Ali in the head, right? He's on the ground kicking Mr. Ali in the head. Start it up again. Now, right there, between 2:13:29 and 2:13:30, frame 8, you can see Mr.
So the defense is claiming that Mr. Ali was the victim and that he was. I heard a comment early in trial that leads me to believe this may be something they say. They may not, because they haven't brought it up again. But at one point, he said he was protecting himself and his child from the boyfriend. Hence why he's got her like this on the ground with him. That, I think, is kind of the defense they're going for.
Ali on the ground underneath Caleb's feet here. And if you watch him, after he gets kicked in the head, right there, he kind of curls up at that point. All right? And then additional hitting and kicking is happening very quickly. We're 3 seconds in here. He's getting hit in the head. He's getting kicked in the head. And he's hanging on to Fatima. Now, remember this scenario. We're at the bus stop. Somebody we don't know comes up to us, gets between us and our daughter. This is Isaiah at the time. And he starts putting his hands up in my throat, my neck area, because I'm trying to take my daughter home. Okay? Mr. Ali takes one punch at him to get him away. Doesn't even knock him to the ground. He just kind of gets him off. Then he's heading over to still get his daughter into the car. He's the father. He's the concerned father who hasn't heard anything about where she's been all day. other than here she sits at the bus stop, right? He does not know these people. These people come at him and attack him at that point. He's got his daughter with him. He's trying to control his daughter. She's trying to get away. And so what does he do? He hangs on. Okay? He's hanging on to his daughter. She's in front of him on the ground, and he's got it. He's kind of curled around her, and he's hanging on. Now, the government would have you think that at that point, he's strangling her, and he's intending to kill her. When in fact, what we see is a man laying on the ground who just got kicked in the head, holding on to his daughter. Now, why is that important? Well, because if you remember when we were talking to Dr. Gilbert, I asked her a couple of things about blows to the head, right? I said, well, what about hitting the tree with your head? She said, well, Fatima didn't have anything on her head. And I said, well, what about if you kick somebody in the head? Oh, yeah, that can cause problems. That can cause cerebral edema or concussion. What happens when you get those? Well, your body functions, but you can't control it, right? That's where we're at. We're at a place where a guy is on the ground. He's being attacked. He's being punched. He's being kicked in the head while he has his daughter. Apparently, while that's happening in these few seconds, he's forming some sort of an intent to strangle her. There's no evidence that was ever put forth that he was intending to strangle her. What we have here is we have a melee, a mob, right? We have chaos going on. And at this point, what happens is they start yelling and screaming at him to let her go. That's what they're screaming, right? I'm going to start the video here at 2:13:34. Let's play it at full speed for the next few seconds. Turn on some audio as well. All right. So let's watch what happens. I don't know where the audio is.
Yeah, I know that problem.
13:38, frame 9. You can see Isaiah is right there pounding on Mr. Ali's head. Up and down, many times. Now, we haven't got to the point yet where Caleb drags Mr. Ali. He doesn't grab his arm and try and pull his arm free. What he does is he just grabs him by the bottom of the coat and yanks it up. You can see Mr. Ali's back come up. He drags him away from the tree. That's where he's going with that. Doesn't drag him very far, but he drags him away from the tree. Let's watch that. I'm going to start at 2:13:38. Right there. Now, he's not grabbing his arms. He's grabbing at his coat. He's grabbing on his back, and he's yanking him across the ground. Meanwhile, Fatima, who allegedly they're trying to protect, is underneath Mr. Ali. Mr. Ali is on his stomach right there. He is on his stomach being dragged by somebody he doesn't know, punched by somebody he doesn't know, across the ground with his daughter with him, and he's hanging on. He doesn't want anyone to snatch his daughter. He wants to hang on to his daughter, right? So watch it again. Keep going from there. Kicking, punching, hitting. Now, at that point, you could see Fatima, and there comes the bus driver, Mr. Denicola. All right, I'm going to stop it now. 2:13:54. We're 40 seconds into this video. That's where we are. Mr. Denicola is there. Now, what he said was that he went there and he stopped the assault, contrary to what Mr. Wagner said. Mr. Wagner said he stopped the assault. And then finally, of course, Isaiah says, no, it was me. I stopped the assault because I knocked him out. That's what he said. Okay. So one of the three of them knocked him out. Now,
They all did.
I don't know Josh Wagner, but I do know this. He ordered the tape on this case, he said, from a public records request 6 months ago. We can assume he watched it. He said he got there before the bus driver. He's not there yet because he didn't get there before the bus driver. Mr. Denicola was there, bending down. Going to start again from 2:13:54. You can see in the background there, Isaiah is still hitting. Now, here we are at 2:14. Okay, this is 2:14:00. This is when Mr. Wagner appears from the left wearing the hunter's cap, And right here, you can see Mrs. Ali, okay? Bent over, Fatima and her father right here is the bus driver who said he was loosening any remaining grip from around Fatima's throat, all right? Now, there was a point, and we've seen it, where Fatima goes limp, okay? What I want to tell you is, you can see at this point, I will give you the exact frame, 214:02.8, she starts moving her feet, okay? So we can assume at that point that whatever has been compressing her throat has been removed. Now, let's assume for a minute that it is
Quit
a
assuming.
arm that's compressing her throat. Seems reasonable, right? We can all agree on that. Whether or not there's a crime, though, requires more than that, okay? There has to be an intent to assault, okay? An intent is not just, oh, well, there's obviously intent because it happened. No. Intent requires purpose, right? You have to be acting to make something happen. I'm going to give you an example, all right? This is one of my favorite intent examples. You're in a basketball game. 2 seconds
Oh,
left.
God, here we go. Sports.
Right? You're down at the other team's offensive end,
Can we get rid of the sports intentions?
and the guy's dribbling. You steal the ball from him. You win the game, right? Enjoy a celebration with a second left. You throw the ball up in the air, right?
Are you having a tinkitude fit? Are you having a tinker fit? You remember the tinker fit in the movie?
It goes through the basket. You lose the game because you threw it up before the clock went, right? You didn't intend it to happen. It certainly happened. There certainly were consequences of it happening because the ball went through the hoop. That doesn't mean you intended for the ball to go through the hoop just because you threw it in the air, right? You didn't have the purpose. Cost you the game. You lost.
Bad example. I know. Give me the cake.
That happens. Accidents happen. Situations happen where you're attacked by a mob and you don't know exactly what's going on. You've got people yelling, people kicking, people hitting you. You're laying there. You don't know what's happening. You're hanging on. You've been kicked in the head. You could have edema, cerebral edema. You could have a concussion. You could have any of these things. Then you say, well, where's the evidence of that? The evidence of that is that when asked, Mr. Ali, 40 minutes after this incident, do you want to see a doctor? He says no. That's the medical that we have on Mr. Ali. There's no way to know what happened at that time because no medical exam was done. They listened to a guy who just clearly been beat about the head and neck area, right? He'd been beat severely. They asked him for his opinion on whether he needs to go to the doctor. Doesn't make any sense.
Even a man who's been hit by a car, laying on the ground and talking to me as a first responder, has the right to tell me I don't want any medical care. Yeah. He has a right to say that. Don't blame the medical profession because he's an idiot.
He's been knocked out. According to Isaiah, he punched him enough times, he broke his hand on his head, and he knocked him out. That's where we are, okay? Now that, let me play the video for just a couple more seconds here. We're at 2:14:02. Let's play it. Until there. You can see at that point, it's kind of hard. I'm sorry, Your Honor. 2:14:08, frame 6. Again, you guys will have all of this in the room. You can take a look at it. If you look right here, you can see that Fatima is laying there next to her father. And at this point, this is the hat right here of Mr. Wagner. And he then sits on Mr. Ali for the remainder. Mr. Ali no longer moves from that point for the next several minutes. Okay? And it's not until Officer Hang comes and arrests him. So that's the end of that video. 2:14:08. That's the 53 seconds that we're talking about.
It is.
That's the amount of time for all of this to happen where Mr. Ali allegedly formed the intent to kill his daughter. That's what they're thinking that he was doing. A man who called the police when his daughter was missing. Not just once, but at least twice. A man who spent the day looking for his daughter. He finds her. He wants to take her home. He has no idea what's going on, except that she ran away that morning. No one has had
Did
to
she
call him
give
to tell
any
him what's
dates?
happening.
I gave them to you already. Look at your text.
He goes, he tries to take her home. He gets attacked by a mob. He's beat about the head and neck area. And allegedly, he has, at that point, informed intent to either A, kill his daughter, which obviously didn't want to do, or B, seriously maim her. Assault 1, no. The question is, did he strangle her with an intent? Did he intend it? Was it intended at all when he's there? Or is it just circumstantial, right? Just because I'm on the ground, I've been tackled, I've been dragged, I've been kicked, I've been punched, I'm hanging on to my daughter. I don't know who these people are trying to take her, but I sure don't want to let her go. Something a father would do. Something a father would want to do, hang on to his child. Now, is it unfortunate that her neck was compressed? Yes, it was. But that is not a crime if you don't intend it. Okay? Now, it probably would have been better in this case if all the witnesses hadn't watched this video before coming to testify, because it's possible some of their testimony could have been contaminated by what they saw, which is different than what they remembered. But it all was the same pretty much, except they still made mistakes, right? They still made mistakes because they didn't want to know what they had done. Now, I want to just talk a little bit more about the witnesses that we heard from. We heard from Dr. Gilbert. She's the one who testified. She said the body's an amazing thing. What she also said, if you're knocked unconscious, it says the body's functioning, but the ability to control it is not there. Okay? If you're hit in the head and you're concussed, you lose your abilities to use your brain. If you don't have the ability to use your brain, you can't form the intent necessary to commit the crimes that the government is alleging, right? They said he did not go to school with a plan to kill his daughter. He did not develop a plan to kill his daughter between when he got out of his truck and when he was tackled to the ground. What he did was develop the intent to hang on, to protect his daughter. They showed nothing else. They showed no evidence of anything. They didn't have him saying, I'm going to do this, I'm going to do that. They had no evidence of anyone hearing him making any threats. They had no evidence of any of that because there wasn't any. No intent. What was in his mind? Did they prove it to you beyond a reasonable doubt? Get into jury instructions beyond a reasonable doubt. Something, a doubt for which there is a reason. Okay? As to any single element of a crime. And in this case, intent. Is there a doubt as to his intent? Yes, there is. How do we know? Because they didn't provide us any evidence. They provided us physical activities that were going on. A mob beating a man getting punched and kicked in the head, a man getting dragged across the ground, a man hanging onto his daughter. And from that, they're trying to have you think, well, intent to kill. If not intent to kill, intent to maim. If not intent to maim, intent to strangle. None of that was proven. None of that was proven in this case. No intent. And let's talk about parental rights, right? You have the right when your daughter is gone, run away, to take her home. That is your parental right. Okay? Grabbing her by the shoulder, taking her home is not against the law. Okay? What happened here, though? Isaiah got himself involved in this. He put himself in the situation and made it physical. He grabbed Mr. Ali. He stuck his hand up in his face. He pulled on Fatima, and he was wrestling with Mr. Ali. Again, Mr. Ali doesn't even know him. Doesn't know who this guy is, doesn't know what his intent is with his daughter, right? Mr. Ali does what? He punches him one time to get him away. He doesn't knock him to the ground. He doesn't knock him out. He hits him. Isaiah literally takes one step back before he turns, points, and yells. Starts running back towards Mr. Ali. He doesn't run to protect Fatima. He runs to get Mr. Ali, the man who just hit him. He's angry. Okay? So the question is, was the punch that Mr. Ali took reasonable? If it's not reasonable, it's not self-defense. But what does he have? He has a guy he doesn't know, grabbing at his throat area, pushing him around, turns around, takes one swing at him, turns around and walks away, right? He doesn't go beat him up. He doesn't pound him into the ground. He doesn't kick him in the head. He punches him once, goes back to what he's doing, which is trying to get his runaway daughter home, okay? Trying to get his runaway daughter home, not a crime, all right? Striking someone when they're interfering with you, getting your daughter, by grabbing at you, you can defend yourself as long as it's reasonable, right? He didn't pull a gun out and shoot Isaiah. That would be unreasonable, right? He got him, he hit him once, he turned around, he went away. That's self-defense, all right? Now,
Y'all are liking the state's closing better against him after we bitched about the state when they ended? Ooh, this guy's not doing so good, is he? I'm anxious. This is the most we've heard from this attorney. This attorney barely said boo in this trial. So this is the first time we're really getting to hear him.
what about some of the other issues that they're bringing in? Again, they become kind of irrelevant. There's no intent to kill. There's no intent to do serious bodily injury. The only injury that they had in this case that lasted was this pneumomediastinum. What did we hear about pneumomediastinum? We heard that usually it just goes away, right? It's air in your cavity. It went away in this case. By 8:30 the next morning, it was not getting worse. She had been monitored, no problems noted. It's over. That is not a serious bodily injury, a great bodily injury. It's none of those things, okay? What you're going to be asked to do is look at these different things, and you're going to have to say, well, did he intend this? Well, I'm saying he didn't intend anything. But if you read it, first of all, for assault one, did he intend great bodily injury? Okay, that's permanent injury. Did you plan on permanently injuring somebody? Did you plan on permanently disfiguring them? Did you cut a finger off, or cut their ear off, or cut their nose off, or something? No. Did you cause a permanent functional issue with one of their organs? Did you pop an eye out? Did you do any of those things? No, you didn't. That's great bodily injury. You're going to notice in your instructions, which are a freight train, I know, assault 2 is different. Assault 2 is substantial bodily injury. That's already significantly less than great bodily injury. That's substantial bodily injury. The definition for substantial bodily injury. Was it something that happened that is somewhat temporary, right? I mean, you could say, I guess, if you intended to strangle someone and cut off their air and blood, you could say, well, that's substantial bodily injury because it temporarily cut off their blood flow, right? It's not great bodily injury because it didn't cause any permanent damage. It didn't have anything that was going to last forever, all right? So part of the issue with the jury instructions is they're quite long. They're quite lengthy for all the different crimes, okay? But the definitions are all there. And so what you have to do is you have to take a look at them and say, okay, of the elements, what did they prove? Did they prove intent on all the assaults and the murder, attempted murder? Did they prove intent? What evidence did we have that we can now find factually that they have proved that beyond a reasonable doubt? They've proved it beyond the point where we have no reason to doubt their evidence. Not a single reason. Okay? doesn't have to be a series of reasons, and it doesn't have to be a series of elements. It has to be one reason for an element not being proved. One reason to give you a doubt. Now, the prosecutor also talked about abiding belief. I like abiding belief as well. Abiding belief doesn't mean it's not proof beyond a reasonable doubt. It means that you are so convinced that that will never change. Okay? You are not going to wake up tomorrow and say, "Oh, you know what? I just thought they didn't prove this, right? Because they failed to do this." An abiding belief means you're going to remember that for the rest of your life. It's never going to change. Okay? You're not going to reconsider in a month. You're not going to reconsider in a year. You're not going to reconsider and say, "Gosh, you know, maybe they didn't prove that." That's a hard standard. That's beyond a reasonable doubt. If you have a reason, if you have a doubt, that's all you need. They have the burden. They've undertaken the burden. And in this case, they did not meet the burden. All right? They didn't meet the burden for attempted murder because they didn't show any intent to kill. They didn't meet the burden for assault, assault 1 because they didn't show the intent necessary to get to assault 1. Okay? They showed a couple of minor injuries. All of those injuries could be associated with an accidental situation, right? I have my arms around you. A guy's dragging me on top of you. I could be strangling you at that point. The other thing is to remember about strangulation is it doesn't take much, right? It doesn't take much to strangle somebody. 4 pounds of pressure is what I heard from Dr. Gilbert. If you stop some sort of a vein, and 11 pounds of pressure if it's an artery, okay? Interestingly, she threw in 6 pounds of pressure for a pistol trigger, right? And much more than that for a soft handshake. Much more than 11 pounds.
Ronnie.
Firm handshake, more than that, but not very much. Think about a handshake. That's how much pressure is more than 11 pounds. It could happen in a situation where you're hanging on to somebody, your hands get up around their neck, and you get dragged across the ground. At that point, after being kicked in the head, you may not realize what you're doing, right? You may not have the ability to know what your body's doing. People are screaming at you. People are kicking you. Up until the very last minute, Isaiah was punching him in the head. Up until the very last minute when Zahraa comes in and pushes Isaiah off. She pushes Isaiah. Isaiah says at that point, he's knocked him out. Mr. Ali's laying on the ground. He's not moving. Everything's over at that point. Okay? He's that close to getting knocked out when all of this is happening. And we don't know at what point he lost his ability to reason and function. Now, I've already touched on a couple of these things. One of the things that
First of all, he doesn't have his earpiece in and he hasn't had it in. And they say they don't understand English. You know damn well they do. Number 2, nothing this lawyer claims can be held in evidence. There was nobody that got on the stand, including the defendant, to say, I passed out. I became unconscious. I had injuries. They put on zero defense. Now you can't hold it against him, but what you can do is say, okay, so I'm listening to this attorney and it sounds like he is basically testifying for the defendant in his closing. That's kind of how I feel right now if I'm just listening as somebody who doesn't know anything about law. If their closing arguments are not part of testimony, then this guy's up a shite creek.
To talk about in instruction 1, I just wanted to mention a couple of things. I'm not going to go through all of them.
He did not go unconscious.
Anyone that has personal interest in the outcome can have bias, okay? Personal interest in this case, essentially everyone involved in this case has a personal interest, right? They all say, well, that's what I saw. Well, did you? Because a lot of what I heard from the testimony.
Oh, good luck, boo. Prayers. Okay. Prayers.
Proof beyond a reasonable doubt, we just talked about briefly. Instruction 12 is the intent instruction. Proof
That's
beyond a
right.
reasonable doubt the objective or purpose of the
100% right.
was to accomplish a result that constitutes a crime. Again, objective or purpose, okay? You have to set out to do something. I can easily imagine a situation where you intend to strangle somebody. They're standing over there, you're mad at them, you go and you grab them around the throat and you strangle them, right? That would be clear intent. There's no mistakes, no accident, no way that you couldn't mean to do what you're doing. That demonstrates intent. We don't have that in this case. I think that the prosecutors already touched on some of the other ones, like recklessly. Again, the degrees of injuries are different. The intent element, mens rea, the mind's thought process is different between assault 1 and assault 2. Okay, so make sure that you read the instructions carefully. And
good luck.
Instruction 25, I made a note. And if you read instruction 25, let me just take a quick look and see what I did here. It says, this is about recklessness, right? A person is reckless or acts recklessly when he or she knows of and disregards substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. Okay? So, was he reckless? Was Mr. Ali reckless? Well, let's talk about the situation. He's on the ground, getting beat and kicked by people he doesn't know. Okay? And at that point,
As to verse to people he does know?
Is that reckless? If you were in the same situation, a reasonable person, and that was going on, what would you be expected to do? Would you be expected to do something different? If you were going to act the same, you're not being reckless, right? Reckless, deviating from what they're doing in the same situation. Gross deviation, okay? Now,
1 hour.
this all comes down to what a parent would do in a similar situation. Your daughter's run away. You don't know what's happening. You see her at the bus stop. You go to talk to her. She tells you she doesn't want to go. She's your child. You have the parental duty to parent, right? That's your duty as a parent. You say, we're coming home. She says, no, I don't want to go. A struggle ensues. And here we are. That's what this case is all about. There's no nefarious intents. There's no intents to hurt anybody badly. There's no intents to kill anybody. There's an intent to take your daughter home. 17-year-old daughter who's run away. We know she's run away before because we know from Mr. Barnes and Corporal Stanford that that's why they were at the house looking for him the weekend before. She'd run away. That's why Officer Hang went to her mother, went to the mother of Isaiah and had her call the school. They're looking for her. They know she's a runaway. So I put to you that the state has not met its heavy burden in this case. They have not shown you proof of intent. And intent is what matters. Okay? Intent is the key. Look back through the evidence. What was the intent? Where did they show you anything in the evidence that you can say factually, there it is? They can't. They can say, oh, well, all of this bad stuff happened, which indicates intent. No, that's not it. We say if it happened accidentally, then clearly it's not a crime. It's not intent. You can't say, oh, well, somebody was injured, so they must have intended it. It's like your basketball guy. He made the basket. He must have intended it. No, he didn't intend it. It was wrong. It was a mistake. Bad things happen without crimes being committed. So remember now, Mr. Leary's going to have an opportunity to talk to you. He's going to talk to you a lot more about what happened after. But at this point, Mr. Ali has not been shown to have committed these crimes. I'm going to ask you to find not guilty of anything. If you do decide to go through on the lesser includeds, do it carefully, okay? Just because you say, well, maybe it wasn't in Assault 1, it must have been an assault 2? No. Intent is still required. Number 3, was there an assault 4? Take a look at it carefully. Did he intend it? Intent goes to all of them. Okay, totally forgot about unlawful imprisonment. I'm going to go back now, sorry. Unlawful imprisonment. Again, you have the ability to control your daughter, right? She's a runaway. He grabs her by the shoulder. That's not unlawful imprisonment. He hangs on to her. That's not unlawful imprisonment. Okay? What's he doing? He's trying to get his daughter into his car so he can take her home. That's it. That's not unlawful imprisonment at all. If it is, a lot of people in trouble. All right?
I hate that. All right. That's so condescending. I hate that. All right.
Leave it at that point and let you hear from Mr. Leary. Thank you very much.
I'm so surprised the judge doesn't do a stretch break.
Thank you.
Thank you.
Members of the jury, we're actually going to take a 10-minute recess at this time. And then when you come back, Mr. Leary will make his closing argument. Again, we are not done with this process. Do not discuss anything during this 10-minute recess, research anything and the like. Thank you.
Damn it. All right. Oh, somebody asked what I'm doing. I am
We'll be in recess for 10 minutes. Thank you.
I'm beating another hat, y'all. This is mine. All right, guys, what do you think? Oh my gosh, I kind of know what you think. That happens all too much. A lot of cases are being taken seriously. The consequences can be very devastating. Ooh, what? Say, I voted even though I'm only hearing the state right now, but she's doing an excellent job. It bored the hell out of me. We had a kid, but that's okay. She's at least more methodical. This guy is. We had a case in the UK. A girl went to the police to report her parents were going to K her. Statements were took exact 6 months later. The police did a welfare check and found deceased in the garden of the parents. Well, that's true. Who are you talking about giving their first appearance? What am I missing? I'm boring too, but frankly, Roy, I just have a trouble hiding Amazon boxes. I run out of the family members to play. Oh, you can always say they're from all your friends and peeps here on my channel. Oh my gosh. Oh my gosh. Kids here are taught in school about how to notify airport security if they're scared to be placed in a metal. Oh, that's a good one. I'd never heard of that. I hope so. True. I'm going to need some logic in a minute. Some katam. All right, give me a second. One of the things that, so the numbers are 85% think that this defense sucks compared to the state. And I get it. Well, hello, Rat Face. Thank you for joining. Thank you so very much. Appreciate you. So, the prosecution's closing arguments. I did take a few notes. Quit doing that for crying out loud. My computer's not obeying me. All right. The prosecution had the intent to kill. The prosecutors emphasized that the attack was premeditated and rooted in a so-called honor unaliving motive after the daughter refused an arranged marriage and ran away. Multiple eyewitnesses testified seeing Ihsan Ali choking the daughter to the point of unconsciousness while Zahraa allegedly assisted. Doctors confirmed signs of strangulation, including air trap near the trachea and visible trauma. The surveillance and cell phone videos were cited in support of the timeline and the severity of the attack. Prosecutors pointed out to the prior threats and no trespass order and Zahraa's violation of the order as evidence of cohesive behavior. Now, the defense, Ihsan Ali's defense, basically argued that there was no intent to unalive, suggested incident was chaotic confrontation and not an attempt of redrum. They questioned whether the injuries were consistent with lethal force. The defense hinted that culture context may have shaped the perception of the parents' actions. They urged jurors to consider inconsistencies in witness accounts and the possibility of misinterpretation. That was my takeaway. That's my takeaway. Everybody's feeling that way, She-Wolf. Everybody. I know my shirt's wrinkled today. I didn't have the energy to iron it. Yeah. This is all pretty dang good, y'all. One thing though that I just really wish this would just move a little faster, but then again. Is that a good thing, Frankie, or a bad thing? I can tell somehow I can tell the Nightbot to calm down a little bit, but it doing its job. Helicopter just flew over where? We have them flying over here now all the time. Well, this is what I have. It's from 1836. It's a kratom based with bright white kratom with lion's mane, shanga mushroom, and cinnamon and nutmeg. And it really does. It gives you a pep of energy with like coffee, but without all the jitters and the highs and the crashes of coffee. And then, let me get it. I just dropped it. You get the benefit of the natural, legal. I dropped it again. Why is it rolling off? Quit rolling off. Natural and legal mushrooms. And I really enjoy this. I mean, just gives me a little more clarity of mind. I really use these a lot when I'm doing my homework. So someone asked me how college was going. I was taking 2 classes. One is kind of like the administrative side to police departments and law enforcement departments. And the other one is human and sex trafficking. So we're getting
Oh, I thank you, Ada.
I'll show this, but I won't say it. These are two of the books I had to use. And the funny thing is I had to buy them and I didn't even crack the book open. Nothing that we used for this class involved either one of these books. However, that said, that's okay, because I am going to do a deep dive into these books and I'm going to use them. Oh, someone wrote in them. I'm going to use them in my thesis for my master's. Sorry, guys. My daughter and I need to go see my adoptive mother, the one that raised me. And while I'm there, I hope to go and crash Carmen Spawn of AJ's house. Now I want to go visit Carmen Spawn of AJ, and they actually live in the same town as my adopted mom. So I'm going to hopefully get to see Carmen while I'm there. I still have her mug, her Starbucks tumbler. She told me to bring it when I came. Really? I think all of these, well, and see what frustrates me is in Kerrville where I live, they don't have live feeds. I wish they did. I'd love a live feed in my court. Well, Ronnie Nightbot did scold Tinkitude because she used all caps. Oh, I got a little box thing set up for them. I do. Let's see if it will get mad at me. Let's see if the Nightbot gets mad at me. By the way, all of the super chats, all of the super stickers, all of that will be going to the relief fund here in Kerrville. We need millions and millions and millions and millions and millions to recover. This one rancher has over 60 acres and 100% of his fence is gone. Now that wouldn't cover them, but we're supporting the disabled people. I need to get 3 more wheelchairs and then I'm done. And then I need to give more, and then we donate money to the fire department that lost everything. So we're helping them replace some of their gear. Well, it didn't bother me. Trying to get it to ding me, and let's see if it works. Let's see. I don't know. Yes. Tinkitude. I don't know why it did it. I did it. Tinkitude, I'm sorry. I'm sorry, Tinkitude. It was me. It's fussing at me. Hi, chat video. Viewing from Australia. Yay. Could you please explain what? Okay. Let me take a breath. Viewing from Australia, can you please explain why the jurors are not allowed to know that the parents had intended to move her overseas or an arranged marriage? Oh, okay. Tori, I'd love to explain. They can't know about the honor redrum or the fact that they had an arranged marriage with a 61-year-old pedophile male. That's what I call him. I probably shouldn't have said that, but I'm 5 hours into this live. it will prejudice them to the point that it wouldn't be a fair trial. Because once people hear those two facts, that's a no bueno. That's a done. You're guilty. That's what they are concerned with and would most likely win in a court of appeals. So, yeah, we don't always agree with those things, but I do understand the legalities of that decision. It's hard. It's hard, but that's the reason why. Thank you for that fabulous question. And thank you guys for watching. And while we're doing this, if you guys are here for the very first time, if you comment I liked after you hit the thumbs up, and if you comment I subbed after you actually subscribe, and if you put I shared after you actually share, you will be entered into a drawing for an end of the month giveaway of a merch shop. You can get something from my merch shop. One thing. At the end of the month, I have a winner, and they get to do a merch shopping spree, basically. So please, please comment, like, subscribe, and share. We are growing, and YouTube took away 43 of my subscribes. So check and make sure that you're still subscribed. They do that every once in a while as an audit to make sure you're not buying bots, because I had a big steep in subscriptions in a short period of time. Hello, Miss Karen. Hello, everybody. Thank you all for joining.
Please be seated. Members of the jury, if you would now please give your full attention to Mr. Leary as he makes a closing argument on behalf of the defendant, Mrs. Ali.
Okay. Ladies and gentlemen of the jury, thank you. In the aftermath of October 18th, 2024, Zahraa Ali, in the parking lot, alone, sitting in her husband's truck, had to think to herself, how did I get here? Just 24 hours before, she's planning a trip to go to Iraq to see her sister. Her daughter, Fatima, told you, Mom can be lonely. It can be hard. She missed her sister. She was worried about me.
I'll be honest, I have testified in many trials. I've been a part of a lot of trials. I've seen a lot of trials in person. And honestly, no emotion, no reaction is what they really want from you, because anything you do, even the no reaction is going to be judged, but anything you do emotionally or reactionary is even going to be more scrutinized. It's either this is who she is and this is how she is, or she's following the orders of her husband and his attorneys and her attorney. I don't know.
School wasn't going well.
Definitely.
I had left Timberline.
Aren't they great? I love my
Or
mods.
not homeschool, online school. Clearly, there was conflict with the choices that she was making. She had previously run away. This was my client's last gasped attempt. I have a 17-year-old daughter. Mere months till she's 18. This is my last chance where I have the ability to parent my daughter, hopefully get her in the right direction.
Right
Go to Iraq,
direction?
bring her sister, bring her brothers, spend time with family, be away from dad, continue with school, and hit the reset button. Little did she know that there was another plan afoot. The alarm that would go off at 4 o'clock in the morning that wouldn't wake up the 6-year-old brother. Her third daughter would quietly go downstairs, sneak out the back door into the dark, with $100 that she had taken from her mom's purse, no job, no cell phone, no place to go. Apparently had never even told her boyfriend what she was going to do. These are the rash decisions that every parent fears. You want to protect your kids from danger, as the prosecutor acknowledged in closing. It's a tough job. It can suck. You worry, you hope, you pray that they do the right thing, and that when mistakes are made, that they're not devastating, that the child can learn from them. And when they emerge into their 20s, into their late 20s, you can look back, laugh and cry, and be grateful that you're still together. I'm reminded of a story in jury selection that I think you were all there for, when the guy's talking about his daughter who ran away on a horse. And I asked him, well, where's she now? Oh, she lives next door. That's what one could hope for. But instead, the night of October 14th, or the late afternoon of October 18th, she's sitting in the car. Despite all of her efforts to track down and protect her daughter, she lost her daughter.
That's not on me. Oh, come on, seriously. There we go. Hey, Tinkachu, go into Discord. Tinkachu, go into our Discord and go to members chat. There's something for you.
Okay. Intercity transit bus, Exhibit 38. So we've heard a lot of descriptions as to where people are, what they're doing. We know definitively, as we piece this together, where my client was at the start of this. What did I say? Sorry, Exhibit 34. Okay. So now hitting play.
Can you
at
the time, please?
Yep, it's hitting play at 2:13:08. And this is just a clip, and we see it stop at 2:13:14, and we see the silver and black or silver and blue Honda Element that we will now know contains Haneen Ali and Zahraa Ali. Now we also know that at the approach of this, that the conflict between, the physical conflict between Mr. Ali and Isaiah Williams has not happened. So when she drives by on Mullen Road, she potentially saw her daughter, her husband, Isaiah, but there had been no physical confrontation at that point. There we go. Plug it on. Plug it in. Okay. Well, here's what I can do. I can talk you through it. Okay, so we see the intercity transit bus. We know that They're approaching. At 2:14, we see the hunt element come in. And we know from what I just showed you and the other exhibits, and you'll be able to watch on your own, is that none of the physical confrontation has occurred. So she has no knowledge as to any physical altercation outside of the bus. There we go. Okay, so we now have seen exhibit 34 up until 2:14. So we know that the bus is passing her in the turn lane at 2:14, and she is then about to turn in behind the bus. How do we know that? We know that from exhibit 114, and that is the parking lot surveillance video that shows the bus on Mullen Road and the arrival of the Honda Element. So there we see it turning in behind the bus. And we will see, or not, when you watch it back, when you're deliberating, you will see her run through the parking lot. And the time it takes to go from when the car turns in, and you can time it up to when the fight occurs, to then running across the parking lot and to when she arrives. Okay, so in terms of this discussion about what other witnesses see and what they describe, none of that is she's privy to. She doesn't see the punch. She doesn't see the punches to her husband, the kicks, at least initially until she arrives. All right, so we're going to try something different.
Something not working, boo?
And we're going to try to go to exhibit 34. And this will just take me a second to load up. So when we talk about what exhibit 34 shows,
This is a good question. I'll answer it. The father paid for his attorney because he has money. The mama doesn't have any money. Mama is considered indigent. She gets a state-provided attorney.
it is something that I anticipate that you're going to spend a considerable amount of time, because fortunately for my client, in 2025, 2024, we have surveillance video, and we're not relying on the testimony of eyewitnesses, because as has been on full display in this case, eyewitness testimony can be all over the map in terms of what people saw, what they perceived, versus what actually happened. When we
Your Honor, may we have a recess for this guy to get his crap in order, please? Your Honor, we need a 10-minute recess for this guy to get his stuff lined up. No, he would not pay for his wife's attorney. You need a cherry pie?
Okay.
Oh
so
my
now
God,
I
that's
have
my
exhibit
favorite.
34 up on the screen. Now, as we work through it, we are all in agreement.
Can you indicate what time you have up there,
Yep.
please? Thanks.
So at 2:13:56, we see Mr. Wagner walking across the street. We know a significant amount of physical activity has occurred in terms of Mr. Ali being punched, the dragging, and the bus driver getting out of the bus and coming to the aid, frankly, of Mr. Ali and his daughter. Now, hitting play. Okay, so now we are at 2:13:59. What we see right here, I don't know why I use technology. Okay, what we see here is we see Mr. Wagner. We see the individual in the beige sweatsuit, okay? Right above his left shoulder, you can see the head of my client. And Zayla Carter, sweatsuit, oh my goodness. We could see Josh Wagner. Now, Your Honor, can we take a 5-minute break?
We can.
Yeah.
Try this
Jury, I'm going to
before.
ask the bailiff to take you back for hopefully just about a 5-minute break.
Yeah, I knew that was coming. Enjoy the evening. Bye, honey. 2800. We love you. Thank you for watching. You're simply the best. Honey, make sure you do the I like and I shared before you leave. Make sure you do it. He has been. Both of the attorneys have been a joke all along. Well, let me get some. I can't stop in the middle of a count. Let me get this done. 4 is 8, and I need 5. I am beating a hat. For those of you who know, I had a hat that I absolutely loved. It was gorgeous hat, and I auctioned it off to raise money for a service dog that I'm not going to get. Yeah, don't get me started. But I thought about sending the woman a bill and say, do you know what? You owe me $1,500. But anyway, there we go. I stopped the bead. I had to tie that line in or I was going to lose all the beads. So for some of those of you who don't know, I sell these hats. And I bead the rim. And I also do baseball caps. Those are reasonably priced. That hat is a $200 George Strait Stetson cowboy hat. $200 hat. Cowboy hats, that's mediocre price. And then it'll cost me another $400 because I'm doing a one pattern repeated. So it's not as hard to do. So that'll be another $400-ish, maybe $500. So the hat will be a $600 hat minimum. So, but anyway, I love them. I also do Native American beadwork. Once again, this indicates a level of disrespect they hold for the families and their culture. So you basically, to bear their children and care for the husband, you're basically nothing but an animal. You're worth less than a cow or a goat. You're there to pop out the kids and service the husband's needs, and that is it. Aww. What is going on? Anybody know why the Nightbot's going off on Frankie Leroy? Maybe you're using too many emojis? I guess I'm going to have to go change the settings. I got to figure that out, but I can't do it while I'm live. Go have the rest of your... Oh, Lucy? Luca? I don't know how to say that. I'll call you Lou. Lou, thank you so much for joining. We greatly appreciate your presence. You're so sweet. Yep, that's Islam for you, sadly. That's probably very true. No, it is true. It is very true, true. So, and it sucks. It does. Go to commands. Why is it not popping up? I want to see my commands. There we go. Timers. I'm changing some of the stuff right now because it's just too much. That's not what I said. 30 minutes. Update. I'm going to change everything. I think they're going too much. Yeah, I'm changing the timing on these because it's a little bit much for some of them. There we go. I've changed some of them. Let's see. Okay, here's our top chatter. Leroy, then June, then Tinkatoo, Penny, and Weird Debbie. Y'all are the top chatters. Awesome, guys. I'm turning off the excess emojis. Okay, I've made some changes, guys, so let's see how all that goes. Let's see if it worked. Hey, they're demonstrating a need for mods. Yes, I am in need. I was just getting ready to go there. You're reading my mind. We are needing mods. I have wonderful mods, but we need more mods. We need more of you. My mods are fabulous. Absolutely the best. And I absolutely love them. But I want to say this. Everybody, thank you so much for your support. We have the Highlanders are our jam here. I have Heidi and Hamish. They're behind me. Hamish is right there. Heidi is right there. I'll put her back in the corner so y'all can see them. Thank you for not being drama llama ding dongs. And also, don't judge. Mind your business. Coffees isn't cheap. No, I'm kidding. And here's one more fun one for you. My brain temporarily closed for more coffee maintenance. We like to have fun around here. So, hello. Thank you for joining us. And one last thing. We have a new intro. I'm going to play it right now just so y'all can see it. Welcome. I'm AdaKay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Yeah, keep your emojis below 5 and watch your caps. Now, I did leave the all caps on because I really can't read them. People who are like me and other commentators who are dyslexic, it is very hard to read all caps. I don't mind using all caps in a word, like there are no reasons for this. That's fine. But it's okay to cap a word if it's important or necessary. You like the coffee one? I know. And look at her.
Hopefully.
It's been working while you were gone.
Okay.
Thank you. I thought it was time for a refresh. So we'll see how this works. We'll see. We shall see. I'm going back to look at timers. Okay, so let's see if the bot slows down just a little bit.
Please be seated. All right, Mr. Larry, you may continue.
Thank you for your patience. Thank you for being here. You might be surprised I am somewhat averse to using technology, and this only confirms that. Okay, so if we can have the screen. Did work in your absence. Okay. All right. So we
Hi,
have
Renee. Thank you for joining.
at 13:57, zoomed in, and we see Josh Wagner, his truck crossing the bike lane white stripe. And you will see my client emerge from screen right by the tree. And I'm going to work my way through. So you can see, as I'm going frame by frame, you can see her now walk in front of the tree and extend her hands out. And you can see Isaiah, his hand and face slightly above the bus driver. And we see Mr. Wagner go down. And we are at 14:01, frame 3. And you will see my client then begin to step back. Okay, so we are at 14:04, frame 6. And what you can see is you will see the camel hat of Mr. Wagner. You see the individual in the beige, orangish sweatsuit, male with the backpack. And over his right shoulder, you will see my client standing to get out of the way of Mr. Wagner as he prepares to go down. Moving frame through. Mr. Wagner then goes down. We are at 2:14:07, and you can still see my client. She's very clear here, standing above the right shoulder of the individual in the beige sweatsuit. She is standing as Mr. Wagner goes down to intervene. So now I'm going to go back to 2:14:07 and hit play. You see Isaiah walking around. We see him momentarily start talking with Haneen. Haneen is filming him. He's upset, threatens to punch her. And that's at 2:14:36 as I stop it. Okay. So we see Zayla Carter and take him away from Haneen as I hit play again. You can see the bus driver just standing around. So we're now at 2:14:49. And we see Isaiah standing up by the tree. We see the third individual, a third adult that's never been named, in the blue rain jacket and a beige hat. We see Mr. Wagner sitting with his hand on Mr. Ali's head, and the situation appears to be calm. So now, if we look at the testimony of witnesses as to what they described, what my client did. The situation was over. She didn't appear to be at risk. If she was, I would have brought her onto the bus. Josh described the mom as screaming and crying. She didn't get in my way. She didn't impede. Elijah, I didn't see the adult females. Eric, she just looked like she was watching from the looks of it. Caleb, question. Did you see Zahraa Ali attempt to get people to stop punching her husband in the head? Not that I'm aware. Athena, the person whose arm was under the neck and the person yelling, my husband, do you know who that was? I'm not sure anymore. Now, what's interesting is in the state's closing argument, they said that I asked a confusing question and I was the one that elicited that response. I actually watched it last night and went back to it. It was actually on redirect from Ms. Zoe. And if you can all look at your notes and see when she
blame everybody else.
In response to a state's question, not the defense. No appear point. She appeared to have her arms wrapped around her upper torso. Isaiah. So the mom, her arm around her neck and her shoulder, her upper chest, as he described. Now, as you described it, you didn't describe it as up against her neck. No, sir. You were concerned about where it could go, not what you saw. Absolutely. The only person who said that she saw my client strangling her daughter was Zayla Carter. Now, that's interesting because what I want to do, I'm going to rewind, and I want you to remember Zayla Carter. In all black, she's got the beige backpack. And what she's really doing is trying to manage Isaiah. She intervenes when he is yelling at Haneen, pulling him away, getting him away from Haneen. She then walks around and walks towards the front, comes back, and then when she sees Isaiah go hands-on with my client, she then intervenes. So you tell me, or you decide for yourselves, as to whether she's actually paying attention to what's happening.
She should have been.
So I will go back all the way to the point of where my client and Josh Wagner. Now,
A good point, Karen.
How long my client is standing up before she's even down on the ground with her daughter.
You indicate the time, please.
Yep. Thank you, Your Honor. It is 2:13:58 hitting play. So there you see Ms. Carter dive into the pack. In front of the bus driver. She's standing over in the far left behind Isaiah. Haneen starts filming. Isaiah begins to attempt to punch. She pulls Isaiah back at 2:14:37. She's holding on to Isaiah. Isaiah disengages from Haneen. She's having a spirited conversation with Haneen. She then walks away. Back to the whole incident. She then confronts Haneen again, starts pushing her. Pointing, turns to her right, looks to her left. Stopping at 2:15:30. Wasn't watching at all. I mean, I don't blame her. There's a lot going on.
Sidebar.
Isaiah. Haneen is arguing back and forth with her. State also relies on Mary Wagner. This wasn't intentional. I just happened to stop it at 2:15:30. She has now decided to run across the street and start, saying, "Hey guys, knock it off." Everybody who was around there, nobody said that they saw my client strangling. They said, "Yeah, I saw her grabbing her, saw her holding her." Her daughter to the police at the hospital that night. My mom was holding me. I was in pain. I had just woken up. I was confused. I tried to speak, but words couldn't come out. My voice was raspy. I wanted my mom to let go of me. I was in pain. She wasn't trying to hurt me. She was protecting me from the chaos. I can't imagine an attempted murder charge where the alleged victim is telling law enforcement that night, "I don't think the person's trying to hurt me." There was chaos. I had just been rendered unconscious from a previous struggle that my mom wasn't involved in. So let's take a walk through the jury instructions.
Oh.
I will be the first to acknowledge, or maybe not even the first to acknowledge, that there is a lot here, okay? Even as somebody who's been doing this, state, defense, the court, there's a lot to this. And the court instructed you that every single instruction matters. There's no one instruction that's more important than the other. Many of the instructions refer to other instructions. A couple of trials ago, I described this as a book, which I think is helpful. If you think of this as kind of, when you read a book, there's an introduction, right? Instruction number 1, it's your duty to decide the facts in this case based on the evidence presented to you during this trial, right? So that's the introduction. Judge talking about her role. I'm not ever intended to comment on the evidence. If you think I did, don't do that. I don't take that way. How you evaluate evidence, how you assess credibility, lawyers' remarks, objections, evidence. So that really kind of like, okay, basic stuff. So then we talk about jury instruction number 2. As jurors, here's your job. Your duty is to discuss. Number 3, every charge is different and not a verdict on.
I don't care if it was my husband, my son, my mother, my father, anybody, a stranger, their friend, their boyfriend, their husband, their kid, anybody who's whooping ass on my child, I'm going to be whooping it on them.
one charge determines the verdict on the other. Instruction number 4, reasonable doubt. Okay? Everything has its place. So then we get to around 13. We talk about accomplice liability. And then the first one is a to convict instruction for Mr. Ali, and that's 15. Okay. So if you're taking notes, you can take notes or you don't have to. But there are 5 to convict instructions for my client. Attempted murder in the second degree, to convict is instruction 16. The assault 2 is instruction 30. Unlawful imprisonment is instruction 35. And I'm going to walk us through some of these. Burglary in the second degree is 46. And violation of the court order is 48. And so we often spend a lot of time talking about those because that is the ultimate roadmap for you as to how you decide, or has the state proven beyond a reasonable doubt the following elements? And then it refers to other instructions. So then you get to the end, and then it kind of is a concluding instruction, and it tells you, okay, here's how you deliberate. Select a presiding juror, kind of the order in which you consider things, when you do a special verdict, when you consider a lesser, okay? Now, there will be times where I can imagine a juror saying, well, what about this? The answer to that question, if there is an answer, is somewhere in here, okay? You have every right to ask the court a question and say, as the foreperson would write the question and say, you're asked for the following information. And as Ms. Stone alluded to, we are very limited in the ability to answer those questions. I'm not saying you're not going to get an answer, but very often it will be, please refer back to your instructions, because we have
You're not the judge.
Influence your process.
You're not the judge. Why are you bringing that up? That has nothing to do with your closing argument. She's already told them that. Move on.
Give undue attention to a certain instruction. Or if there's
Thank you, Tori.
But if you get a response to say, please refer to your instruction, the answer is somewhere in there. It may be it's unsatisfying, but that's kind of how this works. Okay, so I want to be conscious of time, so I'm going to kind of walk through the to convict instructions. Turning to 16, which is attempted murder in the second degree for my client. Okay. Now, if there is a reasonable doubt as to any of these elements, you're up. The state hasn't established beyond a reasonable doubt. And Mr. Kading talked about it a little bit, but the reasonable doubt instruction is instruction number 4. You don't need to turn to it, but I'll just tell you. So that's where it talks about the presumption of innocence. The state has the burden. A reasonable doubt is a doubt, can be singular, for which a reason exists. Okay? So it's not just some doubt that's made up in thin air. You have a reason for it. And your reason can arise from the evidence, testimony, exhibits, or the lack of evidence. Well, how come we didn't hear from this person? We weren't given this, okay? So the question is if you have a reasonable doubt, the state hasn't satisfied its burden. Now, as a principal or accomplice, did she take a substantial step toward the commission of murder in the second degree? Instruction number 11 defines substantial steps. Conduct strongly indicates a criminal purpose. So when she walked up there, was she acting as an accomplice? (13) defines accomplice. Did she aid? More than mere presence and knowledge of criminal activity of another must be shown to establish that a person present is an accomplice. She didn't solicit, she didn't command, she didn't encourage, she didn't request her husband to commit murder in the second degree. Did she aid or agree to aid in his attempt to murder his daughter? Well, the state has acknowledged that there was no plan. There was no, Mr. Ali didn't arrive there with the intent to murder his daughter. So in the seconds that she walked up there, after seeing her husband being punched, she said to the officers, I saw that. As she approached, her husband's on the ground, her daughter's on the other side, there's kids in between. Mr. Wagner, coming from the other direction, had a clear view of Fatima. The state would have you believe that in those mere seconds that she formed the intent to say, wow, I'm going to help my husband kill my daughter, by kind of standing around trying to push Isaiah off, who had just been punching her husband in the head. Or that she, while she's holding her daughter, crying, my daughter, in a voice that Fatima described as sad, and told the police that she was trying to protect her from the chaos. In the state's eyes, that's attempted murder. Ladies and gentlemen, this is why we have juries. It's not her decision. It's not the court's decision. It's not my decision. It's your decision. It's your responsibility to hold the state to its burden, that we start from a presumption of innocence. Constitutionally, we walk in this door and we say that my client has not done anything. What did she do? She ran across a parking lot, through a crowd of kids, said that she could see her husband being punched, not 30 times, not 40 times, towards the end, stood there, as we saw in the video when it zoomed in, kind of with Mr. Wagner. Wagner goes in, frees his daughter. If that's attempted murder, we're all in trouble. If a mother going to the aid of her daughter, checking on her husband, who a mob has surrounded and kicked repeatedly and beat, and there's no evidence that she could actually see her face from where she was standing, that in those seconds it's attempted murder, submit that it's not. Next is the assault 2. Instruction 30. State has to prove. On or about October 18, 2024, the defendant, Zahraa Ali, intentionally assaulted her daughter by strangulation. Isaiah Williams. Her arm was around her neck and shoulder, around the upper chest. Would you describe it as up against her neck? No, sir. Were you concerned about what you saw previously was potentially going to happen again? Absolutely. And that's why you intervened. Not because she was being strangled, but you wanted to break her free and you were worried about her. Instruction 35, unlawful imprisonment. Did mom substantially interfere with the liberty of her daughter? That the restraint was without legal authority, and that the defendant knew such restraint was without legal authority. We revert back to instruction 21. And that is the parental discipline. Discipline isn't really, I think, an appropriate term, because you think of it in terms of somebody who's been bad. But in terms of basically, when do you get to hold your child? So physical discipline of a child is lawful when it is reasonable and moderate, and it is inflicted by parents for the purposes of restraining or correcting a child. She's not trying to correct her. I don't even know that she's really trying to restrain her. I think Fatima described her mom's actions perfectly. She was trying to protect me from the chaos. Wailing, my daughter, my daughter. That seems to run entirely counter to criminal intent, acting unlawfully. The defendant knew that such restraint was without legal authority. Okay, I want to turn to the burglary. And I know I'm going fast, but you guys have been sitting here all day, and I want to be respectful of your time. Okay. Front page of the instructions. State of Washington versus Zahraa Ali in the case number. Okay. This isn't Fatima Ali versus Zahraa Ali. Daughter doesn't bring charges. This isn't Timberline High School, North Thurston School District versus Zahraa Ali. This is the state of Washington as represented by these two prosecutors, okay? This is the state that is electing to bring the charges, and they are the ones choosing to bring the charges, okay? There are two, we heard about the no contact or the trespass order that was issued by the vice principal. We can question all day the wisdom of that order, but that order was in place, right? In response to School Resource Officer Howard, I was there basically as a show of force. I handed her the letter, said you can't come to school. She appeared to understand that she couldn't come to school. Okay. And the letter, which you have in evidence, says you could be charged with criminal trespass if you violate this order. If we were here talking about count 4, defendant Zahraa Ali is charged with a crime of criminal trespass, I'd be like, yeah. State has proved beyond a reasonable doubt that she's guilty of trespass. But that's not what they chose to do. They chose to try to, for whatever reason, go for more.
Objection. Sustained.
So they didn't charge criminal trespass. They're charging burglary. So criminal trespass is the first piece I can see. She didn't have permission to be in the school. The second piece is that her entering the school or remaining at the school was done with the intent to commit a crime against a person or property therein. Okay. State in their closing said, okay, there's 3 potential crimes that she could have committed while she was there. She could have run in to try to assault her daughter. Really? Do we really think that she was running in there to assault her daughter? The woman who was holding her, protecting her from the chaos, is then going to run into the school and assault her. Isaiah. Maybe she was trying to assault Isaiah. She had no interest in Isaiah. Haneen was upset with Isaiah. You saw her interacting with Isaiah a ton in this melee. She was upset. There was pushing. There was a threat to punch by Isaiah. That was, she didn't care about Isaiah. Her intent to go into that school was not to assault Isaiah. So then the only question is, the third option is a violation of protection order. So this is where it gets interesting. The 2 convict for the violation of the court order in 48. You have the body-worn video, Exhibit 38, from the officer who handed the order to my client. You get to see, and this is the miracle of body-worn video. You get to see what she said. You don't get to rely, you don't have to rely on his interpretation. He says, she's like, are you with the school? No, I'm not with the school. I'm not a school resource officer. What is this? Haneen comes and you can hear them talk in Arabic. State chose not to translate. They have it on video. They didn't use an interpreter to say what was being discussed. And she has questions. And he's just like, well, you know, it looks like Dad, Isaiah Williams, this person is. Yeah, I know. So it just basically, I mean, it says, and this is what he's telling her. Don't contact him. Don't call him. Don't email. Don't stalk him. I don't even know if he said stalk, but he said, you know, there's no mention of school. He never tells her school, never tells her 1,000 feet. It's a little curious when the state puts up the exhibit and says, oh, it's a really simple document. We know from Fatima, she says, yeah, Mom speaks English, not nearly as well as Dad. Does she read English? Nope. She gets handed a document, not written in Arabic, doesn't use a language line, doesn't.
He's basically arguing that she was trying to protect her daughter. She was hugging her. You know, she's 18 and she's almost 18 and she's not going to have many opportunities. Bullshit. That child said on the witness stand, they almost never touched. Ever. Mom and her rarely ever hugged. They barely ever touched. That was not normal, especially from behind. Yeah, no. That mama was trying to finish what Daddy couldn't.
Doesn't say to Haneen, hey, look at paragraph 4 on page 4, whatever the number is, and make sure you understand
they do.
that this could be bad if you go to the school 1,000 feet. None of that conversation happens. State, for whatever reason, never called Haneen.
Very good
to say,
question.
What conversation did you have with your mom? There is zero evidence. All that you can know is that she was said, don't have contact. So now we go back to the burglary. That the entering or remaining was with the intent to commit crime against a person or property therein. Did she run into that school to violate? I'm going to run into that school to violate with the intent to violate a protection order against Isaiah. She wasn't running in there to have contact with Isaiah. She was running in there. My daughter, I saw my daughter run in here. I had it on here, but you guys have it. You guys can watch the video from Timberline High School. She is in there for seconds. She runs in. You hear from the counselor. She gets in, closes the door. She could hear her yell, my daughter, where's my daughter? I know my daughter went in here. What does she do? She lingers for like 2 seconds, turns around and walks out on her own. She wasn't being non-compliant. She then goes around to the other side. The principal's like, no, we don't know what he says, but we can kind of surmise. Like, no, go, can't be here, go. So in order to convict her of burglary, you have to conclude that she has the intent to commit a crime inside. Not that there was some order that she didn't understand written in English that said she couldn't be within 1,000 feet. That she had the intent to do something other than find out where her daughter is. You know, it's just interesting. Picking up themes. State was constantly asking. She was more concerned about her husband. Really? She's holding her daughter. Her daughter gets ripped out of her hands by Isaiah. She runs and she kind of shuffles towards the school. For somebody who is more concerned about her husband who has just been kicked, and she left him behind, goes to check on daughter,
Oh my God.
goes into the school. Where's my daughter? Where's my daughter? And the question is well, did she ask her condition? She's trying to find her.
I didn't inhale, I promise.
So then
I'm just holding it.
The final crime, the violation of the court order.
That's right. Cause for speculation.
Knowingly violate a restraint provision of the order prohibiting contact with a protected.
How can the judge sit there with a straight face?
Distance provision in there. That if she understood it, she violated it. She wasn't supposed to be there. What evidence is there that she understood it? You hand me a protection order written in Arabic.
Auntie Candy, that's a good question. Usually I just go live and everybody has their bells clicked and I say verdict, but I can put it on Instagram. I can put it on Twitter, X, whatever, that we have a verdict if you want to come on over here, but you have to be in my account. I would love to have a way to do my own app, but I can't do that. I don't know how to do that. But anyway, but I can go on Twitter and X and Facebook and say we've got verdict. And I can even have them translate it in Arabic for them if they'd like. I know I'm such a biatch.
What did she know? She knew that she couldn't call, she couldn't talk, she couldn't have contact with Isaiah. You watch that entire video. At no point does Isaiah say, I'm having a conversation with her. At no time does she reach out and try to have contact with Isaiah. Yeah, she was there. She stayed in the car. She stayed away. Daughter got in trouble. She ran over to her daughter.
I know, but I said I can do that too.
She went to the school to check on her daughter. She never talked to Isaiah. She never had any contact with him. Now, state's going to be like, well, that's preposterous. Really? Is she there to have contact with Isaiah? She's there for her daughter.
Okay, I'll have to figure out how to do that. I don't know how to do that. I just where do I put it in Discord?
Sitting in that car.
Private messages? You'll have to teach me, G14.
October 18th. She knows she's different. She's from a different country. Speaks limited English. Has limited success with navigating the school. Tried to do what was best for her daughter. Tried to get her transferred to North Thurston.
I got you fooled.
Couldn't imagine a scenario where her daughter went to school, was running away from a school that she could never even go to. She tried to get in-person school for her and was turned away.
This is the wife's lawyer. We still got a rebuttal, and it's like they got an hour and a half.
Went to the police, tried to get help, didn't work.
Supposed to be 2 hours, hour and a half ish.
Went to the school to try to intervene, wasn't told the condition of her daughter, wasn't allowed to see.
Okay, we have a lot of new people here, so let me just say this. Everybody is welcome here, all abilities. I'm deaf. We have a lot of people here that struggle with different abilities or are blessed with different abilities. And we love people with different opinions, so long as you're respectful, no name calling, and we keep the pineapples and no politics. Okay? So we welcome opinions. We just need to be respectful, and y'all are amazing at that right now. I don't really ever worry about people on my channel because y'all are just awesome, respectful people, and I thank you for that.
Her daughter, her husband was taken away.
And they're both still in jail. They did not bond out.
No idea that she would have to defend herself and her approach to her daughter and her approach to her husband, and that under a convoluted set of facts and allegations would be accused.
Yep, they're
of
two different defense attorneys.
assault in the second degree.
One for the husband,
unlawful imprisonment,
one for the wife.
all because, as her daughter described, she was trying to protect her from the chaos. She went into the school to look at.
I told you, thank you in the live that I had received it. Boo, did you send another one?
After her. On the one hand, the
I
prosecutor says
looked.
she doesn't care about her. She cares more about her husband. But then when she runs into the school to check on her, she picks up an allegation of a fourth charge, a burglary. That could have been a criminal trespass, but no, we got to defend.
Objection. Sustained.
Objection!
A burglary in the second degree charge. You talk about unconscious bias. My client is different. You can't allow yourself to look at her any differently and reach a decision because she's different. The decision has to be the same, whether or not her child grew up from kindergarten to junior year.
Frankie, if you sent one, where and when? Because I'm having to look.
The mom was the
Yeah,
head of the
no
PTA.
reason. Oh, thank you. I did. Thank you. Oh, thanks for the donation, Leroy. And it will go 100% towards a wheelchair. We have 3 more wheelchairs to get, and I think we're done.
Client did.
I do see it. My apologies. It didn't alert me. My apologies. Thank you so very much. I would have thanked you if I'd seen it. I apologize.
We have a presumption of innocence, and it is designed to safeguard, protect clients who may be different, to be a check on the government, and to say no, not this time, and not this case.
Didn't alert
Consider
me.
the facts, the circumstances, and the law. There is one verdict that applies for each and every one of the counts. My client is not guilty. I think we can all agree that this is a tragedy, and we certainly could have done things differently, but that doesn't make this a crime. Again, I appreciate you being here.
Members of the jury, we're going to do a brief stand up.
For those of you who don't know, I live in Kerrville, Texas, where that awful flood happened. And yes, my backyard was affected, but my house was not. We have a lot of, I'm a volunteer firefighter and first responder. I'm also a chaplain, so I have been involved with the families. I was a part of, for a while, I was helping the families walk through waiting to find out that their loved ones had died. There were really no alive ones. And then I also helped walk through with some of the loved ones as they identified the remains. And then I also have been working with the disabled community because a lot of the people who were affected were elderly and disabled people. And all of their medical equipment went floating down the river. And if you don't know about it, Google Kerrville, Kerrbille, 4th of July flood. So all of my super chats and super stickers and all donations are going to 2 places. One, we've bought 4 wheelchairs. And then the other half of it is we had a volunteer fire department that got on their trucks and were saving people from trees and rescuing, whitewater rescuing, as they call it. And when they got back to the firehouse, it was all empty. The water had come up at so high that it washed everything out of the fire department, all their bunker gear, all their helmets, their boots, the oxygen, all of it was gone. It looked like somebody just cleaned house. Nothing was left. If it wasn't screwed to the wall or bolted to the floor, it was gone. And so what we're doing is we're raising money. I've already donated $500 to the fire department to help them. They need to get all new bunker gear. They did find some of it downriver, but it's not usable. And bunker gear per person, you're looking about $5,000 a person, $5,000 a person to replace it. And a lot of these volunteer fire departments don't have the money that the paid departments do. It's everything that they get to support their department's own donations. So, I have really been putting it out there. I think we've raised about $1,500-ish overall. I am not taking any of that money. It is all going to help people. The disabled people, they can get stuff through places like Red Cross, but it takes a while and there's a lot of red tape. When I can just go down to Walmart and buy a transfer wheelchair for them that will suffice until the insurance replaces their really nice wheelchair for 150, $200. So we had somebody donate $1,000, and that person is going to get a thank you card from me. I haven't sent it yet. So that is what's happening. I have driven down past where the flood started, that camp, that all 27 people, 2 camp counselors, and all 25 girls or something like that, were swept away and unalived in the river. Anyway, I have been through that camp. I've driven that road hundreds of times. It looks like they've had a lot of cleanup. There's been a lot of amazing work to help get the roads passable and the bridges cleared and start searching for the bodies. We're still finding remains. But the problem is it takes a lot of man hours and time, and it's going to take a year to get just the cleanup done. So on the 4th of August, I'm going to do a month in review, and I'm going to show you some of that footage that I've taken. You are right, but it takes time. And disabled people, we've bought, I found a CPAP that was like new, but I bought new mask for it and hose. I supplied one of those, and things like that. So, yes, it does not happen quickly with grants and things. So, some people will have to wait, but they can wait. There's some people who absolutely need things right away and can't wait. And that's what I'm trying to provide. So, anyway, so all your super chats would be greatly appreciated, and it will go to helping those who are truly in need, and 100% goes directly to it. Nothing's taken out for office or clerical or goodwill or things like that. And I am a 501c3, so if you need the tax exemption, I can send it to you. They did. They did give me a discount. Basically,
all right, I'll ask everyone to come back to order, please. Members of the jury, because the state has the burden of proof in this case, they have an opportunity to make what is called a rebuttal argument to you. So please give your attention to Ms. Stone.
I may auction off a hat. There's going to be a big fundraiser coming up, and I'm going to do some baseball caps because those are quick and easy to do. They take time, but they're not like as difficult as this is. So I may bead me some baseball caps and put them in for the auction to help raise money.
Backwards a little bit. I want to start with Mr. Leary's arguments, and then we'll go back to Mr. Kading. So let's start first with Mr. Leary's arguments. How did I get here? How did, as he says, his client is thinking all these things? Well, you don't know that. There was no evidence of that. There was no testimony of that. You have no indication of that whatsoever. There was quite a bit.
Good girl. She's hitting him right where she needs to. There's no evidence that was presented. She's not saying they didn't put on a defense, because that would be a little argumentative. But what she is saying is there's no evidence to state that. So she's calling them to the mat. And by the way, y'all were fussing about the way she's dressed. She has a really nice blouse underneath that has a little collar with a little thing hanging. This is like a loose suit jacket.
It actually of Mr. Leary just.
You may not like it, but look at it. She's got a nice shirt on underneath.
Have nothing about what his client is thinking. So you don't get to take that as evidence in any way. You get to look at his client's actions, her behaviors, and her statements. And you get to evaluate the evidence in this case based on that, not what Mr. Leary asserts to you his client is thinking during the course of this time. He says that this is her last chance to parent. That's what is probably happening on this day because they're getting ready to go to Iraq. I submit to you, this is in fact her last chance to isolate Fatima. You heard from Fatima. This wasn't just like, oh, I'd rather go somewhere else, somewhere different. She had real fears about going back to Iraq. She had real fears about that. It was a one-way ticket. There was no intent or explanation or indication of return at that time. You heard her say, I'd been before and there were some things I liked about it, but mostly I did not feel safe. And when I have now been pulled from school, I am no longer around anyone. I've had my cell phone taken away. I can't communicate with anyone. I am at home where my parents can see me all the time. I don't have any adults to talk to. And now I'm going to a country where I don't feel safe. There might be family there, but as Fatima has demonstrated throughout this trial, and this evidence is demonstrated, those are not family members that support Fatima. That's not what she's expecting. And there is no return ticket to come home for a 17-year-old who has lived here for a long time. That was very concerning to her based on her own personal experiences. And she expressed that to you.
I think that, you know, she's a casual. I think that a lot of us expect lawyers to have their power suit on for closing and opening. I get it.
There is, Mr. Leary referred to, going back to voir dire, the juror that talked about what his experience was with that, his runaway child. And let's be very clear, that's not evidence in this case. That's simply voir dire. But notably from that, at no point during his efforts to get his daughter home did you note that he said he strangled his child to do so. The evidence here is what has been presented to you from the witnesses and the testimony. Mrs. Because of the evidence, not because of something different, because of the statements of witnesses, because the statements of the people that were present. He says, how could his client know? She just gets there. She has no idea. Yet every single other person that is present says it is obvious, immediately obvious. Not kind of obvious. No, I had to get around to a couple of people to see. It is immediately obvious that this child is unconscious and being choked. But somehow mom is the one person of this whole thing that can't see it. She's the only one. She can only see what is happening to her husband, not to anyone else. When we talk about the kids who say they saw it, that's incorrect. Isaiah sees mom strangling with her arms around. She says she can't breathe. And that's part of why he, in fact, reaches down to help her. Athena specifically says mom has her around the neck and is pulling at her around the neck. When you go back and look at those exhibits, you'll see that in one of Noah's still shots, Fatima is sitting there and you can see mom's arms around her neck. Not in the same way dad's are, it's a different hold, but it is around her neck and Fatima tells you she can't breathe. You will see also that at some point it looks like she's being pulled back.
Looking up.
Is popping up because mom is in fact pulling on her. Athena said very clearly that mom is grabbing at her to get her and it is overly aggressive. That was Athena's description of mom grabbing her by the neck. She says Fatima is flailing her arms around and mom puts her arms around her neck. She says ultimately when Mr. Leary was talking about confusing Athena, Miss Zos asked on redirect, you sound like you were confused because Mr. Leary, do you recall he went through second by second on the video with Athena and said, well, do you see it here? Well, do you see it here? Well, do you see it here? And Athena said, I know it was mom, but now that you show me the video, I can't see where mom is on the video, but I know what I saw in person and I know it was mom. But now I guess I'm confused. And Ms. Zoe came back on redirect and said, are you confused because you remember it being mom, but now you can't see the video specifically? Yes. So in fact, it was Mr. Leary that asked her second by second. But Athena Rich told you, in fact, that it was mom. And she was not confused about that. We heard.
If you're here seeking asylum because you might be unalived and you're that kind of refugee, I don't think you should go back to the country. I think if you move here to become a better person, better life, and you want to live here for whatever reasons, that's fine. But if you're fleeing for whatever reason, fleeing your country to live here, I wouldn't go back.
Heard Fatima say, I don't think she was trying
This
to
is
hurt
so
me
true.
later at the hospital. But what she immediately says, and you heard Liz Robinson testify, that when she comes in, my dad was trying to kill me. My dad was trying to kill me. My mom was choking me. That's what Fatima reports to Liz Robinson. That's what Liz Robinson testifies to. And you remember when Fatima testified, she said, I didn't think she was trying to choke me at the time. And I said, Fatima, do you want to believe your mom is trying to kill you? Do you want to believe your mom is trying to strangle you? No, I don't. That is an absolutely reasonable response from a 17-year-old whose dad just strangled her into unconsciousness and a seizure. It is an absolutely reasonable response to want to believe that at least one of your parents is on your side.
That's
Absolutely
so true.
reasonable.
Good girl. Well
Doesn't mean that's what
spoken.
mom was doing. It means that that's what that child is hoping at her core, that there is a parent that is looking out for her. And that is not what happened on this day.
That is well said, my dear.
Mom
I
has
like
just
that.
as long
Good
on
job.
scene as Josh Wagner. Mom actually has longer on scene as Josh Wagner to see what is happening. And when you look at that video, you see that she does not provide any aid at any time to her child.
Or your dad.
Zero aid.
I'm liking her
When
now.
she's
A whole
standing
lot
there
better.
and counsel talks about her saying, my daughter, that is the explanation for, that's her expressing her concern. But at the time that that is actually happening, remember what is actually going on at that time. That is when Haneen and Isaiah and Zayla are having that confrontation, because Haneen comes in late. Haneen doesn't see anything that's happening. Wagner is already down, holding her dad down when Haneen gets there, and straight in puts the phone in Isaiah's face. And again, why is that? Because in this scenario, for this family, Isaiah is the bad guy. In every version of everything that you have heard, that complaint has been about Isaiah. So when defense counsel says she doesn't care about Isaiah, she doesn't, whatever, he's whatever. That's not true at all. Every chance that she gets, Zara and Haneen provide information to law enforcement about how this is all Isaiah's fault. She says, go, go, go. He said, go, go, go. And he took her. You know these people. They're rude. That's what she says. Those are their statements consistently. So this idea that somehow Isaiah doesn't matter, he's of no consequence. So she's not going in there to violate any orders or assault Isaiah or do anything to Isaiah. She absolutely is. She knows she's not supposed to be there. She knows she's not supposed to have contact. She just doesn't care because she does not like Isaiah. And she says that repeatedly. She says it to Officer Hang. She says it to Officer Bell. She says it to Officer Chavez over and over again. And keep in mind, this is the same Isaiah that in September, just 4 weeks prior, she's already had some kind of interaction with at the school that has gotten her trespassed in the first place. So we already know that she is in fact the focus. We know that she is the focus of Zara's behaviors and actions and ire. And this is an extension of that. And she thinks that he has Fatima and she's going to get him back from Fatima or from Isaiah. So during the course of that interaction, then when Haneen comes in and puts the phone in Isaiah's face, and all of a sudden now Zara is saying, my daughter, my daughter. Who is she actually saying my daughter about? Is she saying my daughter about Fatima? Or is she saying my daughter about Haneen, who is in the middle of that interaction? We don't know. It could be either one of them. But her follow-on behaviors do not demonstrate this overwhelming concern for the condition of Fatima. It demonstrates a concern for getting her back as if she is a possession, because she wants to isolate her and control her. She doesn't want her talking to law enforcement. She doesn't want her making statements or any more statements about what is going on. When we look at her arrival at the school, how does she know to come running? According to Mr. Leary, she arrives at the school. She hasn't seen any kind of conflict happening. So presumably, Dad has called her and said, hey, I see her. She's here with Isaiah. She's at the bus stop. I'm going to go get her. Presumably that's what happens, because how else does she even know to come to the school? There's no way for her to know that. And how does she know when the car parks to get out and start running for that scene? Because I submit to you, Dad has indicated to her in whatever way they communicate about discipline of their children that he is grabbing Fatima and it's going to be a fight, and he knows that. And she is running to assist. And when she gets there, that is exactly what she's doing. She doesn't have to know that he has the intent to kill Fatima prior to, but certainly if you run in and somebody is in the middle of strangling somebody and your first instinct is to remove the people who are trying to help your daughter, that is a substantial step as an accomplice to aid by presence and act.
Yeah, that's something that is not really touched on, but he's a person of color. That really adds to the situation. It does. All he cared about was getting the car. Maybe there's something in it.
Based on what you observed on those videos, do you think there's anything Haneen tells you that is plainly reliable or that doesn't speak to her parents' behalf, regardless of what information she says? Do you think there's anything? She's not there for the striking of her dad, yet she immediately shows up and starts telling law enforcement when they're there, they're hitting my dad, it's all on my video. There's no video of him anyone hitting her dad. She's not even there when that happens. Do you think Haneen becomes a reliable witness to hear anything from? I submit to you that she would not be.
I was surprised she didn't testify on their behalf.
She goes to check on her child.
But she could have get in trouble, become an accomplice.
That her first instinct is to go run and check on her child. The amount of time she spends in that school is grossly less than the amount of time she spends trying to get to her husband and screaming. Remember what Officer Bell's and Officer Chavez's cameras looked like. Screaming over and over again. You let him go. He did nothing wrong. You let him go, over and over. Her interaction, look at her demeanor and her body language when she gets in the school. It's angry pointing is what I submit to you. When she leaves that school, it is angry pointing at Mr. Dean. Then she turns around and she's gone. That's it. Remember what Officer Chavez says. I told her EMS was working on her child. What was her response? She didn't have one. No response.
I would have been running to my child.
Concern that we keep hearing about for Fatima. I submit to you it doesn't exist. It's not there. Fatima told you that she could not breathe. She told Liz Robinson that she could not breathe. And that is consistent with what the other individuals that were present who identified it, because certainly some people said, I didn't see it. Listen, Mr. Denicola said, I saw mom grab, or who I assumed was mom, but then my focus was on dad. That's where I thought the immediate threat was. And Josh Wagner says, I'm staring at dad. This is where my focus is. I know something's over here, but this is my focus. So the people that are actually paying attention at some point, even Isaiah says initially he's not looking at it. And you can see in the video, they're watching dad, because who expects mom to come in as an additional threat? They're not anticipating that until it actually happens. And now they have to intervene. And they immediately, when it happens, start talking about it. Athena says, you can't do that. Like, why are you grabbing her around the throat? You can't do that. Fatima says, I can't breathe. You hear Noah Wagner from across. Let go of her. It's done. At that point, Wagner is already on down. So let go of her is only directed at mom. He's watching it happen in real time. So you absolutely have the individuals that are seeing these things as they are occurring because they are far enough back to identify that. When we talk about crimes and the burglary, as we pointed out, as the state pointed out to you in your instructions, in order for something to be a burglary, you have to enter a building. So yes, a criminal trespass also occurred, but a burglary in the second degree occurs when she enters a building. Just like when she assaults her, that is also an assault in the 4th degree, but it is not only an assault in the 4th degree. And we talked about that. So that argument by defense counsel, you could have done this for criminal trespass. We could have also done that. It would have been yet another crime. And instead we didn't. We went with when she entered the building, which she is prohibited from doing. There is no requirement, and you won't find it in your jury instructions, that you have to receive your document in the language of your
I'm
choosing.
sorry.
It's not how the law works. If you went to, let's say, France, and you got an order or a ticket from France, you wouldn't get to say,
She's living in Canada
I
with
don't know what it
families,
says.
what's been
I get
said.
to ignore it. I'm not responsible for it. That's not how the law works. You don't get to create ignorance for your benefit. You are still subject to the laws of the state of Washington. And
Objection?
Misstating definition
Definition is what?
knowingly.
haven't talked about knowingly.
Talked about
We
what?
have a brief sidebar with the lawyers, and so
Knowingly. Oh.
we'll move around, right?
Sidebar.
She's 18. She can do what she wants now, but I'm concerned for her safety. I am really concerned for her safety. By the way, I just want to say, y'all have been a blessing today. Thank you so much for joining. I really hope you'll come back. We may have, on the 1st, Joe Schmo, who was at the Lori Daybell sentencing. It's going to be in Kerrville. He's driving through from Arizona to Florida. And he's going to stop, and I'm going to drive him through the flood zone, and he's going to be here. So on the 31st, I'm going to be closed down. We're not going to have any court unless something major happens. And I'm going to get the studio kind of set up to where he can be next to me, and we can share the mic, and we can work, and y'all can ask him all the questions you want to ask about Lori Daybell, because he was raised in that faith and religion, and he knows all about it all too well. He's also very good friends with Megan Connor, the cousin of Lori Daybell, and I'll see if I can't get her to hop on live too, but via remote. So the 1st, I am looking to have a really special live, so long as his trip here is smooth and everything goes well. So this is all contingent on his health, his travels, and all of that.
Please be seated. In just one moment. Okay, we just had a sidebar after Mr. Larry's objection. The objection is really a misstatement of the law. We got to sidebar. Mr. Larry made a very short argument as it related to his objection. Ms. Stone started to respond, and then I just stopped the sidebar and said instead we'd have it on the record. So I am not summarizing verbatim what was argued at sidebar, because I'm not going to rely on that. I will just have the argument here in open court. Anything to add to that?
Ooh,
Mr.
that's
Larry?
unusual.
The sidebar itself.
By the way, I have to tell you, even though we may not agree with the decision of the court not to bring in the honor unaliving or redrum, and the fact that she was going to be sent for an arranged marriage to a 61-year-old perv, she runs an amazingly strict but very fair, very clean court, and I appreciate her.
Nope. Anything first to add to the sidebar? Mr. Keating, Ms. Stone.
No, Your Honor.
All right, go ahead.
Okay, thank you. So instruction 48 is a to convict for violation of court order. Prong 3 says that honor about the said date, the defendant knowingly violated a restraint provision of the order prohibiting contact with a protected party. It's the state's burden to prove beyond a reasonable doubt each and every element. And so prong 3 is the burden on the state to establish that the defendant knowingly violated a restraint provision. My argument is that she was presented an order in a language that there's testimony from her daughter that she does not read. And the state in rebuttal argued that the defense doesn't get to argue that it was written in the wrong language. She said the state said there was nothing in the instructions. It said that the order had to be written in her language, and used the analogy that if one of us was to go to France, we wouldn't be able to say that we have ignorance of the law because we don't speak French. The problem here is that's not.
They stay.
My client's not claiming innocent or ignorance of the law.
They stay.
The specific issue is the state has to establish a knowing violation of a restraint provision. And if it is contained in a document that there's testimony that she.
I have done the most deep research as I can find, and it is not clear if they are actually citizens or they're granted work visas. We don't know if they're citizens, and nobody's telling.
Doesn't understand. The state hasn't established that it's a knowing violation, and to assert that somehow it's our job to prove, or it's somehow wrong for the defense to argue that because it was written not in Arabic, it's an invalid defense. This goes squarely to whether the state has established beyond a reasonable doubt the knowingly violated. And to undercut that diminishes their burden of proof, the presumption of innocence, and shifts the burden to us, and all three are improper.
Thank you. Ms. Stone?
Thank you, Your Honor. Your Honor, first of all, I wasn't done making my argument. I was partway into my argument when counsel raised the issue. So it's unclear to the state how counsel can complain that the state hasn't made an appropriate argument when it hasn't let the state make, in fact, the argument. Second of all, he says very specifically during his closing that one of the ways that he is demonstrating that the state cannot prove that the defendant knew because it wasn't written in their language, as in specifically Arabic, her first choice of language. This is a direct response to that argument made by the defense, which the state is entitled to do. There are, in fact, additional arguments I'm making along with this same line that go to that.
He opened the door.
The state has not yet once misstated the obligation of the state as it relates to knowledge. I am talking about a piece of evidence that defense counsel presented, and I am responding to that directly and tying it into knowledge, which still has a significant amount of argument to go from the state. So at this point, not only is his objection not consistent with what the state's arguments have been, it is untimely because the state has not in fact finished that argument, and it is improper because the state is entitled to respond in rebuttal to these specific arguments that defense counsel has made, which is
so
not
true.
Essentially in her preferred language, then how can the state show that she knew, and so she can't be held accountable for knowing? The state can't. Those are all appropriate arguments for the state to respond to, and I was in the process of doing so when defense counsel untimely objected to the course of that argument.
Mr. Lurie, anything further?
I would just note that it's not her preferred language. It's that it was written in a language that the testimony is that she doesn't read.
Okay, guys, do y'all realize what's happening here? I have a thought. This is one of the things that if he was to put her on the stand, this would have been one of the big part of her testimony. But they didn't. They put zero defense up. So how is he going to get this in? How is he going to get it before the jury? You can't put the crap back on the horse. They've heard it. He got it in. This is his way of getting evidence in a way that's through the back door. He's screwing them through the back door.
All right. I'm going to overrule the objection. I do not find that the argument that was made by Ms. Stone misstates the law as contained in the jury
That's
instructions
true.
and does not shift the burden of proof to Mrs. Ali in any fashion. And so please bring the jury in.
So, you know, you lawyers, if you want to get evidence in, just put your dang people up there. And if they don't want to testify, put the daughter up there, put somebody up there, put somebody up there so you can argue this legitimately in closing and not bring up stuff that is not in evidence, just like the state said in the opening of her rebuttal. That's heartbreaking. Maybe not. And you know what? They may be doing it to protect the daughter, too. I was shocked that the other daughter did not testify on their behalf. I wonder even if she's there.
Please be seated. I am overruling the objection. Ms. Stone, you may continue.
I like that she tells them what she's done. Love it.
So back to what we were talking about, you're not going to find in your jury instructions the requirement that any order be written in any particular language in order to establish knowledge. That is simply not the requirement. The state has to show that the defendant knew it, and you have been given sufficient and ample and overwhelming amount of evidence that she did. Specifically, she was offered the opportunity for an interpreter, and she declined that during the course of the trespass order service. She was then asked for Haneen expressly to be provided so that she could be aware of what the limitations were during the trespass order notice. Again, during the no contact order, as you see, she specifically wants Haneen there, and you see Haneen ask the officer, "Are you okay if I'm here?" She likes to have me present, essentially, words to that effect, so that I can help her with this. And she says, yes. Counsel continued to tell you that the testimony from Fatima was that her mom doesn't read English. That was not Fatima's testimony, I submit to you. Fatima's testimony was she doesn't read it well, and she certainly doesn't read it as well as she speaks it, but Haneen usually helps her. And that is, in fact, her preferred version of that. You heard the school talk about they've had communications with mom. Those communications are consistently in English. So she absolutely is able to move around her universe in English. The expectation is that you are obligated to follow the laws of the state of Washington, regardless of what your first and preferred language is. I want to be very clear. That does not mean that somehow makes it easier for you. Mr. Leary made a big argument, I'll choose the word argument, at the end, that somehow Mrs. Ali, and Mr. Ali are being specifically targeted for some reason other than what their actions are. The laws of the state of Washington apply to them equally. Their actions are what are on trial, not them as humans, not them as people. You don't sit here as judges of character. That's not what your purpose is. You are here to determine if the actions that they took on October 18th, 2024
are consistent or inconsistent with the law, as the court has instructed you, and whether the state has proven that to you beyond a reasonable doubt, not whether you personally agree or disagree with anything about either one of them. That is not the standard, and you absolutely should not be doing that. We don't decide cases based on sympathy or prejudice. You absolutely should not be doing that. We decide cases based on evidence. This is a court of law, not a court of feelings. And so I would ask you to return to your instructions. Somehow, Mrs. Ali speaking a different language, it may impact your decision or your evaluation process in terms of knowledge, but likewise, the additional assistance that she was provided and offered, that she accepted, and the assistance that she declined demonstrates to you in how she interacted with both law enforcement and the school as to both of those orders, that she understood absolutely what the parameters were for what behavior she was allowed to do and which ones she was not allowed to do. And she knows she's not supposed to be in that school. Absolutely knows she's not supposed to be there on October 18th. But she goes in anyway because she says Isaiah took her child and go, go, go. And they went in there, run away. So she wants to go get her child back from Isaiah, and she is not allowed to do so when she gets in there by the faculty. She is prohibited from doing so when she gets in there by the faculty. When we talk about the behaviors actually at the scene of mom, again, Mr. Leary is described as like she is comforting her child. That's what she's there for. But you heard Fatima say, that's not what we do. There's no hugging in my family. Like, not just like, hey, it's only occasional here and there. There's no hugging in my family. That is what Fatima said. These are not arms that reach around and comfort her child. This is a different kind of hold. This is a restraint. This is a choking around the neck. And Fatima says immediately, I can't breathe. And Denicola says, I can hear her whispering something, but it's not coming out, right? Remember Athena's testimony also saying, I remember her saying, my husband, as it's happening. That's what I remember. Not my daughter, my daughter. And we know at the time, as we talked about before, Fatima has been isolated significantly at the time that contact is made. So when she runs into the school, again, mom is chasing her down and trying to pull her back. So the 4 weeks of isolation that she has had leading up to this one-way ticket out of the country, mom wants her back. Mom doesn't want her to talk to law enforcement, I submit to you, doesn't want her to talk to the school officials anymore. And that is what she is concerned about. Remember, she says, just let me talk to her. I just want to talk to her for 1 minute. That's what she's telling Officer Chavez. Not how is she, what is she doing? Just let me talk to her for 1 minute. Does that sound like a mom that wants to know about the condition of her child? Or does that sound like a mom who wants to make sure that she and her child are on the same page and they are able to get their story straight?
That is control and manipulation. Thank you, everybody, for being here. I appreciate all the newbies.
So then let's go to Mr. Kading.
Good observation.
Mr. Kading over and over again says, when my client was unconscious, my client had this head trauma, and my client had all of these things wrong with him. You heard no evidence of that. In fact,
I do interpret
Isaiah
for the deaf when they're watching.
I thought he went unconscious. And when asked, is that something you did or is that something that happens later? He says, well, when we were striking him, nothing happened. Eventually, his eyes closed. And when is that? Well, Mr. Wagner was the one and he doesn't know his name, Mr. Wagner. He says, not the adult, not the bus guy, the other guy. When that guy gets there, everything stops. And Josh Wagner says, when he gets there, his eyes are open. He is choking that child. He is strangling that child. And when Josh Wagner does whatever special operations maneuver Josh Wagner does, that is when he releases. And everyone agrees with that. DeNicola says, I'm trying to get his hands apart, but I'm not successful. I'm doing it on my own. And then another guy shows up at the same time. They all talk about the third individual that is present but has really no interaction. And you see that guy in the blue coat come running from the elementary school across the street. But about the time that Wagner is on top of Mr. Ali, that is the same time that DeNicola is down there pulling at the hands. And I submit to you, those things happen at approximately the same time. But each of those kids indicate his eyes are wide open. Remember what DeNicola says, the look on his face. This is not an individual who is unconscious and strangling. It's not an individual where there's any didn't need any.
Love you, Angela.
Why would they check for a head trauma when they've identified, would you like any medical? Do you need any medical? No. Because there's nothing wrong with Mr. Ali. There's no cerebral anything. There's no loss of consciousness. And remember what Dr. Gilbert says, when you lose consciousness, you lose control of your body. And you see exactly what happens when you lose consciousness. When you watch the video of Fatima, you go limp. Everything relaxes. You go limp. You heard Lisa Wall talk about that. When you lose consciousness, you relax, which is what makes strangulation even more dangerous when you lose consciousness, because all of your muscles relax. You know what your muscles don't do? They don't hold on and pull even tighter. The scenario that Mr. Kading offered you over and over again is not reflected in the evidence in any way. Everyone that described how Mr. Ali was holding his daughter describes it in right to left, describes it in a headlock, a rear naked choke, armbar, and it's pinched back. Every single person did this. If he is unconscious, it all drops. It all lets go. And you didn't see that once. And when you listen to them talk about it, there's not a single person that says it looked like it was involuntary, that it was not intentional, that it was anything other than exactly what it was. He was angry, and the look on his face says so. He is intending to do those behaviors. Intent is reflected, I submit to you, by action. A lot of people can say a lot of things, but what we should be evaluating people by are the actions that they take. And the actions, the force used by Mr. Ali was with the intent to murder his daughter. That action is taken, that intent can be formed at any point during the course of that. He does not simply walk over as his daughter is trying to run away from him and grab her by the wrist to take her home. That's not what he does. You see him in that video, and I'm not sure Mr. Kading played it multiple times, and we must be watching a very different video, because when he says, look, he's just grabbing her, right, around the neck. She's bent down, and he immediately goes around her neck and immediately grabs her and maintains that hold on her throughout. So that is absolutely what he's doing. He is strangling her from the get-go. Isaiah and Caleb, those kids are watching, and they immediately know what's going on. And they immediately know that this is wrong. You actually see at one point, Fatima, as they're starting to go back, her hands are here, and she's already at the neck. Her hands are already up, because that's where his arms are. The kids see that too. So no, they're not attacking. This is not some mob that is beating up where Mr. Ali somehow is the victim in this case. Mr. Ali instigated this. He initiated this whole series of events, and he strangled his child in front of a large group of other children who know exactly what they saw when they saw it. And as kids, knew that Fatima was in danger and had to intervene. That's what they were doing. They're not the initial aggressors.
And I will tell you, each one of those kids is a hero in my book. They stepped up and defended that little girl, younger woman. Sorry. They defended that young woman. And each one of those kids and the bus driver and the bystanders, the man and woman that drove up and stopped, saved her life.
Mr. Ali is. He's not defending himself against Isaiah. He immediately grabs, as all of those kids described, Fatima aggressively. And Isaiah knows, because he has the historical background on this family. He's not simply taking Fatima's words for what has been going on. And he told you that. I know what happens. I've seen my own information to corroborate what Fatima has told me. He's also had his own experience with mom to corroborate what Fatima has told him. He knows that the school has taken these efforts. If you're a kid and the school has taken these efforts, might that also indicate to you that those safety concerns have been corroborated?
Yeah.
So no, it's not just Fatima making statements and everybody just taking her word for it. Those statements have real value. And the people that are involved or subject to them, I submit to you, know when danger is most likely to them based on their relationships with the people that they are involved with. They don't call, the school doesn't call her parents, and the school doesn't call her parents because they have a safety concern. So in what world would you, as a official who has a history of interacting with a child, call the person to let them know that you found their child so that they can come home and take them when you have a safety concern? Ms. Robinson said it wasn't imminent, and then she described imminent means like he's not strangling her right in front of me. I don't need to call 911 at the moment because he's not right here, but we can make another set of arrangements for her. Absolutely appropriate.
Kudos to the school. They did a good job. Not all of them do that kind of a job.
They talked about, when Mr. Kading talked about, well, Isaiah hit him because he was mad. Isaiah said, I mean, I was mad, yeah, after I got punched, as I think is a reasonable, I submit to you, is a reasonable response. He doesn't say, I went and attacked him because I was mad. The question was, well, when Mr. Ali punched you, you were mad, weren't you? And he was like, yeah. That is an absolutely reasonable response for a kid to say, this adult punched me in the side of the head. He was trying to attack his daughter. I was trying to intervene to keep her safe, which Isaiah is also entitled to do. And the defendant punched me in the side of the head. So yeah, I was kind of mad about it. Fair. But then when he stumbles back, and you see how far in the video from the front of the bus, how far he stumbles as a result of that, he stands back up, he looks around, and Dad is already taking Fatima into a headlock and a chokehold. So when they go, they're not going over the push him down and start kicking him. They're trying to get Fatima out. And to be fair, they're kids. So if we're arguing that the execution of said non-existent plan by kids wasn't the greatest execution.
Get a load of this. This man who thinks women are below a mosquito has no respect for a female. He's got a female judge and two female assistant district attorneys. Insult to injury.
That's probably a fair statement, but it doesn't mean the intent is any different, right? It's very clear that they're all screaming, they're all kicking, and despite all of that, Dad doesn't release. Even when Mr. DeNicola is there yelling about it, even when Mr. Wagner shows up. That is not, those injuries to Fatima are not because they're just wrestling on the ground and he's trying to protect her. Nothing about what he is doing is trying to protect her. And you have that testimony. And you have the description of the injuries. That armbar hold that was described to you, that is very specific. That's not simply hands. It's not like, oh, we all got caught up and we were all tangled. It was this, and he was locked in. And Mr. DeNicola described it as his hands were tied together and he could not even pry his fingers apart. He was actively resisting having his fingers pried apart.
When you get one too many beads, you break them out.
Defense counsel argued that all of these kids had all watched the video. All these people had come in and they'd spent all this time testifying about the video. And so therefore, that's why all of their testimony was the same. Ladies and gentlemen, that is akin to interviewing people that have left the Grand Canyon and taking issue with the fact that they all called it real big. They all described what they saw. They described her going pale. They described her lips going blue. They described her, well, two of them saw her seizing, what Dr. Gilbert would describe as seizing. They don't know that that's what they're seeing, but that's what they've described. They've described her being unconscious. All of those things are described to you because that's what they observed and from their vantage points. And some of them didn't describe things that other people identified. And to that end, Mr. Denicola and Mr. Wagner and Mary Wagner also didn't describe all of the same things. But the things they did describe that were the same, that overlap, is because that's what happened. And that is consistent with the video. So statements to the contrary don't make any sense, right? We've described, you heard Fatima say she thinks as she's coming into this conversation, it's calm, but all of the other students are watching and they're like, it looked really angry and aggressive to me. So what does that tell you about the environment that Fatima is in? That what feels like a calm conversation to her with her dad is described otherwise by the objective observers watching, that is not calm. You have evidence of the intent for days. And Mr. Kading said, there's no evidence of any intent here. You do. And the actions are, in fact, the evidence of your intent. When you look at that assault one, for example, it says that whether the defendant acted with the intent. And if you walked up and somebody was strangling someone into unconsciousness in that same type of hold, and they said, don't worry, it's fine. I'm not trying to kill him. Don't worry, it's fine. I'm not trying to hurt him. They're fine. And you've watched their lips go blue and you've watched their eyes roll back.
It's okay. It's a strangulation challenge we had in the 1980s.
Back in their head.
Yeah, we did.
Watch them seize. Would those words mean anything to you? I'd submit that they would not. You would not believe that because of what you were observing with your eyes about the acts themselves. They speak louder than any words that Mr. Ali could have provided at the time.
The daughter is dead to them.
Don't get
she
caught,
is.
Please,
In their mind, she's dead.
Great bodily harm under assault in the first degree. The great bodily harm has to be inflicted. That is not the instruction to you. The instruction to you is that the force used must be likely to cause great bodily harm or death. That the force used, and you have an overwhelming amount of evidence of that specifically. Mr. Ali knows exactly who these individuals are. He's spoken with Mr. Barnes. They've spoken about Fatima and Isaiah specifically. He knows that his wife is subject to, I submit to you, a no contact order with Isaiah.
I'm going to sustain the objection.
He knows who these individuals are.
Objection, Your Honor.
Overruled.
He knows who these individuals are. He's spoken with Mr. Barnes. He knows that Fatima is in a relationship. In fact, he's told, and Mr. Barnes testified about that. Said, I'll do my best. We can try and keep these kids apart. That's what Mr. Barnes told you. But what are we gonna do? Like, they're in love, but I want to be respectful, and I want your wife to stay away from my son. That was his testimony on the stand. And then as they're standing there, Isaiah is rubbing her back and essentially saying, it's okay, right? And you heard Noah's testimony. Noah says, I said, inshallah, it's love. What are you going to do? They're in love. And that he did not like that. Mr. Ali did not like that. He knows.
No.
Exactly. There's no.
The moment that young man touched her back. Now, I'm sure he's touched it many times before, but not in front of Daddy. See, she was supposed to be on a plane that morning flying to Iraq because she had a one-way ticket because she was going to marry a 61-year-old man in Iraq in an arranged marriage. So when Daddy saw that young man put the hand on his daughter, that is when the honor unaliving clicked. Because at that instant, she was no longer pure. He was either going to have to unalive her or back out of the agreement. And that's a lot of money because they get paid for their daughters. Sometimes they get property, cars, cows, pigs, not pigs, but you know what I mean. Money, dowries they get paid. And so this wasn't just about the honor. She cost them probably half of their retirement. And depending on the person marrying, depending on his wealth level, depending on what they priced the daughter to be, it could be very expensive. So he not only, it wasn't only about unaliving because of honor. He also just lost a ton of money. See, that to me is when it comes into prostituting a child. You're selling them to somebody to become a wife, to be performed upon, and to pop children out and become a slave. That's trafficking.
Here that Mr. Ali is dense and he doesn't recognize contextual clues, especially when there's been a direct conversation about it. That information is all information that Mr. Ali has. So if anyone also
you disagree with me, fine, but that's my knowledge.
The point of Mr. Ali's ire, again, that would be Isaiah. So do you think that punch then is delivered with a bit more force because of who it is being delivered to versus push? Maybe the reasonable alternative is a push to that. But he doesn't do that. He punches him in the head. And again, why? Because he's mad.
He's lucky he didn't try to unalive the boy.
Doubt is not a doubt. It's
First.
Not a single doubt. That's not the standard. That is a misstatement, in fact, of that law. Go back to your instructions. The standard is whether it is a reasonable doubt, not any possibility, not any doubt. And in fact, if you have an abiding belief in the truth of the charges, then you don't have a reasonable doubt.
That's premeditated, Ronnie.
You didn't know anything about the facts whatsoever. You knew nothing. So if you're coming to that place now where you're like, I believe that I have an abiding belief in the truth of the charges, that the state has proven that to me beyond a reasonable doubt, and I submit to you, I have met my burden. Certainly do not lower the burden of the state, but also don't make it greater than what it actually is. And that's
a good comment.
Before you, not any doubt, not a single doubt, but a reasonable doubt.
That's a good comment. Good.
Council use the.
I need to make a comment because I'm on several social medias, and somebody was asking, why in the world am I sewing? Well, I am beating a hat, but why am I doing it? I'll be honest. I'm a survivor of ex-trafficking in my 20s.
The example of.
I spent stuck in it, held prison in it for over a year and a half. I survived. That said, sometimes I have to, in order for me to continue doing this, I kind of have to do something, just kind of separate myself a little bit. It's called self-care. So if anything gets a little too much on my channel, we encourage self-care. We encourage you to step away, take care of yourself, but it's kind of hard for me to do that because I'm running alive. So that is why I do the beating sometimes just because I have an order and I got to get it done. But sometimes you'll see me kind of breaking in and out like this, so I don't become triggered. And it's all about, and I'm very cautious about that with you guys. So you guys, please, if anything ever gets too much, it's okay to step away and come back. We support you. Really?
Basketball.
Oh, sorry.
So he must have intended it, that you can only intend a strangulation.
Inch an hour.
Hands. Anything else, bless you. Anything else is not evidence of intention. I submit to you, it is a strange or maybe even an absurd scenario where somebody whoops-a-daisies their way into an armbar hold, a rear naked choke. That's not an accidental event. That is a exceptionally intentional event.
But I am listening very intently.
You can be let me back up. Defense counsel said, you know, these are parents that they're at the end with Fatima. They are struggled. They've had a hard time. As I said during my first closing, everyone can relate to that, right? Parenting is hard, and that people derive sympathy from that, and we certainly individuals can understand that. But it does not matter for the purpose of this trial as it relates to the actions that those defendants took. You can be the worst kid in the absolute world, and it still wouldn't justify what these two parents did to Fatima on that day. You do not get to strangle your child. You just don't. So that is, parental discipline does not allow for that. Parents have a lot of leeway. And that's, I would argue that's probably true across the country, but in the state of Washington, parents have a lot of leeway in how they restrain and discipline their child. But those rights are not unabridged. You don't get to do whatever you want and then couch it under the guise of parental discipline. And here, Mr. and Mrs. Ali grossly
Oh, human being 34/7. Leaving DNA means put your finger on the button, click the like button. Leave your DNA. Click the like. Because you have to touch the button and you leave DNA on the button.
exceeded what that looks like. Fatima was strangled for approximately 45 seconds. And if you think about how long
you can die
45
within a minute
is for somebody who hasn't taken a breath, they weren't anticipating holding their breath. They weren't anticipating being strangled. And it's not just holding their breath, but there's additional pressure and panic occurring at the time. 45 seconds is a really long time. So let's count it out.
Oh, thank you, Penny. This is 45 seconds they are taking. Good idea. I love it. That's brilliant. This is 45 seconds.
That's 45 seconds. That's how long her dad was strangling her. It's a really long time, you guys. School is supposed to be a safe place for kids. It's a safe place for Fatima. She told you that when she testified. She's known adults and other students there for 2 years. She's formed relationships with those adults. The school told you they had concerns about Fatima being online and not having access to other adults. These are the same adults Tracy Arnold testified that told you they would feed her, they would give her snacks. When Fatima shows up at school that morning, she leaves the house at 4 or 5 a.m. and she just essentially waits, does circles until school opens up. She testified about that. And as soon as school opens up, she goes in. That's where she goes. She doesn't go somewhere else. She doesn't get on a bus to Disneyland. She doesn't do something else. She goes to the school. And defense counsel says she ran straight to Isaiah. She ran straight to Mr. Thomas. That was her first period teacher, also Isaiah. That's where her safe people were in that class. She goes to her first period class, to her safe people, her safe adults. And she talks to Mr. Thomas first. Remember, Mr. Thomas calls Isaiah out of class. Mr. Thomas goes and gets her snacks, brings them out to her, and then sends her to go see the counselors. And that's where she spends the rest of that day. She knows these adults. She trusts these adults, and her parents know that about her. We tell our kids to tell someone when they don't feel safe. You tell them to find a safe adult. Tell your teacher, tell your counselor, tell someone outside of your home. And that is exactly what Fatima did on October 18th of 2024. She has been characterized throughout this trial as just an angsty, bratty teenager who just didn't want to go on a family trip that could not be farther from the truth. She did not just want to hang out with her boyfriend. She showed up, she flees her house, she hides, she goes directly to the school. She tells the school that she needs help. What evidence is there that the things she testified about on that day were a lie? What about that video that you watched, we've now all watched repeatedly, was a lie? Was there anything about that video that she said didn't happen that was a lie that you saw? I submit to you that there was not. Fatima said she was not safe. That's what she said. I didn't feel safe. I don't feel safe. I told the school I didn't feel safe. Isaiah knew I didn't feel safe. 6.5 hours later, her parents showed up and proved she was correct. So where is the lie in that? She was most certainly not safe. I'd ask you to return verdicts of guilty. Thank you.
Thank you. Members of the jury, in just a moment, the bailiffs are going to come forward and lead you back to.
I want to share. Let's take a breath, everybody. We're going to take a quick breath before we get into more of this stuff, but I want to show you. This is what I just finished making. Okay, so just want you to know this is what I just finished making about 2 weeks ago, a week ago, actually. That is one of my hats. And I think I got to go this way. That is some of the beadwork. And that's the beautiful lady wearing my hat. Isn't that gorgeous? She's one of my best friends. But that is a lot of work. A lot of work. It's an inch an hour. Pretty much how I have to charge it. And I'm so glad I got to give that to her. It's more of a pink color, but it doesn't show up that way here. All right, just wanted to let y'all see what one kind of looks like.
To the jury room. When you return to the jury room, the 2 alternate jurors who are remaining will take their belongings and they will be leaving. But I will tell both of the alternate jurors I have not and do not release you from the instructions that I have given you. You are still prohibited from discussing this case from anyone seeking out information, be exposed to information, and the like. Once the trial is concluded, the bailiff will reach out to you and let you know that the case is concluded. And at that time, you will be released from my instructions. If something happens during the jury deliberation process and one of the 12 is unable to continue, number 2 would be called back, join the group, and deliberations start all over again. And same would be if we had 2 people, then alternate number 3 could still be called back. And that's why you are not released from your instructions in any way. And I want to truly, if I don't see you again, thank you so much for your service. For the 12 of you who are going to be going back to the jury room, it is 4:10. What you need to do today is you need to select your presiding juror. And then you need to decide what time you're coming back tomorrow morning, either at 8:30 or 9 o'clock, to begin your deliberations. I'd be sending you home at 4:30, so I don't want you to start your deliberations. Select your presiding juror and select the time that you are coming back tomorrow. All of your instructions remain. You are not to seek out information. You are not to talk about this case with anyone. The only time you can deliberate is when all 12 of you are in the room together for deliberations. So you can't call each other in the middle of the night because it's deliberation time. It's very, very important. So please continue, of course, to follow my instructions. Thank you very much for your time and attention this morning. The bailiffs will lead you back.
It's going to be one of 2 ways. I believe, Renee, I believe it's going to be super quick or it's going to be long and hung. On him, I think it's going to be quicker than it would be on mom. I think mom is going to be if they're going to hang, it's going to be on mama. I would be shocked if they hung on dad, but on mama, if they hang, it's going to be on mom.
Please be seated. If you have not done so already, if you will provide your contact information to the clerk, please, in case we have a question or ultimately if we have a verdict. Mr. Kading and Mr. Larry, I ask that you stay within about 10 or 15 minutes from the courthouse so that you can return
I know, right?
as soon as possible if we have a question. I will say that we should not have a lot of questions because I think the lawyers did a nice job during closing of telling the jurors a lot of what our common questions are. But we could have questions, so I would like people to be readily available. The jury is going to select their presiding juror and then select when they are going to return tomorrow. And as I told them, they can determine that they will start at 8:30 or 9 o'clock tomorrow. And then we will wait to hear from them. Ms. Stone, do you have any questions?
I do not, Your Honor. Thank you.
Mr. Kading?
No, thank you.
Mr. Larry? All right, so we will be in recess until such time as either we have a question from the jury or if they indicate that they have reached a verdict. Thank you.
All rise, court's in recess.
All righty. We made it. So let's see if the court TV will continue the feed or if we're just going to be back in tomorrow. All right. I am kind of liking that. I'm making this for a specific reason, the hat.
Call!
Call the cops!
Call the cops!
He needs to get off of us!
That's a dude!
Let me see. I'm looking for those who've not seen. Give me a second. I'm trying to pull up something. And a bunch of advertisements keep popping up. And it's like, really? Enough with the advertisements, right? It's all too obvious. Did you close the poll? No, I'm closing it now. I was trying to get to it, but I had all this stuff popping up. So the poll that we had before, whose closing did you like the best? Everybody's 89. Stay open. Thank you. 89% said that you like the state. So here's the next, and I know what the answer is going to be, but don't say it yet. Let me get the poll posted. Now, the way I'm putting this up, because I only have so many options I can have. Only have so many options. Okay, I got a poll up. I don't know what this is. So I guess we are not going to have anything after this. Okay. I got the new poll up. Thank you, June. You were reading my mind. I'm going to give you a minute to get that going. I'm going to go back and so yes, they have ended the live. So Court TV, we do not have a live anymore. They're not going to be back today. So I'm going to go ahead and set our live for 9:00. For the 9:00 showing, but it's possible that they will start earlier and I will adjust that time accordingly. By the way, guys, we hit 1,000 plus views today on this video already. Both guilty. So mom only guilty. So are we at 100%? Karen T, did you put mom guilty? Because I'll change it, but it just means 100% both guilty. I have never. Thank you so much, human being 34/7. I appreciate that. I don't really talk a lot about it, but when it's appropriate, I bring it up. But I will say I'm in the 0.001% of survivors. Let's see. "28 years ago. Most people who survive, very few live past 3 to 5 years. So we have 100%. I'll end the poll. I know. So with that, we're going to do the drawings for the end of the month giveaway. One sunny day. I love to sing it. Okay, let me get those up and we'll do the drawings for the giveaway. So right now, if you've not liked the video and commented, let me get it up. Okay, if you've given us a thumbs up and you did not comment like that, I keep getting backwards, like that, I liked, all caps. It's the only time caps are acceptable. Please do so now. If you have subscribed for the first time, put I subbed, all caps. If you have shared, put I shared in all caps. Why? Because in a few minutes, I'm going to do giveaway drawings. At the end of the month, all those names I draw throughout the month will be entered into a drawing for a giveaway. I have merch and things like that. So this month's giveaway is you can pick one item from the merch shop on me. Yep. Yes, set the notifications. Woohoo! All right. Hello, Gabby. Hey, beloved. We have had over 1,000 views on this video today. And y'all commenting, y'all who've been commenting all day have been the bomb, man. Yeah, that's true. In art, when I was growing up, yep, we got everything. The shoe, the fly swatter, the switch, the belt, the hose, you name it. It was swinging at us. I knew somebody who told me when he was 10 years old, starting at the age of 10, his father took him way down into Mexico on a little beach and left him with the food and their tents and fishing poles and bait and said, "See you in a week." Of course, there were older kids with him, but he was the youngest. I'm like, I'd never do that. It's a whole new world, a whole new feeling. Okay, so I'm just waiting to give everybody an opportunity. Okay, guys, we're going to start here for the drawing. Long time. And if we get a repeat, I always draw again. Let's draw again. All right, everybody. We got it done. Got it done. We are now in the end of the Ali trial. We will be in verdict watch tomorrow. So let me explain to you guys, all of y'all who are new and watching. I'm going to kind of give you a rundown of what my mods and I have worked very hard to set up for the next week or two. It is a very odd time for us because some of the trials are missing and hitting. So today is the 28th. We have, we're in Ali, and we're hoping we'll have a verdict tomorrow. So what I'm going to do is I'm going to, during verdict watch, we're going to do a Dan Markel breakdown. I said it right. Tomorrow. And we're going to be talking about the Adelson case a little bit. And then we'll just do some case floating if we need to. Then we have a verdict, then Wednesday and Thursday we're off. Unless I find something that we can do. Thursday, we're off for sure because I've got to get the studio reset to have Joe Schmo in the house. He's physically going to be here. Then on Friday, we got Joe Schmo, and we're going to be, but when he's going to be here, so we'll do that. Then Sunday the 3rd, we have our members only live. So if you want to be a part of that, my memberships start at 99 cents and go to $9.99. So they're very reasonable. Then we will be doing on Monday, Wendy Adelson deep dive, and I will also be doing the 1 month anniversary of the 4th of July flood and giving you a true update as to where we are in this community. Then on the Tuesday of next week will be Charles Adelson. Then on the 6th and 7th, it will be a breakdown onto Donna Adelson. I don't know why I did Adelson. Then on Friday at 9 a.m., we have Donna Adelson pretrial. And then that's next week. Donna Adelson's jury selection starts on the 18th. It should go between the 20th and 21st. The judge has pretty much put his foot down. He wants to be in opening no later than the 22nd. And then we're into Adelson. Yeah, y'all. We have got it all figured out. Well, thank you so much. I know. I can't wait. And we're going to be talking everything we can about Lori Daybell. We're going to do a deep dive into Daybell. Also, he and I are going to do a deep dive into the Brad Simpson case that's based out of Texas, San Antonio. That's going to be coming up, and I hope to go sit in trial for opening statements and have a live stream as well. If they live stream it, I'm going to set it up and I'm going to be running it. Yeah, so I need somebody who's techie to be a mod for me who can learn StreamYard. It's so easy. So if you're techie and you want to try and help me out so I can have you in the background, that would be great. Yep. Joe Schmo. Maud, can you put his link up? He was raised in the Mormon faith. He's no longer a part of the same faith as Lori Daybell. I got Adelson on the brain. He is really good friends with Megan Connor. I'm going to see if I can get her to call in. She is the cousin, and she lives in San Antonio. She is Lori Daybell's cousin. And those two were, both of them, and of course other people, flew into Arizona. He drove into Arizona and were there for the sentencing. And they've also been there for the trial. So I'm going to have people that are very, very close to that case. So, and Gabby, I need somebody who can, while I'm sitting when I have to be remote, who can, if need be, if I'm sitting here, my power goes off, everything drops. I need a person who can get into StreamYard, have access, and pop up the live from their YouTube. So they would host the YouTube stream, whatever court that's running. And they would also have the ability to pop up comments, change the screens, and do this kind of thing, like what I just did here. Just somebody who can run StreamYard in case I go down. If I go down, they can hop in and keep it going until I'm back in. And then also, if I go to a hearing like the Simpson trial, and I'm sitting there, if it's a live feed for there, they can host the live feed while I'm sitting in trial. You could probably see me sitting there. So it's not an easy program. I mean, not a hard program to learn. It's super easy. If I can do it, you can do it. Oh, cool, Gabby. Well, I don't want to put anything else on your plate. It's not something that would be done every day. It's just something that if I crash for whatever reason, I didn't pay the electric bill on time. No, kidding. But one of the frustrations I'm having right now is that we have a lot of disaster stuff in Kerrville that's still going on. There are a lot of techie, a lot of infrastructure stuff going on. Sometimes the power may go down because they're working on a line that was compromised with some from the flood. So anyway, it's one of those things that if I go down, I need somebody who can pop it back up for me. Joe Schmo will be here August 1st. He'll arrive in Kerrville on the 31st. I'm going to drive him the length of the flood because I can get in and let him look around. But that said, he's going to be here. We're going to go live August 1st. He's going to spend the night. Well, Thursday, I think we're going to be fine. I'm looking more for the future, but if you still want to do that, but Joe Schmo's going to be here. I'm going to be here, so running is not going to be a problem. But it's more when I have to go remote. That is a big problem. Or if for some reason we have a bad storm and everything goes down, I need someone to be able to go up and get it up and running until I can. So anyway, everybody, yeah, it's Friday. Everybody, thank you so much for your comments, your love, your support. Being here, but I have to give a huge shout out to my fabulous three mods, Miss Gabby, thank you so much. Gabby, you're rock star as well. Haley's done the StreamYard, but she's been out because of her husband's surgery. So if Haley Mouse was here, we could do that with her, but I'm needing extra mods. I need mods who will be willing to just help monitor the comments. You don't have to do a lot. It gives June and Gabby, June and Ronnie, and sometimes Gabby a break. They're here every day, and if they need to go do something with their family or want to go have a day off or go partay, I would have other mods in the chat. So I need a couple more just regular chat moms as well. Oh, I'm sorry to hear that, but I understand. Well, everybody have a nice rest of your day. I'm going to go, and what y'all don't know is as soon as I get done here, I go and work with flood victims or help other people out. I am still very knee deep in the flood recovery. And so anyway, you're partying right now. Woohoo! Y'all. Oh, I'll tell y'all later. That's a mod. I will tell you guys in my members only live. I'll tell you, I got some personal things to share with y'all. No, I don't have a boyfriend yet. But anyway, this was an amazing day. And I want to thank you guys for being so awesome. And we will see all of y'all again bright and early tomorrow morning. Well, some of you bright and early. It'll be either 10:30 or 11 my time. And that's Central Time. That's 8:39 8:39 Mountain Time. All right, guys. With that, be blessed. Have a great night. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.